Today's date, August 31st, 2020, Court AM bench, Zoom meeting, State v. SignAd.
Hey, good morning, Dan Lee Collins. How are you? Great, great. Is Clavy around? Oh, okay. All right, having the peps. Yeah. I was just gonna tell her, if do you happen to have, and again, don't want to interfere with Mechanitek's business, obviously, but do you happen to have YouTube maybe downloaded on your phone? Or David, go to YouTube real quick, have something. Okay, go to search. Okay, then put in the number 200831, no spaces. Then a space. Then spell out cause, C-A-U-S-E, space, N-O for number. Then 18, letter C, letter V, hyphen 5774. Well, see what happens if you hit search. It just hits search based on that. Yeah. Do you see me? I'm talking to you on the phone. Yeah. yeah, I didn't want to tell you that, but sorry. Yeah. That's how we're doing some. You can tell Clay she can look in. I told her this, we got a big deal going on with a lot of folks. So this, when you have a lot of folks, this is what we got to do now. So. Well, I'm waving at you right now. Yeah. so you can put on there, like, so I'll know so many people are. Okay. All right. Bye-bye.
There's 4 people already waiting, huh?
I see.
Holy shit.
I'm not going to get them till about 5 more minutes.
Yeah. We're about to hit the big time.
Yeah. Sit. I'm just gonna shut this door.
I'm gonna lock it just to make sure that.
Don't lock it. Yeah. The whole reason you have this,
Oh,
all this is it's supposed to be the open court. You know, so I don't think it's good to have open court when you lock the door. Okay, guess I just go to C waiting room. There we go. All right, who do we got? Okay, let me see. So I can see Mario, but you need to be unmuted, and I can see Mr. White, but you need to unmute. All right.
Morning, you're on.
Good morning. Good morning. Okay. So I see Miss Knox, Rothfelders, Mr. White, and Mario.
Mr. Lewis, Mr. Lewis will be joining us shortly. There was a car wreck in town. So I'm standing here until he gets in. But
Okay.
maybe
And so is Miss Fagerberg going to be here?
She is. I'm not sure where she is yet. She should be joining us if she's not trying already. So,
Okay. Well, we'll just, it's not 9 o'clock yet, so I just want to make sure we have everybody here.
okay.
That's Richard. Who's the other guy? Is it Chris Walker or
Mhm.
It is.
While we're waiting for Miss Fagerberg, just so I'll know all the players, the person who's listed as Mario, let me get your name.
Good morning. Judge, my name is Mario Caro, C-A-R-O.
Okay.
And I am the real estate appraiser.
And Mr. White, who are you with?
BNSF.
All right, so I see Miss Fagerberg and she's unmuted.
Steve Henderson's not.
Right. Right. And I'm not seeing Mr. Henderson yet. And who is Mr. Henderson with, so I can make a note?
I apologize, Your Honor. My camera on my laptop is not actually functioning, so I don't have the ability to share video.
Okay. And who are you associated with, Mr. Henderson?
I'm Nicole Fagerberg's paralegal.
Okay. All right, so do we know, is anybody else joining us?
Mr. Lewis is trying to get his computer to work, Your Honor, but I'm here and we can certainly operate. I think we're supposed to be dismissed out of the suit anyway, once our attorney fees are granted.
Right, and I know Mr. Lewis had filed a motion to dismiss last week, and I believe it's been signed, so.
I believe they also signed a stipulation as to attorney fees yesterday, Your Honor.
It's on top of that. All right, so before we get started, just to let everybody know, on Friday, had an agreed order for dismissal signed by Mr. White and Ms. Fagerberg, and I signed that last week. I signed it on Friday, so if anybody.
Thank you, Ron. So may I be excused then?
I think your client is out.
Thank you, Ron. Y'all have a good day.
Thank you.
Judge Lady,
Yes,
if I could, Richard Rothfelder for SignAd. You remember my partner and son, Chris Rothfelder, is my
Yes.
co-counsel today.
yes.
And you asked earlier for who else is on the video call. My client, Wes Gilbreth, is in the room with me. We're in my conference room in my law office, and he'll be appearing on screen when he gives his testimony later.
Now we see 6 people, so are we waiting for anybody else? I have Mr. Caro, Ms. Knox, Mr. Rothfelder, and that's both Richard and Chris Rothfelder, right?
That's correct.
Yes, sir.
Okay. And Ms. Fagerberg, Mr. Henderson, I'm sorry, and Mr. Gilbert will be available. Anybody else we're waiting for?
I don't think so, Your Honor.
I mean, yeah, Mr. Lewis he was in the waiting room, but I don't know if he left since he's with the railroad. All right, so if we're ready, we'll go ahead and get started. All right, so this is cause number 18CV-5774, State of Texas versus SignAd, FKA SignAd Inc. et al. We have everyone announce who's here.
Announcing, Your Honor, for SignAd Limited, Richard Rothfelder and my co-counsel, Chris Rothfelder, we're the movants on today's motion for damages and the defendant in this eminent domain case.
And Judge, I'm Nicole Fagerberg. Obviously, I'm the Assistant Attorney General, and I have 2 witnesses on the call who, the original appraiser on the file, which was Mario Caro. So I'll let Mario introduce himself, and then Wendy Knox is a representative of a TxDOT permitting division.
All right, so and then I understand there's another witness for SignAd, Wes Gilbert, who's available, but he's not on the Zoom right now. So let me get the witnesses who are on the Zoom to raise their right hands. And you and each of you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do.
I do.
All right, and does anybody want the rule invoked? No, Ms. Fagerberg says no. And
No.
Mr. Rothfelder? No, okay. So the rule will not be invoked. Before we get started, just let me put on the record that we are having a Zoom hearing, and if anybody else there wants to follow it, it's being streamed on YouTube. And if you go to YouTube and search 200831, that's just the date for today, 200831, then cause number 18CV-5774, State of Texas v. SignAd. You should be able to find us. Right, so I've read through the pleadings and read the briefs. Before we get started with any opening statements or testimony, I do want to just go through some procedural things and make sure we're all on the same page. From looking at the briefs and the pleadings, I think everybody agrees that we're proceeding under 21.0195 of the property code. So is that right?
It's
Yes.
21.095C of the property code, Your Honor.
Okay. And then when I'm reading that section, and I think C is what we'll be spending most of the day on, but as I read paragraph B, it says first, the court may grant the motion only if the court determines that the property owner's interest will not be materially affected by the dismissal. So is there any dispute over that, so that I make that finding just based on the pleadings?
Judge, there's been no allegations of that. I think that's normally in a situation where maybe the state has taken possession of the item, but to my knowledge, that's not in play here. We've never taken possession of the item. If you remember, we had an injunction hearing that prevented the state from moving forward with any type of acquisition of the sign structure.
The short answer is no, Your Honor. You can proceed in light of subsection B.
All right, so again, it sounds like everybody agrees that either B is fulfilled or doesn't apply, so then we can move, because just by reading this, it looks like obviously B comes first and then C starts with if the court does something else. So if everyone agrees we can just go right to C, we'll go to C. Now, Ms. Fagerberg had filed, she had non-suited the case and then had filed a dismissal. So I want to address that first. She filed this back on December 20th, 2019, an order granting the state of Texas motion for immediate non-suit. So is there any objection to procedurally me just signing that now?
No, Your Honor.
Ms. Fagerberg?
No.
All right, then I have signed that order granting the state of Texas motion for immediate non-suit of the case with prejudice. And something else that was addressed in the briefs and the pleadings, and I just want to make sure there's no dispute about this, that the $118,000 that was awarded by the special commissioners has not been deposited with the clerk's office. So is that agreed, Ms. Fagerberg?
That's correct, Your Honor.
All right, and in this 21.0195C, it breaks down what the court would make an allowance for into different categories. And so just so everybody will be clear when we're talking about it, it talks about damages, expenses, and attorney's fees. So I'll just start with Mr. Rothfelder. What's the legal distinction between those three? I know what attorney's fees are, but I guess what's the difference between damages and expenses?
Yeah, Judge, if I could refer the court to our summary of damages, expenses, and fees that are before you as Exhibit 26, and I'll share the screen on that as we visit.
Okay, and I guess right now, yeah, I'm not talking about the specific numbers, just kind of what things fall under the category of damages as distinguished from expenses.
Damages are those that were incurred to move the sign out of the right-of-way and eliminate the necessity of the eminent domain case. Those invoices are attached as Exhibit 29 from Houston Sign and Service and totaled $24,600. In addition, there was labor and materials provided by in-house crews at SignAd in the amount of another $21,500. So the combination of that $46,000 were the damages incurred due to eliminating the encroachment and causing the elimination of the condemnation case. The expenses that were incurred were for the surveying to confirm that the sign was out of the right-of-way, all of which was provided to the state, indicating there was no longer any aerial encroachment, along with the expenses, the permit fees paid to the city of Sealy to make sure that the work was done in accordance with those safety and engineering requirements imposed by the city of Sealy. The surveying fees are going to be in evidence as exhibit number 28. The permit fees from the city of Sealy as exhibit 30. And then finally, the attorney's fees, yes, Your Honor, those redacted attorney's fees invoices are exhibit 27.
And then also, just to be clear, the SignAd, you're not asking for the $118,000 compensation that was awarded by the special commissioners?
That's correct, Your Honor.
And Judge, may I respond to that? How do you want to handle objections, by the way?
You just have to, make your objections. Since we're on Zoom, there's, we're handicapped by that a little bit. So just, if somebody hears an objection, just ask the other speaker to stop so we can hear the objection and rule on it.
Well, Judge, the state objects to, well, I mean, as you know from our briefing, we object to everything he described. So we probably need to go over the request for the pre-admission of exhibits and discuss that. But generally, I would say that for now, you're just asking him a question before the court and he's summarizing what he intends to present to you. I will tell you that the state does not believe.
I'll object, Your Honor. I was simply asking your question. Believe me, I will have a much more extensive summary description justification of each of those damages, expenses, and fees when I'm given the opportunity. You asked me what they were, and I answered your question, Your Honor.
And yeah, I'm not even looking for opening statements yet. I'm just going over some things after reading through the briefs and the pleadings just to make sure we're all on the same page. So if somebody says damages when they mean expenses or expenses when they mean damages, I'll kind of know what people are talking about.
Okay, and I guess my point would be the way it's been phrased to me throughout their discovery is almost that the damages for what they're calling a cost to cure, which I don't think that's the appropriate terminology, but I think maybe they phrased it as like the preemptive removal or something of the improvement. We don't believe that that's a possible damage under 21.095. So I was under the understanding that was almost sort of like an alternate theory of compensation. So I guess if they're characterizing now that as a damage under 21.095, that's good for me to know because I had thought it was sort of an alternate compensation theory.
Okay. All right. Well, and that's kind of what I want to do right now is just make sure we're all on the same page on things. All right. And I just want to go through some dates and make sure everybody agrees on these dates. September 8th, 2017 was the offer letter from TxDOT. State did their survey. It's at least the survey is dated May 10th, 2017. SignAd altered the sign around August of 2018. In SignAd's brief, it says that SignAd emailed the state on September 11, 2018, saying the sign was outside the easement, and I realize TxDOT disputes that.
Actually, Judge, if I may correct you, we do stipulate that in September, we received an email from Mr. Rothfelder. We do have a dispute over an October email and whether that was received.
All right, so then and I have that email as September 11, 2018. The state then filed their original petition October 8, 2018, an amended petition on December 12, 2018. The special commissioner's hearing was December 20th. And they awarded $118,000. And on the date of the special commissioner's hearing, December 20th, 2018, the sign was not in the right of way at that time, and that award was not deposited with the court. SignAd, objected to the award on January 2nd, 2019. The state filed a non-suit on December 20th, 2019. Does anybody have any dispute of those facts in that timeline?
No.
No dispute, Your Honor.
And then Mr. Rothfelder, is SignAd asking for anything other than damages, expenses, and attorney's fees under this 21.0195 of the property code?
No, Your Honor.
And it'll come up in the evidence. So again, I'm not asking for, for evidence yet, or even opening statements yet, but in the exhibits that were filed, I noticed, Mr. Rothfelder, you started the attorney's fees in 2018. So you're not asking for any damages, expenses, or fees in 2017, is that correct?
Only those that are summarized in exhibit number 27. And you're right, Judge, they commenced in 2018.
And again, you could cover this in opening if you want. Just as we're going through this, I'm going to have a little discussion or little questions about, since things happened in 2017, but SignAd is not asking for any type of compensation for any of that. Is that right?
That's correct, Your Honor. I will say, in addition to the pleadings, which ask for attorney's fees and itemize those by the evidence, including the summary of the attorney's fee invoices, I'm going to testify live about those that are incurred during the month of August, and then conditional potential appellate attorney's fees.
All right. And Ms. Fagerberg, I see that you stipulated that Mr. Rothfelder's rate of $500 an hour and Chris Rothfelder's rate of $350 an hour is reasonable. So is that right?
I have, Your Honor.
Take note of that. And so looking at the different factors as far as attorney's fees, are there any other of either the 8 factors in Arthur Anderson or the 12 in Johnson that are stipulated to, or Ms. Fagerberg, are you going to require testimonies to the others? I see that Ms. Fagerberg specifically said she's objecting to, again, in the Arthur Anderson case, the factor 1 and factor 4, time and labor, and the amount involved. And then in the Johnson factors, 1 and 8, which are the same one, time and labor and the amount involved. And so she stipulated to the amount of fees. Any others that you're going to stipulate to, or do we need to, we can run through them real quick here. See, under the Arthur Anderson case, it's that the work would preclude work for another case. Are we going to need testimony about that, or is that agreed to?
Your Honor, I don't have an objection that doing work on this case obviously would preclude work on another case.
And in the Arthur Anderson case, the 5th factor is the time limitations that were required. So are we going to need testimony to fulfill that factor?
I'm sorry, can you read the time limitation?
In
I have to-
the Arthur Anderson case, factor number 5 is just the time limitations that were required of the case. And in the Johnson factor, it's number 7. And so, I mean, if you want Mr. Rothfelder to give some testimony, then he sure can. If we can stipulate to things, we can cut down on time, hopefully.
I'm not sure I can stipulate that there was any particular expedited time on this.
Okay, that's fine. All right, so the next in Arthur Anderson, factor 6 is the professional relationship between, I guess, the attorney and the client. So do we need testimony about that?
Your Honor, I think I stated in my briefing, I'm comfortable with the fact that Mr. Rothfelder, I think predominantly or almost entirely represents billboard companies, and I'm sure he's had a very long relationship with SignAd.
All right, and then I think you also stipulated to, again, in Arthur Anderson, the factor 7 about experience and reputation. So is that right?
Yes, hence my willingness for the hourly rate.
And is there any, do you want any testimony as to whether or not this is a fixed or contingent fee?
I think it's obvious from the billing submitted that it's a hourly fee case.
All right, and now looking at some of the others, the extra ones I threw in on the Johnson case, one, there's about the novelty of the case that's involved. So are you going to want testimony about the novelty of this case?
Yes, I don't stipulate that it's terribly novel.
Okay. And in Johnson factors, there's a requirement of showing a customary fee. So you're agreeing to that one, I believe. That his rate is
Correct. I mean, some of these seem like they're sort of overlapping, but yes, I mean, if I've stipulated to the billing rate, I think that's
right. All right. In the Johnson case, one of the factors is the undesirability of the case. So do we need to hear something how undesirable this case was?
probably yes, Your Honor. I think this is actually Mr. Rothfelder likes and enjoys these cases, and they're sort of his bread and butter. I don't think there's anything terribly undesirable about this case.
All right. And in Johnson, the 12th factor is labeled as awards in similar cases. So do you want to hear something about that?
Judge, I think, as I've pointed out in my briefing, I think the overall situation we have is that the value of the sign structure is already eclipsed by the amount of the fees. And I believe more than half the fees have been incurred since I filed the non-suit. So yes, I think the amount here is atypical relative to, the amount of billing is atypical relative to the award and to, I guess, the results achieved, given that the sign was already out of the right of way back in August.
All right. So then And so, Mr. Fagerberg, I want to make sure that you'll agree to the stipulations. Is that my understanding is to determine the reasonableness of any fees, that the state is stipulating that any proof that would be provided under the Arthur Anderson case. Number 2, that this precluded other work. Number 3, that this is your customary fee. Number 6, your professional relationship with SignAd. Number 7, your experience and reputation. And number 8, either it's a fixed or contingent fee that the state is stipulating and will not require any additional testimony or evidence to prove those up. So do you agree to that stipulation?
I do, Your Honor.
Okay, and Mr. Rothfelder?
Yes, I do. I just wanted to make a note here. The Arthur Anderson is also Rule 1.04B of the Texas Disciplinary Rules of Professional Conduct, as we know. So we've got a stipulation on those rules of the Texas Disciplinary Rules of Conduct on 2, 3, 6, 7, and 8. Is that what you calculated, Your Honor?
That's what I calculated. So Ms.
Okay.
Fagerberg, is that correct?
I don't have that in front of me, but verbally I stand by what I've already stated in the last 5 to 10 minutes.
All right. Well, then I'll approve that stipulation as it applies to the factors under Arthur Anderson case. Then under the Johnson factors, as I understand them, there's a stipulation to factor number 3, the skill involved. Number 4, that precluded other work. Number 5, this is a customary fee. Number 6, the fixed or contingent rate. Number 9, the experience and reputation of the attorneys. And 11, the professional relationship between the attorneys and the client. So Ms. Fagerberg, do you again stipulate that there'll be enough evidence to prove up those factors without additional testimony and evidence?
Yes, Your Honor.
And Mr. Rothfelder, do you agree to that stipulation?
So stipulated.
And I will approve that stipulation, so we will not need any additional testimony about those. All right, so I have a few questions that came up during review of the briefs. So if you want to pull those out while we go through them. And I know SignAd had filed 2 different briefs. So the one I'll be referring to is the first brief that was filed on August 26th.
We've only filed 1 brief, Judge. What's the second brief you show?
Okay. Second brief I show, it was filed with a big notebook.
Oh, I mean, we sent you hard copies of the brief and the exhibits just for your convenience. That's duplicative of what was filed electronically.
All right.
So you'd have a bench copy.
Okay. Just
That's the same brief.
Well, it's not exact. I'm sure there's a lot of cutting and pasting involved, but I don't think it's exactly the same. But so,
Really? Okay.
For the purposes right now, I'll just refer to the brief that SignAd is titled Defendant SignAd Limited's Brief in Support of Request for Recovery of Damages, Expenses, and Attorney.
Yes, Your Honor.
All right. All right, so on page 25 of that brief, near the top, there's a statement that it says at the special commissioner's hearing, in which SignAd presented the special commissioners with a copy of SignAd's survey showing the sign out of the state's right-of-way. Despite knowing the sign was outside of its anticipated right-of-way, the state insisted on moving forward with the condemnation proceedings. I'll back up a minute. You know, in an earlier hearing, the minutes or the transcript of the special commissioner's hearing was, I believe it was offered, it was sure referred to. Is that going to be offered as an exhibit today?
The special commissioner's hearing transcript?
Correct.
No. I think maybe the state intends to offer it, but SignAd doesn't intend to offer it.
All right, good. So Mr. Rothfeld, do you have any objection to the transcript of the special commissioner's hearing?
No.
So Ms. Fagerberg, were you going to offer that?
Yes, Judge. We actually both have exchanged our pre-admission request lists with one another and endeavored to try to come to agreements on most of them. We haven't been entirely successful, but we've certainly made progress for you. And I will tell you that it's my understanding that they have agreed to the special commissioner's hearing transcript as one of the agreed items on the state's exhibit list. And specifically, that exhibit is
$34.
34. Thank you.
I have a lot of paper in front of me, so I want to find that as we're referring to that statement in SignAd's brief about presenting the copy of the survey. So let me find that real quick.
Goes on page 20.
Judge, are you wanting a copy of the special commission, that exhibit on the screen right now?
Well, I have it in a file here, so
Okay.
probably easier for me if I could just find it.
Okay.
Did you want us to direct your attention, Your Honor, to the page of the special commissioner's hearing transcript where the reference was made to the commissioners that the sign did not encroach on the right-of-way as indicated by a survey that was tendered?
If I can find it here, I think I can point it out. And I guess part of and I found that now in a file, and one of the things I just want to talk a little bit is again, in SignAd's brief on page 25, it says this was presented to the special commissioners. And then on the state's brief on page 6, it said under number 17, at no point did SignAd's representative C. Rothfelder ever disclose to the commissioners or to the state that SignAd had moved the signs?
Yes, and Judge, I think the discrepancy may be that I will stipulate that Chris Rothfelder attended the hearing and he attempted to put a survey into evidence, but he had no surveyor with him. The state objected and the special commissioners chose not to view it. But we can go over that transcript and I think you'll see that he never discloses that the sign has been moved. He simply attempts to.
Judge, are you just asking questions of us right now, or are you inviting argument from counsel?
I'm just asking questions. Again, when I read the two briefs, there's something that SignAd's brief and the state's brief are quite dissimilar on this one point. So I just want to make sure I'm not missing something. And if the basis of the proof will be the special commissioner's hearing, then we can refer to that.
Well, Chris Rothfelder attended that commissioner's hearing. He has the transcript in front of him. And if Your Honor would like us to refer to page and line we can do so.
I had it, and then the file's so thick that it. All right, so I believe it's on page 21 of the transcript. Where I think starting probably about line 11 is when there's just a discussion about the transcript. But we can talk about that in the evidence. It's just you're reading the transcript. There's just looks like there's a discrepancy as to whether or not there was a survey present or whether it was actually just disclosed to the commissioners and disclosed to the state. Okay, and so Ms. Fagerberg, on page 2 of your brief, the third paragraph, there's a statement that said, SignAd, through its actions, was not a property owner with a property right in the right-of-way path of the bridge at the time the suit was instituted in October 2018. So is that, again, the allegation is because the sign had been altered in 2018?
Yes, Judge. So if you've removed all your property from the right-of-way path, then you don't have any real property in the right-of-way path for us to compensate. So yes, I don't believe they were a real property owner with any interest at the time our suit was filed.
All right, and then going a couple pages over on page 4, what's marked as number 5, said TxDOT made its offer to SignAd for the condemnation of the sign in September 2017. So in September 2017, TxDOT is saying they were a property owner, but by October they were not?
Correct, Your Honor. When we started the process, appraised it, sent out our final offer letters, they were a property owner. But then because they moved the sign and we didn't know it in August of 2018, they ended up not being a property owner at the time of the suit.
Right. So
If I can, I guess I need to respond to that, Your Honor. Of course, I don't think anybody disputes that the sole reason for eliminating the 2-foot aerial encroachment on the expanded highway project was to accommodate the project, to allow the project to go forward under the threat and in anticipation of eminent domain. That's a compensable property right, and we're a property owner accordingly under 21.095C. But secondly, I don't want the court to lose the fact that has not been rebutted anywhere in any of the state's briefing that regardless of the sign, a second compensable interest is the leasehold interest in this case. SignAd maintains that sign on the ground pursuant to a leasehold interest that is compensable in eminent domain, such that when TxDOT condemns the property, requires the removal of the sign, they terminate the lease and have to compensate both the lessee and the lessor. That lease continues in force because, once again, in anticipation of and due to the threat of eminent domain, the sign was actually moved out of the state's right-of-way so that the railroad continues to accept SignAd's ground rent payments and SignAd continues to pay ground rent payments under that leasehold. But we continue to be a property owner, continue to be an owner of the leasehold that would otherwise be subject to the condemnation suit.
But is the leasehold interest anything that's going to be decided today?
No,
Mr.
other than to rebut this allegation about whether we're a qualified property owner to recover damages, expenses, and fees.
May I respond, Judge?
You may.
So, Judge, what they're referring to is the fact that when you have a sign company like Clear Channel or SignAd, and let's say you have a billboard structure that's located on a fee, right? They're going to pay that fee owner every month to be able to have their pole and their sign there, right? And that's what he's referring to. It's sometimes called a sign site. But I'll represent to you that we're not acquiring the sign site. And what they appear to have in this case, because there's no normal fee, because it's a railroad that exists, all they have is a license agreement with the railroad, and we've not damaged that. And nowhere in their discovery do they claim that as one of their, as an item of compensation or a concern for today. So whatever they have with the railroad in terms of it being a license agreement to keep their billboard between the railroad tracks, that's not something that we're impinging upon or acquiring at all.
Well, we adamantly disagree, Your Honor. And common sense tells you, as well as contract and real estate law, that sign is affixed to the real property pursuant to an agreement between the railroad that controls that right of way and has the discretion to lease and collect ground rental payments. SignAd pays rent to the railroad. The railroad collects rent from SignAd. And that license or lease agreement is being offered into evidence under Exhibit 21. And indeed, the railroad collects 30% of the advertising revenue generated on the sign at a minimum of $1,600 per year. It actually turns out to be, in 30% of the advertising revenue, closer to $16,000 a year that the railroad collects as a landlord and that SignAd pays as a tenant. And if the condemnation proceeding had gone forward, the state would have been required to compensate the railroad for the loss of that ground rental income stream. And it would have been required to pay SignAd for its lease bonus value, i.e. the benefit of the bargain in that SignAd actually had a below market rate on its ground lease. So SignAd would have additionally been able to recover its tenant's leasehold interest, valued at about $45,000 was its benefit of the bargain under that leasehold, as well as the cost approach for the sign structure itself. The commissioners awarded 118 without even any evidence. The cost value of that sign is actually probably closer to about $150,000. So if the condemnation case had gone forward, it would have probably been about a $200,000 compensation to SignAd. But once again, because SignAd moved the sign out of the right of way, there was no need for the taxpayers to provide compensation in eminent domain to either SignAd or the railroad. The railroad probably had as its landlord's interest at $16,500 a year in ground rental that it enjoyed. A present value of that at a 6% cap rate is about $275,000.
Judge, I'm going
So
to
the
need to
point,
object
Your
to
Honor,
this.
is that this was going to be about a
Ms.
$470,000
Fagerberg
reward.
objected. So let's wait a minute. Ms. Fagerberg objected. And again, what I'm trying to just find out now before we get started without going into specifics is if what, and that's why I asked earlier, what SignAd is asking for me to rule on today is the damages, expenses, and fees, and whether or not any leasehold interest is part of that damages, expenses, and fees.
And it's not, Your Honor. I was simply, and I apologize for belaboring the point. SignAd is a property owner under the statute entitling property owners to recover their damages, interest, and fees.
And Jed, just to make clear, I disagree with a number of the things Mr. Rothfelder said, as well as some of the things he's trying to put on the value of the sign that have never been brought up in discovery, disclosed, anything else. So just so I want to make sure my objections are clear for the record.
Okay. And again, we haven't even started with any evidence yet. So I just want to make sure I have good signposts where we're going. All right. So Ms. Fagerberg, in the state's brief on page 15, near the bottom of the second paragraph, it said SignAd should not recover damages and expenses for making various cures. And this analogy may not be a very good one, but if making a cure is sort of the equivalent of self-help, and you can correct me if I'm wrong on that, but as a public policy, don't we want to encourage people to use self-help to, reduce fees and costs and court's time?
Judge, the answer is no. Under the law, there is no basis whatsoever for any property owners to claim any type of damage. And by the way, I object to the term cost to cure, because cost to cure means something specific in appraisal terminology. What it means is that when the state acquires something within an appraisal, it's a form of basically giving the landowner extra money for an item that's depreciated. So I want to be really careful about the way we use that term cost to cure. But basically the answer is no, and eminent domain courts are not allowed to give out some type of preemptive relocation package as part of their jurisdiction. Relocation is something that is handled in an entirely different scheme it's a federal scheme. It's administered by states. It has a whole separate appeal system. So you will never find any competent eminent domain judge handing out relocation packages, particularly, and if they are, they're always subject to very stringent approvals and rules. You don't just have property owners doing it on themselves and then suddenly announcing it in the eminent domain suit. They would like something to be paid that was done beforehand without approval. And in a similar vein, if you don't characterize it as relocation, which by the way is only saved for items that are deemed personalty under the law, in the state of Texas, we're not allowed to condemn personalty. We can only condemn real property. And so the other thing to understand, Judge, is we have to evaluate property that's there, not beforehand. If this property had moved forward into a trial phase, we would have looked at the date of valuation as being, or what's called the date of taking in our case law, as being the date that we would have deposited funds. And that is very much a black letter law that you can't move forward. And I cited a case called Capital Livestock. And basically what happened in that case is the landowner sold off part of his property. So he got a big award, but then he sold off the remainder before the date of taking. And the court says, well, you blew your damages to the remainder. You can't collect all these damages to the remainder if the remainder's gone as of the date of deposit after the special commissioner's hearing. So that date of valuation is very critical. We don't want landowners deciding, well, I'm going to do the state a favor and I'll do X to cure my problem. And then try and ask the state for compensation later. It's not legal, certainly. There's no basis for doing it. And I would suggest to you that there could be a lot of problems with that. In fact, go ahead, Your Honor.
I was just to say, looking at the timeline in September the state sends a letter to SignAd and says they want to offer or settle. And I mean, isn't that letter that was sent in September 17 a way to reduce future costs and expenses to everybody?
You're saying, well, I think the September letter was the final, September 2017 was the final offer letter the state gave to SignAd, correct? Are you addressing a different letter that SignAd sent to the state?
I thought that was a letter that the state sent to SignAd in September of 17. So again, isn't that a letter that the state sends to SignAd or any property owner saying, okay, if you can do this right now, we'll give you X amount of dollars, and then we don't have to incur more costs, expenses, and attorney's fees?
Sure, that's exactly what it is, Judge.
Okay, let me
And
hear
for
from
her-
Ms. Fagerberg.
All right.
Well, Judge, the final offer letter is simply the appraised amount that we're offering to the property owner for the acquisition of that property. In any given case, the cost to, remove the obstacle from the right of way could be more or less than the amount. It could be advisable or inadvisable. It could be illegal. It could be legal. It would depend on the circumstance. But from my perspective, there's just absolutely no legal mechanism to give somebody compensation for a cure plan they enact themselves, and then try to get compensation for the state later when that wasn't approved. I've literally never heard of that in the 18 years that I've practiced nothing but eminent domain law. I don't think you'll find a single case ever where that has ever happened.
But isn't this almost, punishing a landowner for trying to reduce costs?
Well, Judge, I certainly don't, look, I think, let me give you an example that I think is a good one, and it helps me think about this situation. Let's say we have a landowner along a freeway and he has an office warehouse. And let's just assume for purposes of this analogy that he doesn't own the fee under it, okay? The fee's owned by somebody else. He owns these improvements. And he gets a letter from the state saying, hey, we're going to bisect your property. It's what's called a Category 1 bisection. Well, for Category 1 bisections, what that means is that the state gets to demolish the entire structure. They literally can come on to the remainder of the property and demolish the rest of it. So for instance, you never see demolition fees being awarded because the state is going to undertake the entire demolition. And the idea is that in a Category 1 bisection, there could be a safety issue, or it's not financially feasible, or some other problem will develop. Well, let's say you have a landowner who decides on his own that he wants to get out of the right-of-way path. So he decides that he's going to go ahead and demolish his own property right now. He'll just cut off the front office. But let's say he doesn't go to the city. He doesn't go and get the permitting. In a lot of big cities, there would be a permit required to demolish a building. Or let's say that he doesn't go get an architectural plan to make sure it's safe to do that. So then he might call me up and say, guess what, Ms. Fagerberg, I did it. Let me send you my demolition pictures. I've gotten my entire office out of your right-of-way line. So please don't sue me in condemnation. Well, on one hand, he's avoided a condemnation. I can't sue him if there's nothing in the path of my right-of-way. But he sort of bought himself another set of problems, right? Namely, he might be in trouble with the city that he's in, because if he's in a big city, well, and he demolished things without proper city approval, he didn't get an architectural plan. Well, gosh, is the city going to let him have a certificate of occupancy? Is there a structural problem? I don't know the answer to that. I don't know if that's advisable from a public policy standpoint or not. But I mean, look, a landowner can always make the choice to demolish something and keep it out of the right of way to prevent the state from coming in and taking it. But then you don't get to come in then and say, well, now pay for my cure and all the resulting problems from it. Okay. Does that make sense?
Sure. And then, so, and Ms. Fagerberg, when do you think the the attorney's fees clock begins for SignAd? Is it when negotiations start, when you get the letter, or when do you think, what's day one of an attorney's fees bill?
You know, I think, Judge, one thing that's bothering me about this case that I think is very confusing is obviously, so in the example I just gave about the gentleman who has an office warehouse and he cuts back his own office to keep the warehouse on his remainder so that the state can't touch it, but then he gets in trouble with the city. What's of course strange here is our situation is that it's the state of Texas right-of-way division and then the AG's office doing the condemnation work, but TxDOT has this separate arm that involves billboard permitting. And I think here, the problem is that throughout 2018, the correspondence shows what they're really trying to do is to amend their permit to move. And that's not something a normal property owner would have undertaken in a standard condemnation case. So I'm not going to stipulate that the billing, even in 2018, was warranted. To me, I don't think if there is no valid suit, I don't know that you have any valid attorney's fees. It looks to me like the totality of evidence in 2018 is really sort of administrative work. In other words, all this billboard permitting happens in administrative courts. And there's a lot of instances where the billing for his administrative work in terms of getting trying to get a new permit and appealing it is now getting asked to be collected in the eminent domain case. And, you know, in a standard property owner case, you wouldn't have had all that work doing that. So I don't feel comfortable stipulating that the clock started back in 2018 and that it was a legitimate legal purpose for condemnation to be trying to do all the work to adjust the permits to avoid the suit.
All right. And yeah, I'm not asking for a stipulation now, but just, you know, when, you know, in general, if a landowner gets a letter from the state of Texas that says, we want to come and take some of your land. And so that landowner takes the letter to an attorney, and the landowner and the attorney meet in his office and they talk about the case, and the attorney goes over the procedure of what's going to happen. You know, there hasn't been a suit filed yet. There hasn't been a response. You know, is that something in general, not in this case, but in general, that you would see that could be a compensatory attorney's fees expense, you know, in any case?
Okay, so Judge, not talking about this case, but as a general principle, I absolutely agree with you. And in fact, I have given attorney's fees. I had a case with a well-known practitioner named Luke Ellis. I've had dismissal cases with Thompson and Knight up in Dallas. I don't know how familiar you are with Dallas, but it's very rare for the state to dismiss cases. I mean, it's almost unheard of, but the times that I've been involved, it involved the LBJ/635 freeway in Dallas. And essentially the state lost funding. And in fact, right before the special commissioners hearings, we had to pay out their legal fees. And you are absolutely right. We paid out all the legal fees from the time, and by the way, we were fine with them. I stipulated to all their legal fees from Thompson and Knight, and from, I believe Luke Ellis was with Jackson and Walker at the time, and we stipulated to all their fees from the time they were hired, which was sometime prior, I believe, to the filing of the petitions, through the time that we let them know it was to be dismissed, which I believe was short, like maybe even the day before the special commissioners hearing. It was very close in time to that.
All right. And so, you know, you said back in September, looking at your brief, back in September of 17, you said at that time, SignAd was a property owner, right?
Yes.
All right. And so is the distinction going to be that between September 17, when the offer letter was made, and in October of 18, when the special commissioners hearing was held, that any work in between that time was permitting work and not landowner work, not condemnation work. Is that's what I should be looking for during this case?
Judge, I mean, they stopped being a landowner in August and they failed to disclose that they had moved it to us. And I believe the evidence indicates we had no reasonable basis to believe they were going to move their sign, given that we had just gone through these lengthy proceedings telling them they couldn't move it. The permitting arm was telling them that. So I think the other thing is, from my perspective, I don't think moving something out of the right of way is a legitimate purpose for something you can collect as a dismissal fee. And Judge, it might help us to actually go over chapter 21 of the property code, because I realize that it doesn't say on its face, hey, this is an equitable doctrine and you need to have clean hands. But throughout the case law that's discussed, and by the way, Judge, there's another statute that's 21.019, and that exists before there was the one that was specific to Texas transportation.
Objection non-responsive.
Yeah, let's, but we can,
Well,
again, in your opening, if you want to go over
okay.
that you may. I'm just,
Well, I guess, but I don't think it's only limited to their characterization as a property owner. And that's what I'm getting at. I believe it also has to do with the fact that the state did not abandon the proceedings here. And I think the reasonable and necessary, it deals with a scenario where the state has abandoned the proceedings, right? Where the state has lost funding for a project, for instance. And here they voluntarily, I mean, they got what they wanted. They moved outside the condemnation. So from my perspective, I don't think the statute is applicable to our situation. I mean, most case law, so in other words, don't just focus on the property ownership. It's also the fact that the state did not abandon the proceeding. They forced our hand because they wanted the proceedings to end.
okay. And again, we could talk about that a little bit later, but I think one of the very first things, I talked about when we got started is, are we going today under 21.0195? And I think everybody agreed we are. So if Ms. Fagerberg, if you have a reason we're not, then I want to know that.
Judge, it's not that I don't think we're proceeding under that, but I will make clear to you that even courts that are specifically analyzing 21.0195, they also still look at case law from 21.019, just because there's more case law to look at. So when you look at some of the courts that have looked at 21.0195, they still look at decisions that were made under that other statute that's related to more general condemnors, if that makes sense.
Okay. And going again to Ms. Fagerberg, in your brief, you refer to this 1970 case, the City of Austin versus Capital Livestock. And there's a lot of discussion in that case about, damage to a remainder track. Is there any analogy, anybody going to claim that the sign that's still there is the equivalent to a remainder track? Ms. Fagerberg?
Your Honor.
Okay, so Ms. Rothfelder, you're not?
No.
Okay, all right, so we can move on to the next thing. All right, and so Mr. Rothfelder, I'm going to direct some of this to you.
Yes, sir.
When Ms. Fagerberg was talking about that there's, the not having clean hands, and you stated, that there's not a state of mind requirement in 21.095, but the statute does say that the court will make a reasonable allowance for damages. I think the purpose of the statute is sort of twofold: to compensate property owners for expenses incurred during abandoned condemnation proceedings, and to discourage subsequent abandonment and condemnation proceedings. So isn't there, almost a good faith, duty that's implied there to look at these reasonable fees, to find something that's reasonable?
You're right. Yeah, sure, Judge. Of course, the statute doesn't use the word abandonment. That's argument from counsel. The statute uses dismissal by TxDOT. Of course, we know section 21.0195C is expressly aimed at TxDOT, and it's in the mandatory as a statutory obligation under which the court shall issue damages, expenses, and attorney's fees, which it determines to be reasonable and necessary. You're absolutely correct, and we'll demonstrate that they were reasonable and necessary under the circumstances in this case, including because of the reasons that you pointed out some 10 minutes ago in questions to Ms. Fagerberg. They made an offer for the complete taking of the sign. It was not satisfactory, but over $110,000. But we moved the sign out of the right of way for less than half that cost. We did a good thing, Judge. We saved the taxpayers the expense in acquiring the property in total. We saved the taxpayers in the court system the necessity of an eminent domain case. And we showed them that there was no longer any encroachment before the petition was filed, before the commissioner's hearing was held. And the evidence is going to show, Judge, by the way, they knew for a fact, they admit, before they came into your court and contested the temporary injunction that we had to submit, they knew that SignAd had removed the encroachment on the right-of-way at least 3 weeks before they came in and acted so surprised that there was no longer any encroachment. So we did a good thing in saving the taxpayers money, and contrary to what counsel says, the courts allow the compensation for the adjustment costs that were undertaken in this case. And indeed, that's all we asked the state to pay was the $45,000 that it cost us to move the sign out of the right-of-way and eliminate the eminent domain case, and they flatly refused. And it's their rebuffing of those efforts to just pay us the reimbursed cost that brings us here asking now for over $200,000 because it took them over a year to dismiss that case.
And by moving the sign or altering the sign, didn't SignAd, get what it ultimately wanted? That was, preventing or trying to prevent the condemnation?
Yes, Your Honor.
Okay. And just so I'm real clear, going back to Ms. Fagerberg, is there any distinction in a condemnation case between taking the fee title to land or taking attachments to or reimbursing somebody for attachments to real property?
Judge, as long as the fixture is characterized as a real property fixture, that would be compensable in eminent domain, but relocation is not compensable in any domain case. So to the extent that it was really some type of a relocation in advance of a suit, that is not something that you have jurisdiction to award.
If I could, Judge, nobody's asking you to award any eminent domain damages, but she's dead wrong. In the billboard context, the billboard owner that either completely relocates his sign or merely adjusts the sign, in this case, to eliminate the encroachment of the real property is entitled to reimbursement of his costs in doing so.
Yeah. So real briefly, so Ms. Fagerberg, do you have any cases that might say that either relocation or adjustment is not compensable?
I can do that, Your Honor. Yes, I can find some for you. This has been briefed before. I'm frankly surprised it's being contested, but yes, relocation claims do not occur in eminent domain cases. So when we have a break, I can pull one of those cases for you.
To be clear, Judge, this is a billboard case. You've got Wendy Knox, who's the supervisor of the Billboard Regulatory Department of TxDOT, on the screen. And you can ask her, Judge, in the context of a billboard case where the billboard company removes the sign from the right-of-way to accommodate the TxDOT highway improvement, they are entitled to reimbursement of their costs in doing so. I
Well,
invite you
let-
to ask Ms. Knox if there's any dispute on the point.
I'm sure somebody will ask Ms. Knox that question. All right, so David, how much of a opening statement would each side like to have to kind of outline where they're going to go? Mr. Rothfelder?
Yeah, I'd like 20 minutes, Judge.
Okay, and Ms. Fagerberg, about how much time do you think you want for an opening?
I don't think I need 20, but I guess let me hear Mr. Rothfelder and we'll see what I need to respond to.
Okay.
I certainly
say-
won't need more than that.
All right, why don't we, let's take about a 5-minute break and then we'll come back and hear the opening statement. So it's almost 10:15, so let's come back about 10:20 and resume, but we'll be in recess.
Thank you,
Thank
Judge.
you.
Need some more friendly lights.
There's two parts.
I know. Makeup, I need hair and makeup. I may want to do something before we go on the record. I'll tell you when we get on the record. Hold on a second. I think I see everybody back. Before we go on the record, I heard people comment about a list of agreed exhibits. I may want to refer to that. So where would that be? I have, Mr. Rothfelder's list of exhibits 1 through 45. But is there a different document that I should look at that says what's agreed to?
Judge, it might be best to go over it orally because I think it's been done through a variety of items of correspondence. I did submit a list to them this weekend that had check marks on it, and I could forward that to you.
Okay. So is that anything that it's on file that I have?
It is not on file, Judge. The parties communicated about it over the weekend informally.
And then, so Ms. Fagerberg, I have the exhibits that have been filed. Is there a kind of an index of the exhibits somewhere?
There should be, Your Honor. In fact, this morning, I sent a copy not to you, but to the CCL email address. And I'll represent to you, it's the same thing I filed last week, but I had failed to add columns. And I wanted to add some extra columns so that we could all better keep track of it.
And so we're going to pull that up on the email. So as soon as I get that, then we'll go back on the record.
Your Honor, I
Yes.
just uploaded those to the chat if you'd like to download them from there.
Okay, I see those. Let's see. All right, when I tried to download that, I'm getting something. Can you all see that? You don't have permission to save in this location. Contact your administrator. So tell you what, if it's the same thing that was emailed, we're getting that printed out. Again, I do have, there was a summary from Mr. Rothfelder that they were listed, again, exhibit 1 through 45. Is there anything different that I should be looking for?
That's our live exhibit list.
Judge, if you'd like, I can send to you the same thing that I sent to them this weekend that has check marks on it already.
But we can just go through it in a minute as soon as we get this email printed out from Ms. Fagerberg. All right, so we have the email from the state where they're 1 through 54. Is that right?
Yes.
Okay. Okay. All right, so we'll go back on the record on state versus SignAd Limited. And one thing I want to do before we do the opening is find out what exhibits are agreed to. So we'll start with Mr. Rothfelder's exhibits. I have a list of his exhibits 1 through 45, with 40 and 41 being blank. And which one of those, Ms. Fagerberg, do you agree that can be admitted
Sure,
without
Judge.
proof?
Number 1 is okay as long as a date is provided. We just want to make clear there's photographs from before and after the sign was moved / altered. So, but assuming they can provide a date, I'm fine with number 1. State agrees to number 2. State agrees to number 6. State agrees to number 9. State agrees to number 10. We're okay with 14 only with respect to notice, not with respect to content. I don't know if that's easier to specify or not. If you'd rather just have me object in toto to that, if I'm only willing to admit it for a limited purpose. Number 15, I'm all right with. Number 16, same as number 14. I'm okay admitting it for notice, not for the content. Number 17, I'm okay with that one. And number 18, I'm all right with that survey as long as that is the, as long as my injunction hearing transcript is also admitted, because it's a little dangerous to admit surveys when we don't have any testimony describing them and we don't really know what people are going to say about it. But as long as the injunction hearing transcript with his testimony is admitted, I'm okay with 18.
So let's just stop there for a minute. So,
Sure.
Mr. Rothfelder, do you agree that the transcript from the injunction hearing will be admitted?
So stipulated.
Okay. All right. So, Ms.
So
Fager?
Judge, on number 19, it's actually a sort of an email chain. It consists of a chain from Chris Rothfelder to Samantha Kessler Diaz in September of 2018. And that email we can stipulate to. Unfortunately, the second email I cannot stipulate to. So I guess the exhibit as a whole, I cannot agree to. If they're willing to redact out the October one, I can agree to it. It might be better to agree to the September one and move the October one to a separate exhibit 1. It looks like he attempted to email her with a survey, but our investigation indicates that we probably didn't receive that. It looks like maybe the survey was too large and it bounced. We'll go over that. Number 20, the state is okay with the revised sign photos, again, as long as they're dated. On number 23, I have there being 2 number 23s. Does anybody else have 2 number 23s?
Yeah, the list that I have just has 123. There's emails between R. Rothfelder and N. Fagerberg, RE Surveys and Settlement, 4/1 and 2/19.
Number 22, I'm fine with admitting in terms of showing notice and timing, but not for the content. With respect to 23, the state will agree. State will agree to 24. State will agree to 25 with the proviso that it's misdated on the face of the document, which is very confusing. So even though their exhibit list does clarify that it's misdated, I would really prefer we have a handwritten date inserted so that we can all stay clear on the dates. As long as that's done, I'll stipulate to 25. With respect to 27, I will agree to. 28, I will agree to. 31, I will agree to. 33, 35, 42, 43, 44. And then I think, let's see here. And then I also have stipulated in an email that I'm amenable to introducing Mario Caro's deposition as an exhibit to the hearing.
All right. Okay, some of these that have other things you want proven, I'm not going to rule on those now. When they come up, well, I just want to clarify what needs to be done. But I will admit SignAd exhibits 1 if the date is proven, admit 2, admit 6, admit 9, admit 10, admit 15, admit 17, admit 18, along with the transcript from the injunction hearing, admit 20 as long as the date is proven, admit 24, admit 27, admit 28, admit 31, admit 33, admit 35, admit 42, admit 43, and admit 44. All right, now looking at the state's exhibits, Mr. Rothfelder, which one of these do you agree to?
By the way, Judge, did you note that there was a stipulation on the admission of exhibits 22 and
22 is noticed not kind, but 25 with the date corrected.
right, 25 with the date corrected as well?
All right, so is exhibit 25 to be agreed to be admitted if the date is corrected? I tell you, what is the correct date?
3/29/18.
All right, so Ms. Fagerberg, do you agree to exhibit 25 being admitted if the date on that is March 29th, 2018?
I do.
All right, so the exhibit 25 is admitted with that change. All right, so Mr. Rothfelder, what state's exhibits do you agree to?
Stipulate to the admissibility of 2 through 35. And 44 and 51.
Right, then states exhibits 2 through and including 35 are admitted. States exhibits 44 is admitted and states exhibit 51 is admitted. All right, so Mr. Rothfelder, you may give your opening statement.
Thank you, Your Honor. You, like me, read over the weekend the state's trial brief, and I've got to tell you, I'm going to start off with a little bit of what I thought was ironic and indeed hypocritical about the things that they alleged in that brief. Indeed, the state rails in that brief about what they characterized as misrepresentation by omission, when it's the state that misrepresented its knowledge that it learned at least 3 weeks before the temporary injunction hearing on February 14, 2019, when we went in and enjoined the state from removing the sign when it had already been eliminated from the right-of-way. Moreover, it's ironic and indeed hypocritical that the state rails about these attorney's fees when SignAd actually took action as you noted in your questions, Your Honor, to avoid a taking that the state had offered over $100,000, and our cost of adjusting the sign out of the right-of-way was less than half that. And we saved the trouble for Your Honor in the court system by eliminating an eminent domain case. When they had knowledge that the sign was out of the right-of-way before the petition was filed and before the special commissioner's hearing was held, and certainly before the temporary injunction was held. And then it's ironic and hypocritical, Your Honor, that after SignAd spent $45,000 to eliminate the eminent domain case, remove the encroachment from the right-of-way, and the evidence will show, thereby saving the state a $470,000 potential award in the eminent domain case to SignAd and the railroad for the leasehold interest as well as the sign. SignAd had attempted to settle the case when it only had the $45,000, offering to waive any attorney's fees. After that injunction hearing where it was ordered that the state could not remove the sign, but the state rebuffed those efforts, and we'll see that in evidence as Exhibit 23, where Ms. Fagerberg responded in the month after that injunction hearing that the state's not interested in negotiating and don't intend to pay any monies, which caused SignAd to go forward with the case to try to recover its cost of adjusting the sign, whether through a trial or if the state dismissed the case, which they took another year to do. And when the state finally dismissed the case, they trigger the mandatory statutory obligation under the property code, 21.095C, which provides that the state, in fact, this is specifically tailored for TxDOT whenever they dismiss a proceeding. When the state dismisses a proceeding, the court shall award damages, expenses, and fees that are reasonable and necessary. And the evidence is going to show, Judge, and it's going to be summarized in a document that will prove up that summary is Exhibit 26, and that evidence will show that the total of the damages, expenses, and fees are $212,000, plus another $20,000 incurred in attorney's fees anticipated this month that haven't been billed, along with the follow-up that we'll have after this hearing. So that we'll be seeking in damages, fees, and expenses in this request to Your Honor of $232,106. Now, the state tries to avoid its mandatory statutory obligation for the reimbursement of those costs by alleging that SignAd wasn't a property owner and that it had bad faith, or at least that the fees were not reasonable because of the actions that it undertook affirmatively to eliminate the condemnation case. But we start off, Your Honor, with the proposition there's no state of mind under the statutory obligation, 21.019 fee. It simply provides that the court shall award, and the courts have looked at that. And indeed, in another billboard case that we cited in our brief, the Eller versus state case made it clear, and I'm quoting, the language of 21.095C is mandatory. The district court therefore had no discretion to refuse to award Eller its reasonable and necessary fees if properly requested and proven. And we've properly requested them, and we're going to prove them today, Judge. Eller's another client of mine, and it's a billboard company that made a similar request, and the court, using that language, made such an award. And it's ironic and indeed hypocritical that the attorney for the state, she admitted in her brief, she admits at the temporary injunction hearing by telling you that, and by the way, that permitting issue, that won't be in front of you today. That's a whole administrative thing that I don't think we need to get into today. But of course, we know TxDOT's talking out of both sides of their mouth because that whole administrative thing is a separate lawsuit that TxDOT has now filed against SignAd, in which they're seeking over $1 million from SignAd, plus removal of the sign because
Judge,
of SignAd
I need to
actions that
object
take-
to relevance.
Okay, so what's the relevance of that, Mr. Hoffeld?
Well, the relevance is that they're claiming that we acted in bad faith in removing the sign out of the right of way, and or that the attorney's fees are not reasonable and necessary because we didn't have a permit to do so. The fact of the matter.
Objection will be overruled if it goes to reasonableness.
And
You
it does,
may
Your Honor.
proceed.
Now, so they have a separate form where they can contest the movement of the sign out of the right of way that they say required a permit. Well, we'll reserve that analysis, although it has to come up before Your Honor today, I believe, to show the reasonableness and necessities of the attorney's fees, to show that SignAd acted in good faith and what it did in trying to save the taxpayers, the condemnation case and the award in eminent domain. The other issue that the state has raised is we're not a property owner, but the court, I think, accurately pointed out that when they initiated this case, we certainly were, and we certainly removed the encroachment on the right of way solely to accommodate the project in anticipation and under the threat of eminent domain. And that's just the sign, because regardless of the ownership of the sign, we also have a leasehold interest. We continue to have a leasehold interest that qualifies us as a property owner. And if that condemnation had gone forward, the lease would have been terminated and we would have been entitled to compensation of about $45,000 for the taking of our leasehold interest in eminent domain.
I'm also going to object to that, Your Honor.
What's your objection?
Judge, there's been no expert opinion provided at any time or in their discovery about the value of a leasehold.
Okay, objection sustained.
Your Honor, if I can be heard, by contrast, Wes Gilbreth has been designated as an expert witness in the case. There have been proof of the advertising revenues provided in the case, and Mr. Gilbreth intends, as an expert on buying and selling billboards, and his knowledge of the case of what they sell for in the open market, he intends to give his opinion on what it would have cost him to duplicate this sign if it had been taken in eminent domain and lost forever, which goes to the point, Judge, that it was reasonable and necessary for SignAd in this case to spend over $200,000 in damages, fees, and expenses to salvage an asset that Mr. Gilbreth, as an expert, will testify would have cost him $750,000 to duplicate on the open market in the industry. That goes directly to the reasonableness and necessity of the attorney's fees, Your Honor.
And Judge, that $750,000, to my knowledge, the first time that number ever appeared was in their brief that was filed Wednesday last week. There's been no valuation that I can see that it is anywhere in their discovery. The only item I can see.
They didn't take his deposition. We fully answered all discovery. They decided not to take his deposition, but it's clearly relevant and clearly goes to the central issue in this hearing.
All right, well, and when we get to Mr. Gilbert, you can explore that testimony, but if you want to go ahead with your opening.
Yeah, Judge, I mean, this whole issue that they were surprised and therefore we misrepresented by omission, that's all belied by a chronology. Starting, Judge, with Exhibit 33 that was pre-admitted, and if I can pull that up on the screen, I want to show the judge that this dates well prior to that September 2018 email that you were, or letter commencing the eminent domain case that you were talking about. Judge, you have the hard copy in the book before you, and you can see Exhibit 33 is an email to Wendy Knox, who's one of the witnesses of the state here, from Greg Polosic, and it's dated March 29, 2017, in which these internal TxDOT folks are talking about this condemnation case. And they specifically say, the proposed plan is to replace the existing IH-10 bridge with a wider bridge impacting the billboard. We are determining the extent of the new bridge clipping the sign. The billboard appears to be located on BNSF property, and an option would be to shift the billboard over if BNSF agrees. Of course, they did. And indeed, TxDOT was looking at this possibility of saving the taxpayers money as an alternative to going forward and filing an eminent domain case and requiring complete removal of the sign as early as this March 29, 2017 email. Now, then we see that TxDOT fully worked and cooperated with TxDOT towards this plan. Specifically, Judge, I direct your attention to Exhibit 10, which is an email already pre-admitted between Dan Creel, the former real estate manager of SignAd, and several TxDOT folks. And you can see in that email, Judge, Exhibit 10, there's a full discussion about what's going on here. As early as January 2018, TxDOT's explaining to both TxDOT and to the city of Sealy the plan to simply move the sign out of the right-of-way, including that first email that's the fourth page of Exhibit 10, involving the Sealy representative who acknowledges that Sealy will issue a permit. Then on January 25, we see on the third page of Exhibit 10, Dan Creel is talking to the TxDOT as well as the Sealy folks and specifically telling him, since we are not moving the sign onto another property or moving the sign on the property, but simply moving a part of the sign face out of the right-of-way without moving the sign, we have secured the Sealy permit. And indeed, that Sealy permit is exhibit number 13, Judge. We'll prove it up. It wasn't pre-admitted, but the Sealy permit to make sure the work was done safe and secure pursuant to this plan that was discussed with TxDOT throughout January 2018. And they came up with the idea themselves as early as March 29, 2017. That Sealy permit was actually issued on January 24, 2018 in exhibit number 13. Now, we then, through Chris Rothfelder, wrote a letter to TxDOT laying out the plan in detail. That's exhibit 14, and this is a letter from Chris Rothfelder to this TxDOT Greg Polosic, dated February 7, 2018, when he laid out all of the reasons that SignAd should be permitted under a proper analysis of a prior settlement agreement that TxDOT had entered into back in 2011 regarding the grounds that TxDOT is now asserting that prohibited the issuance of an amendment to the permit to do this work. Again, we adamantly take the position that a proper regulatory analysis of TxDOT's rules allow the work to be done with an amended permit. Just to move the sign over out of the right-of-way, the 2 or 3 feet it took to accommodate TxDOT's project, eliminate the aerial encroachment. But that's the subject of this SOA case, which we'll take up on October 5 on behalf of SignAd. But it goes to the issue of reasonableness about what TxDOT did and what SignAd and its lawyers did in attempting to secure the right to move the sign out of the right-of-way, eliminate the condemnation case, And then what caused the dismissal and triggering these attorney's fees that then become reasonable. Now, TxDOT went out and inspected the sign, Exhibit 34, pursuant to an application that TxDOT submitted to amend the permit to move the face out of the right-of-way. That's exhibit number 25. That application to move the sign out of the right-of-way is exhibit 25, and it's dated March 29, 2018. TxDOT denied that application incorrectly, Judge. We don't need to go into any more detail than Your Honor would like to hear, but
Your Honor,
the
I don't want to object too much, but I have to. This cannot be a debate about the validity of TxDOT's permitting decisions. It will take this court very far afield. It will waste all of our time. This is an eminent domain case. It is a dismissal of an eminent domain case. And this is not a referendum on TxDOT's regulations about billboard policy and everything that's gone on in the SOA case. In other words, the State Office of Administrative Hearings. I object to all of this as being relevant to the eminent domain case.
once again, they're trying to have it both ways, Judge. They're trying to argue that SignAd acted in bad faith in adjusting the sign out of the right-of-way and committed misrepresentation by omission. They cancel our permit. They file suit in SOA and seek over $1 million.
Same
and
objection,
we
Your
simply
Honor.
are trying to show that SignAd acted reasonably and that the attorney's fees are therefore reasonable and necessary under the circumstances leading up to the work that was done to eliminate the encroachment, and then TxDOT finally conceding there was no further public necessity to proceed with the eminent domain case, dismissing it a full year later after they learned that the sign was not going to encroach and be publicly necessary to take. All of that goes to the reasonableness and necessity of the recovery of damages and attorney's fees in this case. I can see why they don't want to go into the regulatory issue and the settlement in 2011, which makes it clear that what SignAd did in saving the taxpayers the condemnation case and eliminating the eminent domain case, all of that was correctly undertaken. They don't want you to hear about the proper interpretation and the proper analysis of that 2011 settlement agreement, because that authorizes SignAd to do exactly what they did, Judge.
Okay. All right. Well, again, we're just in opening statements here, so I understand there'll be a lot of fights about what's reasonable and what's not, but let's go ahead with your opening statement, Mr. Rothfeld.
But the evidence is clear, and then they introduced without objection and didn't object to our exhibits. They denied our permit application. We timely appealed it. They wrote an affirmance of the denial of the permit application as of July 2018. And that's where SignAd finds itself in the position where it no longer has a right to seek through civil litigation a further judicial determination of the incorrect decision that TxDOT made in denying the permit to move the sign out of the right-of-way. I can tell you from experience, Judge, the courts don't allow, once TxDOT has denied a permit application and you've appealed to the executive director of TxDOT on this internal appellate process, and the executive director of TxDOT affirms his subordinate on the previous denial of the permit, there's no further opportunity for judicial review. So SignAd made the business decision that it could either go with this incorrect decision issued by TxDOT denying permission to move that face back the 2 or 3 feet in order to eliminate the aerial encroachment. And doing so would mean that they lose the sign forever because you can't put them back up in Sealy under Sealy's regulations. And the evidence is going to show that that sign is worth to SignAd on the open market $750,000 to duplicate the
I'll renew my objection.
$60,000 a year in advertising revenue that it generates.
Okay, well, again, I'll sustain the objection as part of an opening statement. But Mr. Rothberger? Rothfeld?
Thank you, Your Honor. They could accept that decision, lose the sign and its value, or they could contest the anticipated regulatory fight that they would have in the State Office of Administrative Hearings, which is what they did. They went ahead and did the work throughout August. They did it over about a 3-week period. During the week, didn't hide anything, didn't do it at night or on weekends. They did the work that, again, TxDOT had anticipated through at least the prior couple of years. And after the work was completed finally in about August 2018, and the sign had been removed from the right-of-way, we saw that Chris Rothfelder emailed then counsel for the state, Samantha Diaz, on October 8, 2018, and told her that the sign was not in the right-of-way.
And I need to object to that again.
I thought this was one of those pre-admitted exhibits.
It was not. Only
Well, I haven't
the
offered it yet, so you can object when I offer it. I'm just an opening statement right now.
All right, so objection's overruled.
And he followed up again before the state's petition was filed by actually providing a survey to the state's attorney that confirmed what he had told her in the previous email, that the sign did not encroach on the right-of-way. Therefore, the state need not incur the expense and inconvenience of an eminent domain case. Indeed, there's no public necessity for you to prosecute the case anymore. The sign is not in the right-of-way. The state nevertheless filed their petition. And the state nevertheless proceeded, as Your Honor noted, to the special commissioner's hearing a couple of months later on December 20, 2018, when once again, Chris Rothfelder appeared at the commissioner's hearing, and you read the provisions from the commissioner's hearing where he told the commissioners that the sign did not encroach on the right-of-way, and he had a survey confirming that the sign did not encroach on the right-of-way. The commissioners went ahead and awarded $118,000 that have never been deposited in the court registry. Finally, Judge, the state gets around to going out there and looking at what SignAd has been telling them for 2 or 3 months, and they confirm themselves that the sign does not encroach on the right-of-way when Greg Polasic, TxDOT inspector, on January 23, 2019, visits the site and calls Wendy Knox, TxDOT's designated representative, and tells her that he sees that the sign has been moved or adjusted by eliminating the closest pole to the highway bridge and moving the face over some 10 to 15 feet in order to eliminate that encroachment. This call prompted Ms. Knox to call another inspector, Ross Sherrard, to visit the site, and he did so, and he prepared not 1, not 2, but he prepared 3 inspection reports, all dated January 30, 2019, confirming that the sign was out of the right-of-way. He sent it with an email to Ms. Knox dated February 5, 2019, and I'm quoting what his email says. This is, by the way, in Exhibit 42 that we'll be taking a look at because it's already pre-admitted, Judge. he's telling Ms. Knox, I thought I would just send it all to you and see if you wanted to look it over. That way we can put in more and take out some if need be. Thanks for your help on this one. Please let me know if you see any way it could be better. Well, and then sure enough, they apparently thought it could be better because they doctored it up 2 more times, and you can see that there's exhibits 43 and 44, all the same January 30, 2019 field inspection report from TxDOT confirming the sign is not in the right of way. But the important thing, Judge, is to look at that date. TxDOT now admits that as early as this January 23, 2019 call between Inspector Polasic and Wendy Knox, followed by the January 30 field inspection reports prepared by Inspector Ross, that they knew the sign was out of the right of way. Yet, despite this knowledge, we had to go forward before Your Honor at the February 14, 2019 injunction hearing, all designed to prevent TxDOT from going in and physically removing the sign. I mean, after all, the commissioner's hearing had already been held, and there was a threat that the state having possession could remove the sign without further notice. So the injunction was designed to maintain the status quo. But they knew the sign was out of the right of way, but they dragged us all up there. And even in Ms. Fagerberg's brief, she says the reason they went forward was because they wanted to subpoena and get testimony under oath that the work was done by SignAd without a permit. Furthering their arguments in that SOA case, which she's now so proud to say is irrelevant for this proceeding, yet the only reason they made Your Honor take the time for that injunction hearing was because they wanted to bolster their argument that the work was done by SignAd without a permit, thereby triggering the administrative proceeding that we now find ourselves litigating in SOA next month. Now, TxDOT had an order that prevented them from removing the sign because after that hearing, they got their own survey some 4 or 5 months after we provided them a survey and demonstrated that the sign was out of the right of way, and they acted like they're now conceding that there's no longer any necessity. But they wait some 8 months before they ever dismiss the case. In the meantime, having only incurred about $50,000 in cost to remove the sign from the right-of-way, we attempt to settle the case in April. And you'll see it's already pre-admitted. Exhibit 23 is my April 1, 2019 email to Ms. Fagerberg proposing settlement just for those costs of removing the sign out of the right-of-way that SignAd incurred. The next day, April 2, 2019, she says, my client is not interested in negotiating on any of the permit issues, and we don't intend to pay any monies to SignAd in this case for the sign or its removal. Now, Judge, faced with a flat, dead, and arrogant rebuffing of simple reimbursement of the cost to eliminate the condemnation case and in the encroachment, SignAd simply said, well, okay, we'll go ahead and present at the upcoming trial the cost that it cost us to accommodate the highway project. So we filed a notice of deposition for TxDOT's designated representative and their appraiser, and we had to go up and have a fight before Your Honor, as you will recall, in January over the propriety of taking the deposition, because they said that they're going to dismiss the case and we ought to be denied attorney's fees because of our bad faith. And you shouldn't even get any discovery to determine why we think that you acted unreasonably. Well, Your Honor granted the permission to take the deposition, and we did take that deposition, all of which led to more costs, damages, and attorney's fees. Finally, a year after they admitted that they knew the sign had been moved out of the right of way on December 20, 2019, they dismissed the case. That triggers the mandatory statutory reimbursement of cost, damages, and fees under 20.00195 of the property code. And there will be evidence that these damages, costs, and fees total $232,106. And that's comprised, and you can see it once again on the summary that we'll put into evidence as exhibit number 26, Your Honor. Attorney's fees through my last billing of $163,000, but I'm going to testify to another $20,000 through the conclusion of this hearing and any post hearing briefing. So that's $183,802. There's surveyor's costs, there's construction costs, there's permitting costs. So with all of those costs, damages, and fees, the evidence is going to show, Judge, that the reasonable and necessary amount is $232,106. Now, let me tell you, Judge, we're going to emphasize once again that it was reasonable and necessary for SignAd to spend over $200,000. It was necessary because TxDOT refused a settlement offer some 9 months ago for 1/5 that amount, leaving them no choice but to go forward until TxDOT finally dismissed the case. It was reasonable for SignAd to incur that amount of money because if they had not removed the sign from the right-of-way, they would have lost it forever, and they would have therefore lost a $750,000 asset when one has to duplicate the $50,000 to $60,000 a year in annual advertising revenue enjoyed on that sign. Now, I want to conclude because Ms. Fegerberg brought up the issue of equity. The equity here, Judge, is that the taxpayers save substantial funds by SignAd doing the right thing in this case. By SignAd, when they found out that there was going to be a highway construction project, that they eliminated the need for the taxpayers to pay what would have been about $470,000 total for the taking of the sign and the leasehold interest of the railroad and SignAd. Not to mention, save the court the time of an eminent domain proceeding. And for that effort, they now find themselves being sued in SOA for over $1 million in removal of the sign on the one hand, and Ms. Fagerberg on the other hand, saying that we were unreasonable, we were unnecessary, and indeed, we misrepresented by omission what we did. Judge, that's the height of irony and hypocrisy. And it would be appropriate in this case under the statutory mandatory reimbursement provision to provide SignAd with its damages, costs, and attorney's fees of $232,106.
Right, and so before we get to Ms. Fagerberg, one thing I just want to make sure that I'm clear on is when Mr. Rothfelder referred to Exhibit 23, he indicated that had been pre-admitted. I don't show that SignAd's Exhibit 23 was pre-admitted. So was I wrong on that one, or were you referring to a state's exhibit?
Notice, but not content.
No, she stipulated to Exhibit 23. That's checked. Right, Nicole?
Yes.
All right, so just if I didn't make that clear earlier, then
But Are we talking about 33 or 23?
23.
So Ms. Fagerberg, you have no objection to SignAd's Exhibit 23?
I don't, Your Honor. I'll be asking to submit other correspondence between us as well, so.
And just to be clear, SignAd's Exhibit 23 is admitted. All right, so Ms. Fagerberg, you may proceed.
So Judge, I do nothing but eminent domain, and I've done it for 18 years. And I consider myself to be a person who does think a lot about rules, equity, and fairness. And when Mr. Rothfelder characterizes it as me railing against them in the brief, it's because honestly, the situation is really making me upset, frankly. If you think about an average property owner, right? Like imagine we talked about the guy who's running his own business, who has an office warehouse, and maybe there's an office on the front and he's going to demolish it himself to get out of the right-of-way path. That most people in eminent domain cases never get attorney's fees, right? They're not breaking rules. They're not saying rules don't apply to them. They're moving forward with their cases, and they're not then trying to bring up things that are not compensable or irrelevant in their cases. What SignAd really wants to do here is to basically say they get what no one else gets and then act really outraged because they're not getting it. No one gets, first of all, they want to ignore permitting rules. And look, I don't really have a problem with that, frankly. I think Mr. Rothfelder sort of conflates the right-of-way division with the permitting division like we're one department. As a right-of-way attorney who does eminent domain cases before judges, I don't really care what they do with their permits. I mean, that's their choice to violate a permit or not and live with the consequences, right? I mean, from my perspective as an eminent domain attorney, that's their choice, right? It's a gamble. If they want to violate a permit and they want to go off and violate it and risk a SOA action, that's their choice, right? It's like a gambler at a casino. They're making a bet, right? They're making a bet that they can move out of the eminent domain case and that they're going to beat the SOA case, right? So if the State Office of Administrative Hearing, that permitting arm, comes after them, they beat the case, they manage to keep the sign up. Well, hey, they've sort of beaten the system, haven't they? They got out of eminent domain by moving the sign. And if they can beat their SOA case, that's a gamble that pays off. But that's their choice. They may or may not win that permitting case. And I don't really think that's relevant. What's relevant from the eminent domain case is that they did not tell us that they moved out of the right-of-way. And no one was expecting them to move out of the right-of-way. As they state in their own briefing, that sign had been there for many decades. And so, and especially when we were aware that they had sought to move and been denied permission to move, you certainly can't say we were expecting them to move. So I guess what I resent is that we were sort of duped into proceeding with our condemnation and are now on the hook for all these fees. And he keeps talking about what a wonderful savings for taxpayers this is, but obviously we're now looking at something like $200,000 in attorney's fees, plus a claim on what he calls this sort of preemptive relocation or cost to cure he's trying to get within an eminent domain case. Well, nobody gets that. There's no law that authorizes preemptive moving before a suit is filed of real property. Certainly outside any regulatory scheme. So the grand total is this: they don't like billboard rules. So they say, well, those shouldn't apply to us. We don't like condemnation rules. So, hey, that doesn't really apply to us. I'm going to ask for something that is not really compensable under eminent domain law. And let's just hope it works out. But the totality of this is just basically SignAd doesn't like rules, and it wants to turn this into a referendum about the fairness or advisability of these rules. That is not what the eminent domain case is for, right? That we are very strictly prescribed in eminent domain as to what we're going to do. We're going to acquire real property, not personality. We are not going to deal with relocation claims, and we are not asking judges to assess the amount of relocation somebody gets. Those are done in different forums, okay? And they want to turn this eminent domain case into a referendum on the advisability and fairness of billboard rules. They were denied their permit. It's a sign that's extraordinarily close on an elevated bridge that's illuminated. The City of Sealy ordinance that they reference, the City of Sealy ordinance in 2015 actually says they don't want billboards because it's unsafe and causes driver accidents and distractions. So I'm not going to get sucked into that, but please understand that TxDOT is not behaving arbitrarily. This sign is extraordinarily close to this bridge. By some measurements, as close as 8 feet away, the elevated faces that are illuminated as people go with truck traffic on IH-10, okay? So they want to turn this into a debate about permitting, and that's improper, right?
But I'm not necessarily asserting an objection, but I am noting for the record that she's completely opened the door on the issue of permitting. I mean, that's all she's talked about for the last 5 minutes in her opening statement. So when she tries to
I
object
object to him
permitting issues
interrupting on
later,
that basis.
Yeah, just one at a time. And again, as everybody knows, openings are just point where you think the evidence will go. So Ms. Fagerberg, you can proceed.
So Judge, I think the point is this. I don't think you have the time, inclination, and frankly, even if you were to try to make determinations about permits being fair or unfair, you don't have any authority to make those. Those are within SOA. They have that debate. Let's let them go have it. But from an eminent domain perspective, what we're objecting to is the fact that we filed a petition and they sort of laid behind the log and didn't disclose that they had moved the sign. And that's really where we have the issue. I couldn't care less if they moved their sign out. If Richard Rothfelder had called me or had called Samantha Kessler Diaz and sent pictures of the demolition of the sign and said, hey, Samantha, or hey, Nicole, I've just demolished this sign. It is fully out of the right of way. Let me share some pictures and photos with you. I would have investigated that and confirmed that we didn't have to file a petition against them. But that's not at all what they did. They just kind of gave these cryptic emails. And I'm suggesting to you, I think there's actually only one in September before the special commissioners that was actually received by the state. And it's all very cryptic. It's sort of like, well, my client's not sure they're in the right of way, which is obviously sounds sort of crazy. After the whole past year, we were debating with them about their ability to get out of the right of way. So I certainly don't think that was supposed to clue anybody in. But so understand that from a legal perspective, I do not have power, and it would never be advisable for me to give money for relocations or for cures done in advance of the filing of a petition, because that is illegal and that would set a very poor precedent for any case, okay? So really what they want is they just don't want the rules to apply to them. And that's where I have the issue. And I strongly take exception to the idea that they told anybody. They didn't. And, Mr. Rothfelder says he's really outraged because there's proof in the file that we knew the sign had been altered by the end of January. Well, there is some proof of that. Now, he doesn't have his facts quite right. Greg Polashik is someone, he's not an inspector who works in permitting. As we were struggling to figure out why this injunction was there, someone went out to the property and I believe they saw the pole had been cut. There was certainly no assessment made prior to the injunction hearing that they had cleared the right-of-way line. Moreover, we had no idea who had done it, when had done it, or any of the other circumstances of it. So I hardly think that's bad faith for someone to notice an alteration before the injunction hearing. But no one's ever hid that. In fact, Judge, I became suspicious, and I believe I was informed on or about February 4th or 5th. And you can take judicial notice, Judge, that I had to file subpoenas in this case to get somebody from SignAd to come testify about what had occurred. And I wonder, had I not issued those subpoenas for the person with the most knowledge about possible alteration of the sign, between April 1st, 2018 and, you know, January 30th, would we ever have gotten that information about who did it and when? I don't know, but I think me issuing that subpoena is ultimately what led to their finally confessing what they did. And that shows another problem with their analysis. They try to argue in their brief, well, we knew we were violating the law and we didn't have the permitting we needed, but gosh, there's no way of appealing it. So we were ready to just go forward and have that fight. But that's not true. The whole reason they didn't tell me, or they didn't tell anyone at the AG's office, and they didn't tell anybody right away that they had moved it, is because they knew that right away would probably contact permitting, and then they would end up having a permitting action filed against them, right? So I think that's, to me, where the issue is. The discussion of permitting is relevant insofar as it explains something that in an ordinary case would be inexplicable, right? In an ordinary case, if you had a landowner who had an office warehouse and he demolished the front part and he didn't want you to file that condemnation, he'd be calling me off the hook and saying, Nicole, look, I demolished this. Let me show you. Let me fax you this. Let me show you all the stuff I've done to get out of the right of way. But here, because SignAd knew that what they had done was without the approval of the permitting, they didn't want to disclose that. They wanted to try to very cryptically act like there were survey problems. Gosh, our survey doesn't show what your survey shows. But of course, the reason it didn't show it is because ours were from the early part of 2017, and their survey was from October 2018 when they'd already moved the sign. So just to clarify, everything SignAd has wanted has to do with them just not wanting the rules to apply to them. And I think that for me is what's bothering me the most about this case. And I also think that on some level, if you look at the reasonability of attorney's fees, right? I mean, yes, it's mandatory to award them, but only if they're reasonable. So think about it from this perspective. What value is the client really getting out of this case once the sign is moved out of the right of way? I mean, the sign was moved out of the right of way and they could have averted my suit entirely had they simply contacted us and been open about what had occurred, right? But what's problem is because they had basically violated the permitting laws and they're at least going to have to go have that fight, right? Now, I understand they say, well, there's a settlement agreement and we think we're going to beat it, whatever. But at the end of the day, they weren't forthcoming about that. You know, I think that's a serious issue. And so that's why they didn't disclose it. And so really, you know, what value is being added to the file once the condemnation action is avoided? Couldn't the condemnation action have been entirely avoided had the client been honest and had SignAd not simply contacted me after the demolition was complete prior to the filing of the petition in October? What value is being added for all this billing that's occurred subsequent to that time? And I would submit to you that either there's no value, if the genuine issue is really to just remove your client out of the right of way, or for instance, they could have filed a motion to dismiss. I'm going to submit to you that there's evidence that they certainly considered it. Correspondence with Mr. Rothfelder continued to indicate to me for many months that he was considering his own motion to dismiss. Judge, he said in front of you during the injunction hearing, he was going to file a motion to dismiss. And he continued saying that for months after. So when he talks about, was there a delay? In part, it's because I was hoping Mr. Rothfelder was going to be filing the dismissal. And I think he could have done so much earlier and achieved what he wanted to achieve for his client, right? If the client is trying to achieve something sort of illegal by lying behind the log and not alerting permitting, well, then I would submit to you that's not a reasonable goal. That's not fair, and that's not something the Texas taxpayers should have to pay for. And if they're using this case to get discovery and permitting, as I strongly suspect the deposition of Wendy Knox was in February, again, why are the Texas taxpayers paying for a deposition of a billboard permitting supervisor when I've already dismissed the eminent domain suit, right? There was a huge amount of billing that month, and I don't think any of it was proper. So from our perspective, there's a lot about this case that's not reasonable, and the lack of reasonability is on the part of SignAd, not the state of Texas.
All right, so Mr. Rothfelder, you want to call your first witness?
Here you are. Call Richard Rothfelder.
You may proceed.
Judge, I've already been sworn. Testify as an officer for the court in a narrative fashion, if I may. Beginning with my background and qualifications, I've been licensed by the State Bar of Texas for over 40 years. The last 30 plus years, I've been board certified in civil trial law. As Ms. Beckerberg noted, we've developed something of a specialty in the representation of the billboard industry in particular, and in governmental regulation in general. I'm also a former mayor of the city of Southside Place, and I've been its city attorney for about the last 8 years. So we have a combination of business litigation expertise, as well as government regulation with niches in eminent domain and billboard representation. Chris Rothfelder is my law partner. He's been licensed for about the last 7 or 8 years. In addition to being a licensed specialist in business litigation, he's also an adjunct professor at South Texas College of Law, leading the trial tactics, advocacy, and mock trial teams, following up on the recent demise of the former dean. Judge, SignAd's attorney's fees through July 31, 2020 are evidenced in pre-admitted Exhibit 27. The first 2 pages of which are summaries of the attorney's fees by lawyer and by year. The second page is a summary for the court's convenience on a month-by-month basis, and then redacted attorney's fee invoices pre-admitted into evidence for that 2-year period, totaling $163,802. Your Honor, SignAd engaged Rothfelder and Fallick to handle this case pursuant to a standard hourly rate plus expenses. The invoices were prepared under what the courts have noted as the lodestar method. They demonstrate the particular services performed, who performed the services, when they were performed, the time required to perform the services, and the billing rate for the performance, billing rate for the lawyer who performed the services. My rate's $500. Chris Rothfelder's rate is currently $350. Some of the work was done at $300 an hour, and those rates have been stipulated, I believe, as being reasonable and necessary given our expertise in billboard law, eminent domain, and government regulation. The summaries show that through July 31, I billed 191.25 hours for a total of $95,625. Chris Rothfelder billed through July 31, 2020, $59,005, and expenses were another $11,436. The services that were rendered are detailed in the invoices attached as Exhibit 27. but they include analysis of the unique facts and law in this case. Indeed, it was a novel case. It includes the minimal aerial encroachment on the right-of-way, TxDOT's regulations for adjusting the face out of the right-of-way, the public necessity for government takings, permitting under the regulations for both Sealy and TxDOT, the history of the sign, prior settlement agreements with TxDOT, and therefore the entitlement to do the work with an adjusted permit. It involved, Your Honor, review of numerous documents, including maps, surveys, photos, construction invoices, surveys and invoices, permits, and numerous TxDOT documentation, review and preparation of pleadings, written discovery, both propounded by SignAd on TxDOT, and Ms. Fagerberg also propounded on SignAd a full set of her own written discovery in the case. Preparation for and attendance at the oral depositions of Wendy Knox and Mary O'Carroll, which took a full day in Austin, and Judge, preparation for and attendance at 4 separate oral hearings in Belleville, including the commissioner's hearing, which, as we'll explain later, wasn't necessary because the state knew prior to the commissioner's hearing that the sign was out of the right-of-way. It includes the February 2019 temporary injunction hearing that we've talked about that wasn't necessary because the state already knew that the sign was out of the right-of-way. It included the hearing that we talked about earlier where the state tried to prevent me from taking the deposition of Knox and Caro, even though they were arguing that SignAd acted in bad faith on the one hand and trying to prevent discovery to elucidate that allegation on the other. Of course, we're having our damages hearing today versus Zoom. There's lots of legal research in this case, Judge. Briefing regarding public necessity, briefing regarding the mandatory statutory reimbursement of damages, fees, and expenses. I anticipate after today's hearing, there may even be some post-briefing. Judge, there's, in addition to those fees through July 31, 2020, unbilled time that we won't send an invoice for until later this week or next week. But I've looked at those invoices and estimate that we'll have about another $20,000 during the month of August to add to the $163,000. So the total in attorney's fees that in my opinion are reasonable and necessary through this proceeding in the trial court will be $183,000. Now, Ms. Fagerberg has talked to me many times about her threats to appeal whatever your honor rules. So I believe SignAd is also entitled to conditional potential appellate attorney's fees. I've been involved likewise as a board certified civil trial lawyer in appeals and are therefore familiar with the cost of appeals both to the Court of Appeals and the Texas Supreme Court. And I estimate that the preparation and presentation of an appeal to the Texas Court of Appeals
Let me
is
object at
under
this point.
$25,000.
Let me object at this point. Judge, I don't believe there's been any testimony as to what appellate fees would be. And second, there's no case law to suggest they get appellate fees.
Well, you haven't asked any discovery in writing, and you certainly haven't taken my deposition, so you've never asked a question about any appellate attorney's fees. And the statute provides for mandatory attorney's fees, which I read that to be like any case where a litigant would be entitled to attorney's fees, including both through trial and appeal. And I have testimony to offer that, to put it in the record, Your Honor.
Okay.
Well-
Objections overruled. You may proceed.
So my opinion that appellate attorney's fees through the Court of Appeals is another $25,000. In the event of appeals to the Texas Supreme Court, in the event a petition for review is filed, but it is not granted by the Texas Supreme Court, a reasonable and necessary attorney's fee is $15,000. In the event that the petition for review is granted by the Texas Supreme Court, a reasonable and necessary attorney's fee of another $10,000, in my opinion. Now, Judge, you've already alluded to the factors under the Anderson case and under Rule 1.04B of the Texas Disciplinary Rules of Professional Conduct as guiding, Your Honor, as guiding the finder of fact on the reasonableness and necessity of attorney's fees. I'm looking at those 8 factors, and it looked like, again, factors 2, 3, 6, 7, and 8 have been stipulated to. So let me focus on, first of all, I think TxDOT's dispute over the time and labor required. First of all, I want to point out, Judge, that there was no duplication of effort between Chris Rothfelder and Richard Rothfelder. And indeed, the fees were saved for the client on this file, like we always do when we properly delegate. I assigned to Chris Rothfelder tasks that were appropriate for him to handle at his lower hourly rate, commensurate with the complexity of the work. As such, we avoided duplication of effort and saved attorney's fees. But more importantly, Judge, most of the time and effort that we incurred in rendering $183,000 in attorney's fees were forced by TxDOT and its attorneys in this case. Again, Ms. Fagerberg rails in her opening statement that we could have picked up the phone and called her. Well, she could have picked up the phone and asked us. The fact of the matter is we provided evidence to her predecessor and to her that the sign was not in the right-of-way, yet they proceeded. As early as March 29, 2017, TxDOT knew that a proposed plan for shifting the face out of the right-of-way was a good idea. Judge, I refer you to Exhibit 33. I think I might have mentioned this in my opening statement. But we see before they even send an offer to TxDOT that they're talking internally, as you can see, Judge, in that March 29, 2017 letter, where they say the proposed plan and an option would be to shift the billboard over if the railroad agrees. Well, just some 9 months later in January 2018, we see that they're talking about doing that very thing. They're coordinating on the proposed plan that would be good for the taxpayers. And you can see in Exhibit 10, already pre-admitted, Judge, emails between Dan Creel of SignAd, Wendy Knox of TxDOT, Warren Escavi of Sealy about this very plan, where Sealy has given the permit. On January 25, we see that Dan Creel is telling all involved that we're simply moving a part of the sign face out of the new right-of-way. Page 2 of Exhibit 10 elicits a responsive email from Wendy Knox on January 25, where she says, Dan, I'm incorrect in my response to you earlier on the phone as I was not looking at my regulations and apologize for my error. To be accurate, I've provided the regulation that does stipulate that in the instance where you are going to leave the sign structure in place and adjust the sign face to cure the encroachment, you'll have to meet the 5-foot setback. And later, just a few minutes later, we see above that on page 2 that Dan Creel says, thanks for the follow-up. That's exactly what we had intended to do. Now, TxDOT knew this was a plan. They had it themselves as early as March 29, 2017, and it was a good plan, and SignAd followed up on it. And indeed, Exhibit 14, is that stipulated as pre-admission?
No.
Okay. Judge, I'm going to offer Exhibit 14. That's an email that was actually, excuse me, Exhibit 14 is the February 7, 2018 letter written by Chris Rothfelder, my law partner under my supervision, to TxDOT. TxDOT's received it, admitted their receipt, laying out the reasons that this plan to shift the face out of the right-of-way is good for the taxpayers, and it's legally permitted under the proper application of the regulations and a 2011 settlement agreement that the parties had previously entered into. I offer into evidence Exhibit 14, Judge.
Ms. Fagerberg?
Judge, I object. It's obviously hearsay and it's just argument. There's no basis to admit this.
It goes to the reasonable necessity of the attorney's fees because TxDOT knew by this heads up letter exactly what SignAd had intended to do and why they were entitled to do it, Judge.
Judge, I disagree. It's just an argument for them that's self-serving hearsay statement. There's no exception to get that into the record.
All right, so objections overruled and Exhibit 14 is admitted.
And as part of this process, the emails that are already pre-admitted, Exhibit 10 made reference to the fact that SignAd knew that Sealy was going to require the issuance of a permit to make sure that the work was going to be done safe and securely and pursuant to engineered standards. And the Sealy permit was attached to that Dan Creel email that we referred to earlier. Exhibit number 10. And it was referenced in, excuse me, the Warren Muscovy email dated January 25, the fourth page where I referenced Sealy's representative is telling TxDOT in this January 25, 2018 email, the sign as it currently sits would not be in compliance with today's ordinance as the height that is allowed is 45 feet tall with a possible additional 5 feet add and 250 square feet in size with the possibility of making it 300. We did discuss that and the Planning Commission and ultimately City Council could grant them a variance to allow them to move the sign. And ultimately they did. And the permit issued by Sealy to do this work that was provided to TxDOT is Exhibit 13. Judge, I don't think that was pre-admitted. You can see in your hard copy the City of Sealy permit issued on January 24, 2018, which we offer into evidence.
And Judge, I object as to the relevance of that. As we've stated, there's no basis to get any type of, removing something out of the right of way in advance of a petition is not a compensable interest.
Judge, she opened up the door. She mentioned the Sealy sign code in her opening statement. She talked about what she said Sealy had in their sign ordinance about safety concerns. I think there probably is something in their preamble about safety concerns, but as she's made it a relevant issue, Exhibit 13 shows that Sealy looked at the permission requested by SignAd and granted the permission in Exhibit 13 to do this work. And as I'll show in further exhibits, that permit was actually issued to TxDOT so they knew that the work could be done in a safe, secure manner, despite what Ms. Fagerberg said in her opening statement.
Yep.
Go ahead, Ms. Fagerberg.
Yeah, Judge, it's a non-compensable interest. I mean, they're trying to put in building permits that were achieved back in early 2018, or actually earlier than that. I think there were multiple permits on different dates, but all of this was done well in advance of any filing of a petition. I don't understand why we're looking at this when when in my opinion, it's not a compensable interest.
All right, so objections overruled and Exhibit 13 is admitted.
In addition to securing the permit from the city of Sealy to do the work, SignAd also submitted an application to TxDOT to adjust the face to move it over some 9 feet, I guess, to clear the actual right-of-way, and then an extra 5 feet for a setback. And they did so by application to amend the permit dated March 29, 2018, and that is pre-admitted as Exhibit 25, where the judge has noted on page 1 of Exhibit 25 that the date on the transmittal letter of Dan Creel is incorrect, where it says September 11, 2017. The record reflects, and the parties agree by contrast, that the letter was actually transmitted on the same date as the permit that's attached, namely March 29, 2018. And, Judge, in looking at this pre-admitted exhibit, we see in the first paragraph that SignAd's application for the amended permit is referenced in the first paragraph. And in the second paragraph, Mr. Creel is also telling Ms. Knox, who we'll hear about later today, enclosing the City of Sealy building permit, allowing the shifting of the sign face over the necessary 7 feet to clear the widened I-10 overpass as well. So the evidence is going to then show that TxDOT denied the permit application. We won't belabor the point now, but in SOA, we will show that the denial of the permit application was wrong. A proper application of a 2011 settlement agreement and a proper application of sections 21.191 and 21.192 of TxDOT's regulations allow this sign to be shifted in order to eliminate a condemnation case. TxDOT did that in August of 2018. And yes, they did it after the denial of that permit application. But the work that they did in order to salvage what Mr. Gilbert is going to testify is a $750,000 asset, justifies the attorney's fees that they incurred in this case. As TxDOT would not afford any further opportunities for judicial appeal, and they therefore had to either go forward and fight it in SOA like they're doing now, or they lose that sign and they lose it forever. Now, when the sign was adjusted out of the right-of-way by August of 2018, Chris Rothfelder proceeded to advise the state's attorney at the time, this is before Ms. Fagerberg was engaged on the file, that there was no need to file an eminent domain petition in the case because the sign no longer overhung the right-of-way and was completely moved out of the right-of-way as well as the 5-foot setback. Specifically, Exhibit 18, now was that pre-admitted or not? I know we went back and forth on the...
It was admitted after the agreement was to admit the transcript of the injunction.
Okay. Exhibit 18 is a survey that was provided to Samantha Diaz. Exhibit 19 is the email transmission, and I think page 2 of Exhibit 19, the September 11, 2018 email was stipulated as admissible.
I do not
and-
believe, do not show that 19 was agreed to. So
Okay.
before you can refer to anything, we'll either get it admitted or not.
Yeah. So Judge, Exhibit 19 is an exchange of emails dated September 11, 2018, September 12, 2018, and October 11, 2018, an email chain between my partner, Chris Rothfelder. I was blind carbon copied on these. The client was blind carbon copied on these. And there was a joint effort by all at SignAd and my law firm to communicate to the state's lawyer that the sign had been removed out of the right of way. That's the relevance of Exhibit 19, and I hereby offer it into evidence.
And before I hear from Ms. Fagerberg, are you saying that the emails were internal in your law firm that you wanted to show the state something, or was the state included on some of these emails?
No, they were all between the state and Chris Rothfelder of my law firm. I'm authenticating them because I know that they are true, correct, authentic, as I was provided copies contemporaneously with the transmittal.
All right, so Ms. Fagerberg?
So Judge, I have no problem stipulating to the September email to Ms. Diaz. In fact, we have our own copy we could provide that doesn't have the October part. The problem with admitting the one on October, and let me just say, I'm in no way doubting that Chris Rothfelder sent it. I am in no way accusing anyone of forgery, but it appears to me that we never received it because the survey was too large. And we can go over the size of that survey, but it does not appear to me that Ms. Diaz ever received it. So I don't want there to be anything misleading in the record about the notion that the state received it, because I don't believe that we did receive the October one in closing that survey.
All right, well, then first of all, the September email, is that September 11th?
Correct, Your Honor.
So the September 11th portion of Exhibit 19 is admitted. And so Mr. Rothfelder, without a connection to the state, what's going to be the relevance, or how are you going to show the October email?
Well, Chris Rothfelder is going to testify that he sent that. He never got a bounce back that has been alleged. By the way, in a hearsay manner by Ms. Fagerberg, we don't have the actual recipient, her predecessor, Samantha Diaz, coming in here and swearing that she didn't get it. And any inference to that will be rebutted by Chris Rothfelder if it becomes necessary, as he attended the special commissioner's hearing, had the survey with him, and provided it again to Samantha Diaz, who didn't complain that a prior email, which was attempted to be submitted to her on October 11, bounced back and that she never received it. The special commissioner's hearing transcript will belie that implication made by hearsay through Ms. Fagerberg.
Judge, all I can represent to you is that I've scoured our files and we do not appear to have it. I asked Chris Rothfelder if he could confirm if Ms. Diaz ever answered him or if there was any confirmation of receipt, any kind of tracking, and they're not able to locate that. And so I don't want it to come in looking as though the state was on notice if in fact no one ever received it on our end. And I do stipulate he tried to offer it at the special commissioner's hearing. And I'll also stipulate to you, the survey that was enclosed, according to their document production, is a massive survey. It shows up as a 36-inch by 24-inch survey with a lot of embedded documentation and stuff, and we can go over that. But I think it's very reasonable under the circumstances to believe that it did bounce because of the size of the document involved.
All
The
right, well,
survey is already in evidence as Exhibit 19.
I understand that, but you're alleging that the state was on notice, and so that's something different. The fact that you had a survey done and it was presented at the injunction hearing, that much is fine. The notion, though, that the state was on notice and received that is the problematic point.
And the-
since the issue with the October email is noticed, the objection will be sustained as far as the October email, but the September email is admitted.
The September 11 email from Chris Rothfeller to the council for the state, as you can see on page 2 of exhibit number 19, provides to Samantha, the client indicates the sign will not overhang the state's proposed acquisition area. SignAd's in the process of retaining a surveyor to confirm that the sign will not encroach into the acquisition area identified in the survey attached to the state's last offer letter. We should have some more information from the surveyor by the end of next week, and I will pass along any documentation received. Assuming the survey confirms that the sign is not going to be within the proposed acquisition area, there should be no need for SignAd to be named as a party to any eminent domain litigation. Now,
I'm sorry, which, are we on 19 right now?
yes, we are.
Which page?
That's page 2 of exhibit 19 that I read from, Judge. You have the hard copy in front of you?
Yes, I do have the hard copy in front of me.
Okay, I'm sorry, Richard, I lost my place.
And then I don't think there's any objection to the September 12 follow-up email that Chris Rothfeller sends Samantha, where he says the client surveyor has indicated that he'll have a survey completed by the end of the month. If the survey confirms that the sign is outside of the state's acquisition area, then SignAd intends to dismiss the case and seek reimbursement of its fees and expenses pursuant to section 21.019 of the property code. So, Judge, that email shows that prior to the state's filing of the petition in the case, just those 2 emails that are admitted in Exhibit 19 shows that TxDOT was informed, yet they went ahead and filed the petition in the case, thereby making it reasonable and necessary for Chris Rothfelder to then attend the special commissioner's hearing that was followed up and scheduled by the state on December 20, 2018. And Your Honor was already looking at the special commissioner's hearing transcript, and I believe on that transcript between pages 17 and 21, there's a discussion between Chris Rothfelder and the commissioners where he has the survey that now confirms that the sign is indeed out of the right-of-way. And he's telling the commissioners that there's no need to go forward with the commissioner's hearing and even the condemnation case in general. Again, that survey that was part of that commissioner's hearing is Exhibit 18, already pre-admitted, and shows the sign does not encroach on the right-of-way. The commissioners went forward. They awarded $118,000, which has not been deposited. Now, the next thing that made it reasonable and necessary, because the state required us to do it, is we had to go to a temporary injunction hearing. And the important part of this, Judge, is when we take a look at exhibits 42. 42, 43, and 44 pre-admitted into evidence. Shows that the state knew before we had to come to Belleville, which, Judge, we love Belleville. We love coming up there to see you. I like going to that restaurant right down the street before and after the hearings. But it cost attorney's fees, and they were made reasonable and necessary because Ms. Fagerberg made us go to a temporary injunction hearing designed to preserve the status quo and prevent the removal of the sign, when her client knew from January 23, 2019, that the sign didn't encroach on the right of way. And
Objection. I don't think the evidence indicates that.
well, we'll ask Ms. Knox about that later.
Well, let's just be clear that a survey had been apparently
I'm
provided.
testifying now,
Okay, but well, then I object to your
and I'll put
characterization
you
of the
on.
evidence.
You'll get an opportunity to testify in a little bit.
All right, so we'll hear that testimony from Ms. Knox.
All right. But Judge, as you can see in exhibit number 42, these are pre-admitted. Wendy Knox is the recipient of an email from Ross Sherrard dated February 5, 2019. And he says, here's my full report. I thought I would just send it to all of you. I thought I would just send all to you and see if you wanted to look it over. That way we can put it in more or take out some if need be. Thank you for your help on this one. Please let me know if you see any way it can be better. And then we see on page 2 of this exhibit 42, the field inspection log by Inspector Ross Sherrard dated January 30, 2019. And we can see that on the 3rd page, he now confirms that the sign has been moved. Excuse me, page 2, the sign has been altered down at the, I'm sorry, Judge, this is page 3 of exhibit 42, page 2 of his inspection report. The sign's been altered. One of the original sign poles is absent, and the sign head is in a different location than previous inspections. The interesting point, Judge, is in that inspection report, we see this same acknowledgement about the same alteration of the sign. The poles are, one pole's absent, the head's been moved over on page 2. But if we look at exhibit 43, we see that on page 3 of Inspector Sherrard's report, he's added a paragraph that didn't appear in the original page of his report attached to exhibit 42. He's now added, it was found by the inspector that the existing sign could pose some safety concerns and may also be a distraction for drivers. It may also cause some hazards when maintenance needs to be done to either sign or the roadway. But that's not all, Judge. We now see in exhibit 44, yet a 3rd iteration of Inspector Sherrard's field inspection report. Again, it's the same point that needs to be made for relevance on the 2nd page of all 3 reports. He acknowledged the sign has been altered by removing the pole that was too close to the right of way and shifting the head over. But on page 3, he's added yet an extra complaint at the very bottom. That paragraph that begins, upon further inspection, the sign configuration was found to be 226 feet by, et cetera. The point being, Judge, we've got an email from the inspector to his boss dated February 5, 2019, where he says, I thought I would just send it to you and see if you wanted to look it over. That way we can put in more or take out some if need be. Please let me know and see if it can be done any better. And there were different ways that they thought it could be done better, but the final document was Exhibit 42 after they've doctored it up 3 times. And the bottom line is they knew by at least January 30, 2019, that the sign was out of the right of way and didn't encroach. And I thought it was interesting because I had to write this down because I almost didn't believe that she would admit it. But Ms. Fagerberg said in her opening statement that she knew by February 4th or 5th herself that the sign had been adjusted and was no longer impacting the right of way. And in
Objection,
fact,
Your Honor. Objection, Your Honor. That's a misstatement.
well, the
And I would
record
also
will
object-
reflect what it says, but I believe that you know there was no encroachment on the right of way a couple of weeks prior to the temporary injunction hearing. And in fact, I want to now refer to the state's own Exhibit 51, I believe it is, where before that injunction hearing, Chris Rothfelder is now corresponding with Ms. Fagerberg. Yeah, and it's dated February 5, 2019. And he concludes by saying, please let me know if the state has an actual survey showing the exact dimensions of the expanded highway and the points at which the sign will be bisected. If the state has a survey showing where the sign will be bisected, then we might be able to save ourselves a trip to Sealy for a hearing. If there's a question about whether the sign will in fact be bisected by the expanded highway, then it should be a simple factual inquiry that we should be able to resolve without the expense of a hearing and likely appeals. Well, that didn't happen. Instead, Ms. Fagerberg said in her opening statement that while she knew by that time the sign indeed did not encroach on the right-of-way, she made a special point of issuing subpoenas for SignAd's witnesses to attend the temporary injunction hearing so we could all go to Belleville for a full day of hearing on the temporary injunction, when her purpose of subpoenaing witnesses and eliciting testimony, she said, was to confirm who and when the sign was moved out of the right-of-way. She knew it had been done, and I would submit, since she says the permitting issue is irrelevant here, well, who and when moved that encroachment onto the right-of-way is irrelevant as well. Indeed, her only relevance for making us go to that temporary injunction hearing was she wanted to make a record to show that SignAd went ahead and eliminated the encroachment on the right-of-way, causing the lack of necessity to go forward on the injunction hearing, so she could show that there was a permit violation and give ammunition for the state's case in SOA. And sure enough, that's what she elicited from Dan Creel at that testimony that you'll remember was back on February 14, 2019, some 2 weeks after she knew the sign was out of the right-of-way, some 3 weeks after her client knew the sign was out of the right-of-way, thereby making it reasonable and necessary for our law firm to attend the temporary injunction hearing and secure the order from the court preventing the state from removing the sign. Otherwise, they could have just stipulated before, like Chris asked her to do in that email sent on February 5. Well, it became reasonable and necessary to incur more attorney's fees, Judge, because after that order was entered, maintaining the status quo for a couple of weeks, i.e. a temporary restraining order preventing the state from removing the sign, we approached Ms. Fagerberg and attempted to settle a case just for our costs. And that's exhibit number 23, already pre-admitted. I'd like to refer you, Judge, to Exhibit 23. That's the April 1 and 2 email exchange that Ms. Fagerberg and I had about this case. And I'd offered originally on April 1, $50,000 to cover our cost of relocating the sign out of the right of way. And I went to quite a bit of effort in explaining why we were entitled to do that, why it was legal to do it, and why this is a good deal, equitable for the taxpayers, fair enough for SignAd at
Judge,
that point.
I'm gonna object. Listen, the reality is, I understand he thinks things are a good deal in terms of his settlement, but that's not relevant to any of the proceedings.
I'll withdraw that, Judge. What I want to do is refer the court's attention to the pre-admitted April 2, 2019 email at the top of page 23, where Ms. Fagerberg responds to Richard and Chris to our settlement offer, whether it was fair and a good deal or not. Her comment was, "I've conveyed your offer to my client. They're not interested in negotiating on any of the permit issues, and we don't intend to pay any money to SignAd in this case for the sign or its removal, given your client's intentional and, in our view, bad faith removal of the sign outside of the projected right-of-way or in dismissal fees." So, Judge, it became reasonable and it became necessary in the face of a definitive and, in my view, arrogant rebuffal of any attempt to compromise early on in the case. Early on, before we incurred attorney's fees and were asking for any and just asking to be reimbursed for the cost of eliminating the encroachment. And we get this definitive and repeated, by the way, every time we ask subsequent to there, that there's not going to be any negotiation. So it became reasonable and necessary for SignAd to try to seek those costs incurred in accommodating the highway improvement project and eliminating the encroachment on it by preparing for trial and seeking to recover those as damages at the trial. And in doing so, you'll remember, Your Honor, that I filed a deposition notice for their appraiser and for their designated representative, Wendy Knox. I did so in December 2019, asking for their depositions to prepare for a trial that was at that time set in April 2020. And that prompted Ms. Fagerberg to file a motion for protective order to try to prevent me from taking those depositions. So, Judge, it became reasonable and it became necessary because of Ms. Fagerberg's objection and motion for protective order for me to come to Belleville and argue in support of my entitlement to take the discovery. I don't need to belabor the point, but Your Honor will remember the argument and remember that he overturned the objections and denied the motion for protective order and allowed me to take the depositions of Ms. Knox and Mr. Caro in Austin. I must say the judge will also remember that that was a difficult deposition, despite Your Honor's instructions that I could take that deposition. And despite the usual rules for deposition under our Texas rules of discovery.
Objection, Your Honor.
Yeah, the objection is sustained. And I tell you what we're gonna do is let's break for lunch now. We'll come back and continue with Mr. Rothfelder's testimony. Let's try to resume about 1:30. And
Thank you, Your Honor.
Do I even
Yeah, there you go.
mute anything? I won't touch anything until you tell me what to do.
Yeah, if somebody wants to sit there through an hour or so of nothing, did something just go ding?
People are
Oh, the getting off.
getting off.
Well,
Now I'm still,
actually, no, I don't want to mess it up. Yeah, let's just do that because I think you can end it and then just restart it, but let's just not do that. Oh, dang, my arms are falling off.
you can put them back on.
I mean, riding with my toes.
Oh, I know one thing. Just for the heck of it. Snap of the light switches. Shows how vain I am. Okay, let's see here. Turn on just one at a time.
Say that one more time.
Just turn off
Turn them off one at a time.
one at a time. See if it, okay, that makes no difference. That makes no difference. Okay, so turn those other two. Now, what I want to do, yeah, just, okay, let's turn this one all back on. Turn everything on. Okay, so those first two made no difference, so just leave them on.
Okay.
Now, what's the next one? Okay, turn that one back on a minute. Now turn the other one. Yeah, of course, what was the one you just before that?
The one before that?
Does that make any difference to you if that one is off?
Oh, it don't make any difference to me. No. If you prefer it that way, that's fine with me.
Or I'll just, you know,
Because you don't have a glare.
there, the trouble is this one hits me
Yes.
on this side.
Yeah,
That one hits me on this side, but
yeah.
I think this one is a little bit less harsh. You know, that if,
The way you have it now seems less harsh than the other way.
right, so I think let's just leave it.
See, because that's like more, well, hold on. No, I've got it, hold on.
So I think,
To me, that's better.
why don't we leave it like you have it right now?
Yeah. Please leave it. Okay. I'll be back.
Vanity's a terrible thing.
But not so terrible. No one used to be. Today's date, August 31st, 2020, court PM bench, Zoom meeting. Are you about to, ready to get on there?
Just about.
Okay. I'm just gonna run and get some more water real quick. Just real quick.
I have a quick question. This is Wendy. I have a small fan on. Is it making extra background noise or anything?
I don't hear anything
Okay, good. Thank you.
while we're, just for my own curiosity, on the
Oh.
next to the shelf, looks like you got a medal with a red ribbon
Oh.
around your other shoulder.
Oh, the other side. Yes, sir. I show dogs, and so some of the shows I'm at, they give those to the veteran dogs that you show. So,
All right.
She specializes in labs,
yes.
and my sons have two, a white lab and a black lab.
They are my sanity. This stuff is too much fun.
Hey, Judge, I saw you looked like you had some other matters on Zoom. Are you now handling all of your docket via Zoom?
No, but I mean, we've done things by Zoom, but especially probate cases, uncontested divorces. If people want to do it by Zoom, I do it. But if they want to, sometimes the attorneys like to leave their office and walk across the street and prove them up.
I hear you. We're doing everything in Harris County by Zoom.
Okay. Yeah, no, we have a mix out here. All right, so is everybody back who needs to be here? All right, well then we'll come back to order on the State of Texas versus SignAd Limited. And Mr. Rothfelder, you may proceed.
Thank you, Your Honor. Before the break, I was reciting on factor number 1 of the Arthur Anderson versus Perry equipment factors, those that are incorporated under Rule 1.04B, namely the time and labor required, and why, in my opinion, it was reasonable and necessary, in part given the behavior of TxDOT. Now I move to the next factor that I believe is not stipulated. That's the novelty and the difficulty of the questions involved. Judge, this one really is, I think, an interesting and novel case. Number one, it involves billboards. There's special law in the state of billboards, as Ms. Fagerberg will tell you. There's a Texas Supreme Court decision decided in 2015 called Clear Channel versus State of Texas. That was my case, by the way, that held that billboards were real property instead of personal property. And that case discussed the compensability of billboards in eminent domain. But then in addition, this case involves the constitutional requirement for the necessity when TxDOT initiates a condemnation case, the public necessity requirement and the right to seek injunctive relief when it doesn't exist. And then thirdly, we have this application of Rule 21.095C of the Property Code. And Ms. Fagerberg and I can both tell you there's just not that many cases under it. It's a relatively novel statute, all which led to the reasonableness and necessity of attorney's fees. The next factor that I don't believe was stipulated to was the skill required to perform the legal services properly. We have a niche in billboard regulation, constitutional law, condemnation. We've been doing that for almost 4 decades. So we certainly have the skill to handle this novel type of complex litigation. Really, you'd have to probably go to a bigger firm to get someone that could have the same expertise in handling this type of case. And the bigger firms are going to charge much higher rates than the $500 that I charge and the $350 an hour that Chris Rothfelder charges to do the same type of services. Preclusion of other employment was the next factor, and the briefing, the research, the court appearances, the depositions, the written discovery propounded and responded to, Judge. All of that took between Chris Rothfelder and I 400 hours, certainly precluding other work. The amount involved and results obtained. I've alluded to this probably in opening statement, but I'll testify to it now, Judge. It's my opinion that the $232,000 that SignAd ended up having to pay in attorney's fees certainly justifies the amount obtained and results sought in this case. SignAd sought to salvage the sign and avoid its removal. It sought that because it thought that it was applying the regulations in a 2011 settlement agreement properly, that it had permission to salvage the sign and avoid the condemnation case. If it had not been able to do that, if the public necessity had not been eliminated and Your Honor had not granted the order eliminating the removal of the sign by TxDOT, that sign would have been gone and gone forever, because Sealy, as Ms. Fagerberg pointed out, prohibits new signs. It could not have been built elsewhere in Sealy. And as Mr. Gilbreth will testify, to recoup the advertising revenue that sign enjoys for SignAd of $50,000 to $60,000 a year, he would have to go out onto the market and buy another sign.
Your Honor, I have to object.
$750,000. Right, Ms.
Judge,
Fagerberg?
I need to object, Your Honor. As they stipulate in their own brief, any calculation of advertising revenue, the valuation of a sign based on advertising revenue is improper. And they state that in their own briefing.
Oh,
so
glad you brought that up. If I may respond, Your Honor.
You may.
Ms. Fagerberg, I'm sure is familiar with the case that I just mentioned, that 2015 Texas Supreme Court decision in the Clear Channel versus State of Texas case, which indeed held that in the eminent domain context, billboards must be valued as real property under the cost approach, which is why there was an offer of 110, a commissioner's award of 118. Mr. Gilbert's going to testify that in his 40 years in the business, that the depreciated cost of that billboard, in his opinion, would be about 150. But what I'm explaining,
Your Honor,
to you, Judge,
I'll object to that coming in. That's not been disclosed.
Okay. And since we're here to talk about expenses and damages, not the condemnation award, the objection will be sustained.
yes. And my point, Judge, is we're talking about the reasonableness of attorney's fees, in this case, $232,000, because SignAd, outside of the condemnation context, when it removes the sign, eliminates the eminent domain case, it salvages the billboard. And in order for it to recoup that billboard on the open market, the testimony will be that it would take $750,000 to buy a similar
Objection, Your
sign,
Honor.
Objection sustained.
thereby making it. And the witness, Mr. Gilbreth, will testify that he was certainly anxious to spend the attorney's fees in order to salvage the sign, which he valued in that fashion, Judge. Now, I think I've hit all of the factors, but to reiterate, Judge, we've provided evidence in Exhibit 27 through the redacted attorney's fees and the summaries thereof of $163,800, and it's my opinion another $20,000 will be incurred through this month and any post-hearing briefing for a total of $183,800. Appellate conditional attorney's fees, Your Honor, of another $20,000, $25,000,
Your Honor,
excuse me, for
we'll
the
get-
Court of Appeals.
Judge, I'll again object to that because appellate fees aren't compensable and those haven't been produced.
Okay, objections overruled.
Conditional attorney's fees through the Court of Appeals, in my opinion, are reasonable and necessary in the amount of $25,000. And in the event of an appeal to the Texas Supreme Court, Judge, it's reasonable and necessary for a $15,000 fee if the Texas Supreme Court refuses to grant the petition for review, and another $10,000 if it grants it. And on that basis, Your Honor, I pass the witness.
And just since you ended your testimony talking about the factors, there's two, and I realize not all the factors have to be testified to, but was there going to be any testimony about the undesirability of the case? I'm not quite sure what that one means, but I like that one.
I think that probably means battle duty, doesn't it, Judge? That's the way I've always used it. That undesirability of the case, I think, is under the Johnson factors as opposed to under Rule 1.04B of the Texas Rules of Disciplinary Conduct. But I will tell you, I think that the novelty and the difficulty probably overlaps with the undesirability. I mean, to her credit, Ms. Fairgard said it, we like litigation and this kind of case, but it's challenging. So I believe that it warrants the $500 and the $350 hourly rates that are being charged and have been paid by the client.
All right, and then did you want to say anything about awards in similar cases?
Well, and that probably overlaps with factor 4 of the Arthur Anderson and the rules of disciplinary conduct, namely the amount involved in the results obtained. The client, as Your Honor has noted, has achieved its primary objective by our presentation of the constitutional arguments that there is no public necessity for the prosecution of a case in eminent domain. The sign has been salvaged. So the primary objective, the result has been obtained. In terms of amounts, because of the novelty of the statute that we're looking at, I can't really compare what sort of, and I don't think that that probably pertains to a case like this, frankly, Judge. I think that that factor usually deals with like a breach of a contract case, which provides for attorney's fees by contract or statute, and the party's already won the breach of the contract, and now he's seeking to recover attorney's fees on top of it. I guess from the perspective that you could say that SignAd has won by salvaging the sign and keeping it instead of needing to go out and buy something to duplicate it. We've won that aspect and have already testified about the reasonableness of the attorney's fees in relation to that objective that they have achieved.
All right, so Ms. Fagerberg, you may proceed.
Thanks. Let's start off with just a sort of a few clarification questions, Mr. Rothfelder. You indicated that when Chris sends an email, you're typically blind copied. Is it fair to say that you know what Chris Rothfelder is doing and has your approval to do it, and nothing he does is unauthorized by Rothfelder and Fallick?
I'd say that's fair.
Okay, so his actions are your actions, and if there's something he did, it's you have personal knowledge, and I can cross-examine you about something involving Chris Rothfelder.
Well, I mean, I don't want to go too far, but in answer to your first question, I have general knowledge about what he's doing and that he's authorized to do it.
Okay, well, we'll go from there, and I guess we'll see if we need to call Chris. Let's talk about the way you keep your billing. I've noticed that your billing in this case, as exhibited on Exhibit 27, it's called the Sealy relocation in the upper left-hand corner. Is that accurate?
We usually just call it the Sealy case.
Okay, but Sealy relocation is repeated multiple times throughout your billing, correct?
But it's written on that, on the bills, yeah.
Okay, and so when is that name given?
The Sealy relocation, or are you asking in general, what is the practice of our law firm about calling a new matter, a particular matter name?
Yes, when do you come up with that name?
When the matter is initiated.
Okay, so when the matter was initiated, which was roughly February 2018, the name was Sealy relocation.
Yes.
Let me ask this. Are you billing separately on the State Office of Administrative Hearings case? In other words, what we've sometimes called SOAH, S-O-A-H. Is your billing separate on that matter, or do you combine it with the eminent domain case?
It's definitely separate.
It's definitely separate. You agree it would be a violation if it were not separate?
I don't know about a violation, but I'm telling you that it is separate.
Okay.
So we'll need to reach whether it's a violation or not.
Let's talk about, obviously, would you agree there were extensive communications between February 2008 when you got involved, SignAd and TxDOT, both in terms of right-of-way division, permitting, and even the Attorney General's office during the course of that year after February?
Well, I mean, I can't characterize it. The amount of the communications are reflected in the invoices. And they certainly involved a lot of communication with your office.
And you became aware of Samantha Kessler Diaz's presence in the case in about April of 2018?
I don't recall. Chris was responsible for most of that communication, especially with Samantha Diaz. You have a document that'll refresh my recollection?
I do. If we're in Exhibit 27, and Judge, do you have a physical copy you can look at, or should we go on Zoom?
And I read 27 of the states or SignAd?
SignAds, the one that they've already admitted of their exhibits. The Bates number is 001891 at the bottom right hand, and I'll represent to you that's an April 2018 billing period.
Right, I have that in front of me.
Okay. Mr. Rothfelder, do you also have that in front of you?
Yes.
On or about 4/13/18, it appears to me that there's a telephone conference with State's Attorney regarding TxDOT's consideration of a proposal. That's Ms. Diaz, is it not?
What date?
04/13/2018. It's the Bates number 001891 in the lower right-hand corner.
What was the date of the?
April 13th, 2018.
Yes. Okay. What's the question?
That's when Ms. Diaz became involved in the case, or you began having a contact at the Attorney General's office.
Yes, it states on that date. Well, I don't know if that was when it began, but there's a reference, a total of half of an hour on that date. And there's several services, one of which is telephone conference with State's Attorney regarding TxDOT's consideration of proposal to adjust sign out of right of way by Chris Rothfelder.
Okay, and let's talk a little bit about the move itself, which occurred in August of 2018. Were you aware of the move in advance?
I knew they were going to do it.
Okay. Even if they didn't have permission from TxDOT's permitting department?
Objection irrelevant by your claim that permitting is not relevant in this case.
Objections overruled.
I knew that they were going to do it without a permit.
Okay. Approximately when did you become aware of that?
When they commenced the work.
In August?
They actually commenced the work in July.
Okay. Their appeal of not getting to have the amended permit, that occurred on July 25th of 2018?
Yes.
And so upon receipt of that letter, they commenced the work, and I believe that is your SignAd's Exhibit 17, the letter from M. Williams.
Exhibit 17 is the letter from Mr. Williams confirming TxDOT's denial of the amended permit application. And it's
Correct.
dated July 25, 2018.
And was that the trigger to begin the moving the signboard at that time?
Thereafter, and I don't know the dates, SignAd commenced the adjustment of the sign.
And why did you indicated in your briefing that in fact SignAd would welcome the ability to go fight this out with TxDOT, correct? You claim there's no appeal mechanism, so you all were well aware it would just end up going to the administrative courts and that was fine with you? Is that an accurate characterization of it?
No.
Okay, what's an accurate characterization of the situation with respect to that?
What's your question?
My question is, when you state in the briefing there wasn't any appeal, and it seemed to me you're indicating in your briefing that you would welcome the opportunity to simply go argue about this in administrative courts. Is that an accurate statement, or am I misconstruing your briefing?
Well, I guess I don't make the decision on behalf of the client. The client made the decisions here. And if you're asking me what my client told me or what I told the client in connection with how to proceed after it received Mr. Williams' letter, I object on the basis of attorney-client privilege.
That objection be sustained.
Did you attempt to alert TxDOT permitting that SignAd had, or did anyone from SignAd literally alert TxDOT permitting, right-of-way division, or the attorney generals by stating that you had in fact moved the sign and shown, for instance, some of the pictures that you've admitted as an exhibit?
The correspondence that I discussed earlier between Chris Rothfelder and Samantha Diaz, I think was the first notice to TxDOT that the sign had been moved out of the right-of-way. I think that was dated September 11.
And Mr. Rothfelder,
that was what, exhibit number 19, I believe.
Well, and Mr. Rothfelder, you agree that that doesn't actually state that the sign's been moved, fair? I mean, it doesn't state that you all moved the sign, correct?
It says what it says. I guess you can take a look at it and read it to the judge if you want.
Why don't we do that?
What it says is there's no public necessity because the sign is not encroaching on the right-of-way. According to you, it doesn't matter who did it or why they did it because you don't want to get into the permitting issues. According to you, the only issue is whether it was in the right-of-way or not.
Mr. Rothfelder, did you or did you not tell TxDOT that SignAd had moved the sign affirmatively?
No. Didn't say who did it, just that it had been done.
Well, can you show me where in that document it shows that it has been done by SignAd?
The letter speaks, or the email speaks for itself. No, it doesn't mention SignAd having done it.
All right. And Mr. Rothfelder, because we have an issue with one of your exhibits that has that September correspondence in it, maybe it would be best if I attempt to admit what I will stipulate as being the last correspondence that I have on this matter. So I'm going to attempt to do something a little bit dangerous and share my screen here, but we'll give it a shot here. Let's see where the share the screen button is. Okay. Oh, the host has disabled participant screen sharing. That's not going to work. Let's see here. I could maybe.
Well, those last two emails are already admitted. The judge granted them when I offered them.
Well, but I think they're in with an October email that's not admissible. So I was going to do it in a separate exhibit.
Sure.
Okay. Well, it doesn't matter. We can go off the portion of that. Okay, so let's read the September part really carefully into the record. On September 11th, the statement from Chris to Samantha, and you indicate this is the first time that in your mind, this should have been an alert to TxDOT, states as follows. Samantha, starting a new email so we can keep it separate from other matters. The client indicates the sign will not overhang the state's proposed acquisition area. SignAd is in the process of retaining a surveyor to confirm the sign will not encroach into the acquisition area identified on the survey attached to the state's last offer letter. We should have some more information from the surveyor by the end of next week, and I will pass along any documentation we receive. Assuming the surveyor confirms the sign's not going to be within the proposed acquisition area, there should be no need for SignAd to be named as a party to any eminent domain litigation. All right, so where in there is the statement that SignAd moved the sign?
Objection, asked and answered.
Objection overruled.
Well, it makes a couple references, I guess 3 references to SignAd and the client, indicating that the sign will not overhang. So the information is coming from SignAd as per the context of the email. It doesn't say, to use your words, the client indicates the sign is not overhanging, and it knows that because it made sure of it by moving the sign out of the right-of-way a couple of weeks ago.
Wait a second. It doesn't say anything about what you just said about moving anything a couple of weeks ago.
That's what I said. The email does not go further in response to your question beyond the client or SignAd indicating that the sign will not overhang the right-of-way. It doesn't go that extra step and say, and by the way, in addition to the client indicating there's no encroachment, it itself eliminated the encroachment back in August. It does not say that.
Right. So then Ms. Diaz states in her response at 4:36 p.m. on September 11th, thanks for letting me know. As you recall from our communications back in April, the sign is within the right-of-way and will need to be moved. We have postponed this for quite some time and unfortunately cannot anymore. We will go ahead and proceed with condemnation. Then there's a response from Chris Rothfelder on September 12th at 10:05. Samantha, understood. The client's surveyor has indicated he'll have a survey completed by the end of the month. If the survey confirms the sign is outside the state's acquisition area, then SignAd intends to move to dismiss the case and seek reimbursement of its fees and expenses pursuant to 21.019 of the property code. Thank you, Chris. Fair to say that he doesn't indicate in this that there is a survey that's been completed, correct?
By that time, he's indicated that the client's surveyor indicates they'll have one by the end of the month.
Right. So it's conditional at this time.
What do you mean conditional?
Well, the word if the survey confirms the sign is outside.
He uses the word if, yeah.
Okay. And so again, there's no statement that my client has moved the sign.
Oh, no, there's no affirmative statement that my client has, I mean, the purpose of the email exchange was to induce your colleague, Ms. Diaz, to take the diligence to go ahead and check herself upon the representation from the property owner that the sign isn't going to encroach. But rather than having her go out and doing any further checking, any surveying on her own, she just went ahead and filed the petition without doing any due diligence.
And Mr. Rothfelder, it's also been clear that for the past probably approximately 6 months, 5 months, you all had in fact been stating to the permitting department that you recognized it was encroaching and therefore you wanted an amended permit application, correct?
No, you mean SignAd making
Yes.
representations? Well, you'll have to ask the witness. Mr. Gilbert's going to testify later.
Okay, but you on your stationery made representations to TxDOT for an amended permit precisely because the sign was going to be encroached upon, correct?
Are you referring to Exhibit 14?
There
Chris
were a number.
Rothfelder's letter to Greg Polosik, dated February 7, 2018, when he's advocating to TxDOT and Mr. Polosik in general that the sign is eligible for an amended permit to eliminate the aerial encroachment. If that's
No.
what you're talking about, yes, our law firm did advocate to TxDOT on that issue in that correspondence.
Okay, so we've
And by
gone
the
from
way,
it.
I don't think, is Exhibit 14 in evidence?
I don't believe it is. I said that I would be willing to do it, admit it for purposes of notice, but not for content.
The judge overruled that objection.
Judge,
I believe 14 has been admitted.
yes.
Oh, has it? Okay.
So that, yes, indeed, that was correspondence from our law firm in answer to your question, advocating for the permission under a proper interpretation of TxDOT's rules in the 2011 settlement agreement to permit the sign to be relocated out of the right-of-way.
All right, let's talk about the next point in time, which I have as being the allegation, I mean, I guess it's more than an allegation, but your firm attempted to send a survey to Samantha Diaz on or about September, was it October 11th?
Are you referring now to that exhibit number 18?
Yes, and I believe.
19. Exhibit
Yes.
19. Now, in fairness to you, the part that you're asking me about now has not been admitted into evidence.
I understand that, and I'm not trying to admit it, but you've made the allegation in your oral statements that it was. Is
Yeah.
it fair to say that the survey you attempted to put in was a 36-inch by 24-inch survey?
No, Chris tells me it was one megabyte, which I got to admit, that doesn't mean a lot to me. But he tells me that that's not a big file.
Well, are you aware that when you try to print that document, it shows up as a 36-inch by 24-inch document?
Well, but that's, I mean, it's the same thing that the judge already admitted and that you didn't have any objection to as Exhibit 18. That's 11 and a half by 8.
You believe
That's the survey.
there's no affirmative testimony that the survey was compressed though, correct?
Well, I haven't offered that testimony.
Okay. So after this email was sent in October, there's no response from Ms. Diaz, correct? As I look at your billing, it does
Not in
not.
Exhibit 19 that I can see, yeah.
Okay, well, I understand that. That's, I believe, so Exhibit 19 is what Chris Rothfelder offered at the Special Commissioners hearing, correct?
Exhibit 18 is the actual survey. And I see from the commissioner's hearing, pages 17 through 21, and from discussing it with him, yes. Exhibit 18, the survey, is what he tendered to the commissioners and to Samantha Diaz, and she never said that she didn't get it previously.
And let's hold on and be precise, because let's talk about when you gave it to the commissioners, was it presented to the commissioners as a 36 by 24-inch document?
I don't know. So, I mean, you asked me earlier about whether I'm copied on emails and whether Chris, acts as an authorized agent for the firm and the client. And I can tell you that for sure he does. But when you start asking me specific things about the commissioner's hearing that I didn't attend, I do not know.
Okay, so let's talk about then what we do know. There's no indication from Ms. Diaz that she receives the survey, correct? As I look through your billing, going back to Exhibit 27, don't see any follow-up with her after that October 11th, 2018 date, correct?
Well, I'm going to have to defer to Chris Rothfelder again. He had exclusive communication with Ms. Diaz. I don't think I've ever spoken to her or emailed with her. So you can correct me if I'm wrong if you're looking at those fee records, Exhibit 27, if I ever communicated with her, but based on the lack of my personal knowledge, I can't answer that question.
Is it fair to say your billing does not indicate any further communication with opposing counsel after that date up until the special commissioner's hearing?
I don't know.
All right, well, let me direct your attention
Chris
to.
Rothfelder would have been the one to do it. I think you and I started communicating when you got in the case. We've had matters previously, but Chris talked solely to Samantha before you substituted in.
I understand that, but what I'm asking is Chris's billing is fully incorporated within the billing that you've submitted as Exhibit 27, correct?
That's correct.
And he's going to be careful about recording his conversations in his billing, isn't he?
He will be careful about recording the reasonable and necessary charges for purposes of preparing our invoices. Typically when we prepare invoices, they're not prepared in anticipation of being cross-examined by a lawyer in conjunction with our time entries. But, in fairness, we think they're thorough and we think they're accurate.
Okay, and that's what I'm asking. I don't see any communications in your fee. For instance, let's look at Bates 001909 within that exhibit number 27.
Say again.
If you'll, the lower right-hand corner has
Yes,
a Bates number.
And what number did you say?
001909.
Okay.
Okay, so In fact, we can see on 1011, it does indicate correspond with opposing counsel. So that from CR. And so it looks like that, you know, there was a communication that he attempted that day. But what I'm saying is subsequent to that, it does not appear to me there is a single communication with opposing counsel, with Ms. Diaz, for the rest of October or for November or for December until the special commissioner's hearings. Would you look through the next few pages and confirm that for me?
Well, there's only, say again now? There's,
In other
that's the
words,
last entry in October. And yeah, you're right. It confirms that Chris sent the email. So to the extent there's any question at all, this confirms that he sent the email. There's nothing in here, if it's your question, where he got a bounce back or had a further communication with Ms. Diaz saying she didn't get the October 11 email. I don't see that.
okay, but you also don't make any effort to ever check in with Ms. Diaz again to confirm she received it, correct?
Lack of personal knowledge. I don't think I ever talked to her at all. So any communication that would have been had with Ms. Diaz would have been by Chris Rothfelder, in fairness. And I, you know, again, I know what he's doing. We're working on this case together. But when you ask me specific things like the nature of his communication, I can't.
But I'm asking you, your billing does
Speculate
not,
about that.
but the representation is your billing is accurate and your billing does not reflect any further communications with opposing counsel after October 11th up until the time of the special commissioner's hearings, correct?
That would be something that you could probably confirm by your going through. I haven't done so. And I
I'll
don't have any
represent you-
personal knowledge. Again, it would have been Chris that had that communication. So you can represent to the judge that you've gone through the billing records, and you can represent that you haven't seen any references after October 11, I guess, up until the commissioner's hearing. Of course, they spoke, I know, at the commissioner's hearing.
Sure, and that's why
Other
I'm
than
saying,
what's reflected in here, I can't testify about it.
okay, but I mean, on some level, the entire premise of this exercise is that your billing records are accurate, right?
I think we've already established that the billing records are accurate.
Okay, and I'll represent to you, I don't see any further communications after October 11th with opposing counsel, correct?
Well, you're asking me if that's your representation to the court as an officer of the court. I guess it is, because that's what you just said.
Okay, well, I mean, do you want to take a look for yourself?
I'll take your word for it if you're making such a representation as an officer of the court to the judge.
Okay, I can't find one. So I guess my concern here is this. Chris Rothfelder attempts to send the email, but we don't have it. And there's never an attempt, there's never any response from Ms. Diaz that she received it. And it also appears that there is in fact no attempt to make sure that Ms. Diaz received it, if that was deemed to be an important document, right? There's no follow-up, there's no certified mail, there's no separate email to her that says, hey, I want to check in with you. I sent you something important 5 days ago. Nothing further was discussed after that October 11th, 2018 email that was attempted.
Well, you've made the representation of the court that there's no billing for that. Frankly, you just brought this up last night for the first time. We produced those email records in discovery some 6 months ago. And if there was an allegation that one of these emails was not received by text dot that it was bounced back. I would have thought that you would have brought that up so that we could clarify that, as opposed to doing it last night at about 5 p.m. We haven't had the opportunity to do the investigation. And frankly, and with all due respect, we're relying solely upon you telling the court that we didn't get it. Why don't you bring your colleague in here, Ms. Diaz, and have her swear to that under oath?
Mr. Rothfelder, let me suggest something. I'm trying to prove up what we can prove up with the personnel we have available. And I'll represent to you, I've attempted to try to find out from ITS, and I've been told that our IT department can't confirm or deny anything. But Mr. Rothfelder, you've produced over 2,000 pages of documents in this case.
You can't? I thought you were affirmatively telling the court that you did not receive this email.
There is nothing in our file to indicate it can. I went to the additional step of consulting with our IT department to confirm that, and they can't. But I'd like to try and share a picture of the survey. Is there a way that we can get the Zoom chat enabled or the participant sharing enabled?
Yeah, I can display exhibit number 18. Would you like me to do so?
I actually have one. Are you enabled? Are you enabled currently?
Am I what?
We,
Do you want me to?
we can pull it up on our.
We can pull up exhibit 18 on the screen if that's what you want to share.
No, I have something. I did it. I pulled it from your Bates production.
Is it one of the marked exhibits?
No, I don't think so. Hold on a second.
Well, I don't. Are you getting ready to pull a fast one there, Ms. Fagerberg? What do you want?
No, what I'm trying to show is the size of the document.
Oh,
That's what I'm trying to prove
I
up.
don't know. I mean,
you seem to be accusing me of bad faith.
no,
and so
I'm not, Nicole.
I'd like to show the size of the document.
Wait. We're doing cross-examination right now. So that means
Right.
Ms. Baker, you ask a question and Mr. Rothfelder answers it, and only one person speak at a time. So
Right.
why don't you go ahead and restate your question, Ms. Fagerberg?
Yeah. Okay. So getting back to where we were, there's no follow-up with Ms. Diaz, correct?
Asked and answered.
Objection sustained.
Okay. And you don't know the size of the document that was transmitted. Chris Rothfelder believes it was 1 megabyte.
I guess, whatever that is.
Yeah, I'm still getting a host disabled participant screen sharing, so I'm not sure how I'm going to do this. We may have to take a break and I may have to email it to everyone. Maybe we could do that.
But
What's the relevance here? I mean,
the relevance is that
I can't prove that you got it if you're saying that you didn't get it, and you're making that representation as an officer to the court that your office didn't get it. I don't have any way to rebut a negative. Is that good enough?
I understand that, but I still feel like it would assist an appellate court reviewing this, and it might assist the judge to see the size of the document that was attempted to be transmitted. And so that's all I'm getting at. Your Honor, is that something you would like to see so that I could email it perhaps to you or to your coordinator?
Well, and when you say the size, are you talking about the dimensions or the number of bits?
Honestly, Judge, I don't know precisely. I can show you though that when you attempt to print it, see the problem with Adobe, this gets complicated. So let me sort of stop cross-examining, Judge, and just address your question. The problem is that when it was all produced in an Adobe file, it was all consolidated. And so the size of the overall file is 288 megabytes. But I don't know how to pull out the size of one particular document to assess that.
I mean, Chris Rothfelder's sitting right next to me and he can explain it if you want.
Well,
Well-
why don't we do this? Why don't we finish with yours and then why don't we call Chris to the
Right.
stand?
Yeah, so Ms. Fagerberg, let's see what you can continue with your cross-examination.
Okay.
Okay.
So then we have, all right, so we have the attempted email in October. And then after that, the next time you give TxDOT any type of notification is at the special commissioner's hearing, correct?
I don't know. Chris may have spoken with Samantha. And if you're saying there's no billing record of it, it's possible he spoke to her but didn't charge the client for it. That's not unusual, to tell you the truth, especially if it's a short call. We don't charge for all of our phone calls. We don't write down all of the time, especially if it's a short email or a short phone call. But I guess, in fairness and answer to your question, I don't know. Because he had all the communication pretty much up to and through the commissioner's hearing.
Okay, well, let's go through the special commissioner's hearing, because the special commissioner's hearing, would you agree that would have been an opportunity, a good opportunity to clear up things, because you have 3 independent fee owners from the community who are ready to listen to you as the tribunal that day?
Well, yeah, and they did. I mean, I didn't go, but you introduced the transcript, so it says what it says. But I've read pages 17 through 21 where Chris told the commissioners that the sign was not encroaching on the right of way, and he had the survey with him. And as I understand it, Ms. Diaz did not deny that she had not previously received that survey that Chris's billing records do indicate that he sent on October 11th.
Well, what I'd like to do is to read into the record what Mr. Rothfelder stated to the commissioners beginning on page 4 of that exhibit. So with respect to the state's exhibits, let me find what number that one is.
It's your exhibit 34.
Okay, thank you. All right, let me just read on page 4 what Mr. Rothfelder says. Good morning, gentlemen. I introduced myself to you a bit earlier, but again, I'm Chris Rothfelder and I represent SignAd Limited. That's the sign company that owns the sign that it's at issue in this condemnation case. And I'm sure that almost everybody, if not everybody in this room, is familiar with the sign. It's the tall stacked square sign that's right there next to the railroad if you go over the overpass just east of Highway 36. We've been involved with this project for a little while now, and the main reason I'm here is basically to get more information about the project. The last petition we got from the state shows the sign is going to be bisected by 1 to 2 feet once the highway is expanded south. After we got that survey, we asked for more plans, but we haven't seen any, so I'm hoping to get some from Mr. Simper today. After we saw the sketch showing the sign would be bisected by 1 to 2 feet, we went out and did our own survey, and we saw there was plenty of room for the highway to expand and it wouldn't bisect the sign. So I'm just going to try to get an understanding of where the sign's going to go. And then I've got some questions for Mr. Caro about his valuation of the sign and some other interests as well. Fair reading?
Oh, I didn't actually follow along, so I can't. Did you?
Well, why didn't you
were
go ahead and
accurate?
do that?
What? I'll take your word for
But
it.
just wait, the transcript from the hearing has been admitted as an exhibit.
Sure.
right?
Okay.
So
Mr.
that's-
Rothfeld, well, Mr. Rothfelder, I mean, you would agree that nowhere in the transcript does Mr. Rothfelder say that SignAd has moved the sign, and that is what explains the survey discrepancy between the May 2017 documents the engineer is using and the one that he attempts to introduce from October of 2018, correct?
I haven't read the transcript thoroughly, so it says what it says. But you can ask Chris that if you want.
Okay. All right. Now let's move to,
I mean, it sure, from just the part that you read, and I'm sure you went through and picked the best part that you wanted the court to hear. He makes a
Objection,
direct
Mr.
reference
Rothfelder.
to the survey and that it only,
Objection sustained. Objection is sustained.
Okay, Mr. Rothfelder, I'll address, I don't know, Judge, do you have a pleadings file with you?
I do.
Let me direct your attention to the objections to the award of the special commissioners. And Mr. Rothfelder, let me give you all a chance to pull your own pleadings as well.
I'm ready.
All right. In your objections, there's no explanation that SignAd has moved the sign, correct? It's just simply that it is not publicly necessary, as stated in paragraph 4 on page 2.
Right. Paragraph 4, page 2, as its initial objection, SignAd challenges plaintiff's right to take the property because the taking of SignAd's property is not publicly necessary to accommodate the state's project, and or the taking of property is not for public use. Correct.
And so, Mr. Rothfelder, why did you all not share in any of these pleadings or with the special commissioners that, in fact, SignAd had just moved the sign out of the way and wanted to go take its chance on doing an administrative court battle in the State Office of Administrative Hearings?
Because that is the one thing that I would agree with you is not relevant to this condemnation suit. It doesn't matter who or why or when, or with or without a permit. The point is the pleading provides the notice to the state that there's a lack of public necessity. And as you've pointed out, it's not relevant to get into the permitting issues, and it's not really relevant as to who did the work. It's only relevant as to whether there was an encroachment that needed to be cleared or not. Otherwise, that's something that'll be resolved in SOA, like you pointed out.
Okay, but Mr. Rothfelder, surely you know that the state was certainly under the impression that it was, in fact, had not been granted any permit to move and therefore was not expecting it to be moved. Fair?
Objection calls for speculation about what the site, what the state suspected.
Objection sustained.
All right, so Mr. Rothfelder, that's what we've gone over in these documents is the totality of what you tried to make clear to the state about SignAd moving the sign.
Is that a question?
Yes.
No.
Okay, what else between the August moving of the sign and the temporary injunction hearing, what other evidence or documentation did you provide to TxDOT that SignAd had moved the sign?
Oh, you mean between August and the temporary injunction hearing?
Correct.
You brought to our attention when you provided some email correspondence with Chris, namely Exhibit 51. And there may be more, but frankly, I didn't have any other exhibits planned, but I did think that your Exhibit 51, where Chris wrote to you on February 5, 2019, and asked you, please let me know if the state has an actual survey showing the exact dimensions of the expanded highway and the points at which the sign will be bisected. If the state has a survey showing where the sign will be bisected, then we may be able to save ourselves a trip to Sealy for a hearing. If there's a question about whether the sign will in fact be bisected by the expanded highway, then it should be a simple factual inquiry that we should be able to resolve without the expense of a hearing and likely appeals. Either way, please send me a copy of the state survey so we can get to the bottom of this. Please feel free to call if you want to discuss. And to my understanding, you never followed up and called to discuss. And by that time, you admitted that you knew the sign had been removed from the right of way. So you could have picked up the phone and called and asked if SignAd was the one that moved.
Objection.
Objection sustained.
All right. In fact, Your Honor, at this time, I had on my pre-admission list a group of exhibits that was correspondence between myself and either Chris Rothfelder or Richard Rothfelder. And that as a group was on the state's pre-admission request list, state's exhibits 42 to 54. Now of those, Mr. Rothfelder only agreed to 2, which was state's exhibit 51 and I believe state's exhibit 44. Is that correct?
That's correct.
Judge, I would like to introduce the rest of that correspondence for several reasons. First of all, I believe it's a relevance objection. Is that it, Mr. Rothfelder?
Well, I suppose since you brought up the issue about Samantha Diaz supposedly not receiving an email, maybe you can't authenticate it as well.
Let me object to that. Mr. Judge, I believe that these are communications that I produced in discovery, and I will represent to you that they're admissible because they're admissions by a party opponent, and moreover, they show what the parties were thinking and working on and what each party had knowledge of and was disclosing. And it's better to have the totality of the communications rather than trying to pick out one that may or may not really be illustrative of the communications. And for that reason, I would seek to admit the remainder of those that were not agreed to by Mr. Rothfelder in that group from 42 to 54.
All right. So, Mr. Rothfelder, what's your objection to 42 through 54, except number 44 and 51?
Well, relevance, of course, first of all. And I guess on the same basis that she was objecting to our exhibit number 19, saying that in order to admit an email, you have to have the recipient of the email confirm receipt in order to properly authenticate it. And Judge, I don't want to make a hard time about it, but the way that she has treated receipts.
Okay, I'm gonna object.
Judge,
don't we-
no objection to those emails. No objection.
All right. So then states exhibits 42, 43, 45, 46, 47, 48, 49, 50, 52, 53, and 54 are admitted.
All right.
Except, of course, on the basis of relevance. And I may object when she asks me questions about them on the basis of relevance.
Okay. Let me direct your attention to, I'll try not to belabor this too much, but let's go to State's Exhibit 49, please.
All right.
Okay, so we start off on page 3 of the email, and Chris and I are looking at scheduling the injunction hearing. Then continuing to work on scheduling, and then if we get to page 1, the very first page of that exhibit, I wrote at 10:45 a.m., I agree, thanks. Thanks to clarify, still waiting to confirm the exact date for the hearing, but I can agree TxDOT will not take the sign down until we schedule the hearing. I will look for that survey today. It was not presented at the hearing. And here's what Chris Rothfelder respond. Thanks, Nicole. TxDOT did not present a survey at the hearing, and TxDOT's testifying engineer, Ryan Simber, did not have a copy of a survey available. The client has asked TxDOT multiple times for a survey since receiving notice of the project in 2017. All we've been given is the sketch and the aerials attached to the state's petition. Attached is a letter the client received from TxDOT in October 2017 indicating that apart from the sketches, the state did not have a better survey. Please let me know what you're able to find one. I'll let you know what I hear from guys about their availability from the 14th or 19th. Thanks, Chris. Doesn't this seem to imply that the problem with the case is that the state had, I guess, a topographical tie-in as opposed to a survey in 2017, as opposed to the fact that the sign had in fact undergone a material change on the ground?
The letter speaks for itself. The rest of it calls for speculation, but it certainly indicates that the state could have gone out and exercised diligence and conducted a survey and provided it.
But you all issued a packet of discovery when you filed your objections on January 2nd, correct? Of 2019?
We definitely sent written discovery requests. I don't remember the date. Is it relevant as to the date that the discovery was sent to you?
Well, I guess I'm
I
just
mean, I
trying
can
to,
check the billing records if you want me to.
I'm just trying to be precise. At that point, the state is endeavoring to find survey documents for you, correct? There were a number of requests.
Doesn't seem like it, no. They'd been requested to provide survey documents now by about 4 months. And it wasn't just Chris. Dan Creel, the real estate manager for SignAd, had been requesting them back since January 2018. It's really surprising to me that TxDOT wouldn't have a legitimate survey showing the public necessity, and that they would continue at such a late date to say they needed to look into it.
Okay, and I'll objection to the non-responsive portion, but Mr. Rothfelder, in other words, the communications have to do with the fact that it's a topographical tie-in attached to the state's petition as opposed to a signed and sealed survey, correct?
A topographical tie-in? I don't see any reference to that, and frankly, I don't know what that is anyway. Where do you see that?
The state produced numerous documents to you in discovery to attempt to prove that up. Can you agree with that? You reviewed the state's discovery in your billing, didn't you?
Sure.
Okay, and you don't disagree that in fact, part of your review was for numerous different engineering, topography documents, all sorts of things to assist you all with your questions about surveys and what the state had attached to its petition. Is that fair?
We reviewed a lot of documents in this case. Topographical, I'm not sure I even know what that means.
You were given documents.
Is it relevant? If so, explain to me what it is, topographical, and
Were you given a state's document production that included documents from WSP Engineering Company, GeoServe, and Gondora survey documents?
I don't know. Chris went through the discovery more than I did, but those names don't sound familiar. I mean, it could be. Why is that TxDOT's engineer, or I don't know.
Okay. All right. Mr. Rothfelder, would you agree that the underlying goal of this case, I think you've said this, was simply to avoid the condemnation action?
No. What do you mean underlying goal?
In other words, the client's main intention, as I understood your narrative testimony, was to move the sign out of the right-of-way path of the bridge so that you could avoid a condemnation, correct?
I mean, I think that's accurate. From the beginning, the client's objective was to salvage the sign. And to be clear, they felt like they had the legal basis for doing so, namely a 2011 settlement agreement and a proper interpretation of the regulations. And I can tell you, based on my personal knowledge in consulting with them, that I agreed that they had the legal basis to do it.
I'm going to object to that.
Their objective to do that.
Objection sustained.
All right, Mr. Rothfelder, would you agree that had you simply contacted the state in writing, sent us some of the demolition or the alteration pictures that you all have admitted yourself as part of your own exhibits, I think it would be Exhibit 31, if we could go to those photos, they were Redmond's photos of sign adjustment process, Exhibit 31.
I have those photos in front of me.
Would you agree that had you simply sent that over or communicated in writing that your client had moved the sign out of the way, you would have accomplished your client's purpose prior to the filing of the condemnation petition?
Say that again.
Right. In other words, the task of getting the sign out of the right of way to avoid the condemnation was achieved in August of 2018, correct?
Yes. I mean, to be clear though, they wanted to do it legally and applied for a permit to do it legally. I mean, they objective was to keep the sign and not be sued in SOA for $1 million for doing so.
But the billing that's throughout that time period in 2018 does relate to the permitting issues, correct?
No,
You don't think so?
those were billed separately to the SOA case.
Let's go back. I don't have a lot more, I promise. Let's go to Exhibit 27, please.
There.
Okay, so for Exhibit 27, let's go to page 001894. And I'll represent to you that's approximately May of 2018.
You have a question?
I do. So with respect to this, on page 001894, there's a number of items that deal with permitting, correct? So for instance, on 05-1618, it states, review TxDOT's permit denials letters, staff conference with C. Rothfelder, and review emails with client regarding same. The same day, CR, Chris Rothfelder, bills 3 hours at $900, receipt and review of notice of denial of amended permit, applications seeking to adjust sign out of expanded right-of-way, emails with D. Creel and W. Gilbreth regarding same, conference with R. Rothfelder regarding same, telephone conference with D. Creel, etc. Begin drafting appeal of amended permit applications to TxDOT. That appears to be permitting work, correct?
Well, again, it goes to SignAd's good faith belief that it had a right to relocate the sign out of the right of way, avoid the condemnation case by getting the amended permit from TxDOT to adjust the face, the 2 feet from the pavement and the extra 5 feet from the setback. They applied for a permit to do it. It was denied wrongfully, and then it was appealed timely.
Okay, but so all this work with respect to applying and appealing for permits is billed in with your eminent domain billing for this case.
It's in connection with this case where, as you pointed out, the objective was to eliminate the eminent domain case by having the sign moved out of the right of way, demonstrating to the court there's no public necessity to prosecute the eminent domain case. And TxDOT would contend you need an amended permit, so they applied for it. They incorrectly denied it. We appealed it, and we charged the services in connection with doing it.
Let's talk about, I want you to move to, let's go ahead and move to approximately 001915.
I'm there.
Actually, I'm sorry, 001916.
Okay.
All right, let me direct you to the bottom right part of that page dated 12/27/18. And by the way, I'm sorry for both of you if you're working this close to the holidays. Let's see, it says begin drafting motion to dismiss. Plea to the jurisdiction and application for temporary injunction. Do you see that?
Yes.
Okay. And there's other references to motion to dismiss throughout your billing. So for instance, if you'll turn to page 001920, and there's on January 15th of 2019, it talks about emails with opposing counsel regarding motion to dismiss. And then on the very next page, 001921, in the top entry, January 16th, 2019, it talks about the filing of the motion to dismiss. Do you see those entries, Mr. Rothfelder?
What was the last one? I'm not sure on
Sure, it was
001921.
correct. On the upper left-hand corner, January
What date?
16th. The 16th of January?
Uh-huh. Yeah. Mm-hmm. Yeah.
Okay. And there's even other times where it continues to appear on 001925. On February the 7th, it refers to motion for temporary injunction and motion to dismiss, correct?
You mean in some of those billing references?
Yes.
Yeah. Mm-hmm.
Okay, so clearly at some point you all were contemplating filing a motion to dismiss, correct?
No, I don't think that's accurate. What was accurate was in January 2019, we knew that we were going to need to secure relief from the court to demonstrate a lack of public necessity to prevent the condemnation case from going forward. And we knew that we were going to have to file an instrument to do so to demonstrate that lack of public necessity. Dismissal's the appropriate action if a court doesn't have the public necessity to condemn property. But we looked at the timing of the situation and realized that any sort of motion to dismiss was going to have to be secondary to maintaining the status quo. So we filed a temporary restraining order application to maintain the status quo to prevent the state from removing the sign. The commissioner's hearing had already been held. Technically, possession of the property had already been acquired by the state. The state technically would have been able to go ahead and remove the sign.
Objection,
But we were
Your
going to
Honor.
join y'all from doing so.
Wait for Ms. Fagerberg to state her objection.
Okay.
Yeah, so Mr. Rothfelder, you stated technically possession had been acquired. That's not correct, is it? Possession comes into play at the deposit of the Special Commissioner's Award, correct?
But I don't think that's a procedural objection as opposed to grounds for further cross-examination. What's your objection?
Well, I think that's objectionable because I think
we
it's
can debate that, you and I, but that's not a procedural objection.
Okay, well, let me ask that. Let me stop you there then, because I think that's misleading to the court. What led you to believe the state was in possession of the sign?
The commissioner's hearing had been held before your email where you finally said you'd be willing to enter into a Rule 11 letter not removing the sign. The sign was in jeopardy to being removed. So we needed an injunction or we needed an agreement. And indeed, we tried to get an agreement. Again, you knew by then, and it would have been easy enough for you to give an agreement not to remove the sign. It would have been easy for you to ask that question that you keep asking why I didn't ask. You could have said, hey, did you guys move that billboard or something?
Objection, Your Honor.
You never did.
Objection sustained.
Okay. Mr. Rothfelder, are you comfortable that the correspondence speaks for itself in this time period about the injunction and being willing to grant Rule 11s? You seem to be
Well,
implying that
I
somehow
object, better reference it to me because I think you might be trying to trick me.
on what grounds do you think I'm trying to trick you?
Well, just the way you phrased the question, I know you're a skillful litigator.
Mr. Rothfeld, I think what I'm getting at is I don't believe there was any delay in the state offering to sign a Rule 11 until we could schedule the hearing. So I'm asking you, are you submitting there was some sort of delay on the state's part in agreeing to the Rule 11?
Well, you made us go to the hearing in Belleville on February 14. You could have agreed to it previously. I read into the record your Exhibit 51, where Chris is asking you if we can have an agreement and save the expense and save the time and save the trouble for everybody to go to Belleville. But you said in your opening statement that you wanted to subpoena witnesses so that you could determine under oath who and when the sign was adjusted, clearly solely for the purpose of the permitting dispute in SOA.
Objection, Your Honor.
Is your objection for non-responsiveness?
Mr. Rothfelder, the state, in fact, do you recall the injunction hearing?
Very well.
Okay, and at the time you represented to the court that you would be filing a motion to dismiss, correct?
Well, that part I don't remember, but it might not be unusual for me to do that. And you've offered, I think, the full transcript of the injunction hearing as an exhibit that I did not object to.
And Mr. Rothfelder, at that hearing, the state then volunteered to get a signed and sealed survey, correct?
I wouldn't say you volunteered it. I mean, we put on a case all morning long that made it crystal clear that there was no public necessity for the state to proceed with the condemnation case. And over the lunch break, you conceded that you were going to lose if you went forward. You didn't want to expose Ms. Knox to further embarrassing cross-examination. So you came to me and wanted to make an agreement belatedly.
I'm going to object to
that. You're
that.
going to go get your own survey.
Objection sustained.
Mr. Rothfelder, you continued to make statements to me throughout the spring of 2018 that you might dismiss the case yourself, correct?
That I might dismiss it or that you might dismiss it?
That you might dismiss it, correct?
I said that we were thinking about dismissing it. And then when you rejected our settlement proposal and didn't give us an opportunity to recover those costs for adjusting the sign out of the right-of-way, I don't want to disclose my trial strategy as I believe that's inadmissible work product. But when you gave us no alternative by flatly rejecting even mere reimbursement of those adjustment costs, we could go to the trial and try to recover it, or you could dismiss the case yourself, which is what you did.
And if I can direct your attention to Exhibit 54, that is something dated May 15th.
Yes, that's your and my email exchange dated May 15, 2019.
Okay, and I state, let's start with mine. I have a pretty short one. I say, Richard and Chris, what is your position with respect to the dismissal? You previously told the court you would move to dismiss this yourself. Despite that, in our latest communications, you stated that might not be the case. I've contacted BNSF and they are not opposed to the dismissal. And then you state, as mentioned in my April 9th email, we have not yet filed a motion to dismiss. If and when we do so, I'll provide you with itemized invoices in support of our request for recovery of attorney's fees upon dismissal. You then say later we may proceed to trial seeking to recover cost to cure damages for adjusting the sign to accommodate the state's highway improvements and eliminate the right-of-way encroachment. Is that the strategy you're referring to?
Well, I mean, that's I don't see it in the email, but that's the strategy that I'm referring to.
Okay, so you viewed those as alternate theories, correct? You were
What's
going
that?
to move to dismiss, or there would be a trial about the fees being a compensation would be this sort of what you term a cost to cure for adjusting the sign in advance of an eminent domain action.
Well, no, I mean, what we really wanted to do, and you didn't read it to the judge, was I started out that second paragraph saying SignAd also remains willing to compromise some sort of settlement of all these disputes with TxDOT. And I referenced the comprehensive proposal that I did so in my April 1 email. We were continuing in that time frame to try to minimize the attorney's fees, trying to stop this lawsuit and just get reimbursed for that pretty modest amount, $45,000 to $50,000 of adjusting the sign out of the right of way. But you flatly refused. So our objective was to try to look at a strategy to be made whole, including going to trial. The case had been set for trial pursuant to the agreed order that you and I submitted to Judge Leedy in April 2020.
And in fact, the correspondence between us shows that in fact, we had to add that because it's a provision of the TRCPs that it's mandatory, correct?
I don't know. You mean, why did we add a trial date?
Correct.
Judge Leedy may have wanted one for his docket, but I do think you're right. I think that the rules specifically provide that the grant of a temporary injunction that is going to maintain the status quo until the final trial on the merits has to recite that date of the final trial on the merits.
All right, now, Mr. Rothfelder, under the property code, you could have filed your own dismissal under 29.019C, correct?
Well, I don't know what the relevance of that is, and you're asking me once again to disclose my work product and my strategy in the case. So we didn't. And that's not before the court today because you did dismiss it and it's a separate proceeding under 21.0195C, so I object accordingly.
Well, Mr. Rothfelder, if we're talking about achieving your client's results and making sure that you all get paid what's reasonable and necessary, what is the rationale for not filing a motion to dismiss and seeking your compensation under 21.019C of the Texas Property Code?
We could have gotten it through trial instead.
So it was sort of an intentional strategy to keep billing through a trial.
No, it was an intentional strategy to try to settle the case, but you wouldn't do so. So we looked at the alternatives to minimize the.
Objection sustained.
No.
I'm sorry, what question are you answering?
The last one you asked.
Okay, let me ask again because I got confused on that. Why did you not file under tell me why it wouldn't have worked to simply file under 21.019C to get all the attorney's fees you were due and to dismiss the case?
Objection, Your Honor. That calls for disclosure of our internal work product and trial strategy, and it's irrelevant as we're here to talk about the dismissal by the state as opposed to speculating what would have happened if it was a dismissal by SignAd.
Objection sustained.
All right, so Mr. Rothfelder, the state files its motion to dismiss after you commence trying to begin doing discovery and send out deposition notices for 2 witnesses, correct?
Yes.
And so on or about December, I believe I filed motions to quash on December 13th and then motions for protective order and a motion to dismiss on or about December 20th of 2019, correct?
I can't verify, but that sounds about right. I know it was in December 2019. And I know
as
you
we-
filed the notice. Wait, the notice of non-suit, I do recall off the top of my head, was December 2019.
Yes. Now, Mr. Rothfelder, you then sought to take the depositions of Wendy Knox and Mario Caro, which the state opposed, correct?
Yes, you filed a motion for protection to prevent me from deposing them.
Okay, and your billing for the month of February involving those depositions was almost $20,000, correct? It was $18,901.40. That's Bates number 001960.
If you represent that to the court, that's fine.
Okay. And then on 001963, it looks like the trip to Austin plus the transcript fees and video were in the neighborhood of about $5,300.
Sounds low, but if that's what you're representing to the judge, that's fine.
Okay. And then the motion, the amount that was filed in January for the motion for protection, Rothfelder and Falk billed $13,285.50 for the month of January after the state's non-suit, correct?
If you're representing that to the judge as an officer of the court, I'll take that as correct. Again, it sounds low, but if that's what you're saying, the record will so reflect.
Well, with all due respect, sometimes there's a balance due at the bottom of the page that's larger, but I'm attempting to be precise and trying to segregate out the monthly bill on that page. Does that make sense?
No.
Okay. In other words, if you go to 001956,
Yes, ma'am.
okay, if you go, let's say approximately 5 or 6 numbers up, it says total amount of this bill is $13,285.50. But then there's a previous balance below it in the amount of $8,626.50.
Correct.
So is it possible it's sounding low to you because I'm not combining the previous balance with the total amount of this bill?
No, the billing for the month of January 2020 was $13,285. There was a previous balance, as you pointed out, $8,626.50. So the billing for the month of January 2020 was $13,285.50.
Mr. Rothfelder, Ms. Knox is a supervisor in the permitting arm of TxDOT, is that correct?
That's not her title. That's one of her responsibilities.
Okay, but
She
not involved-
actually,
she's
you
not
want me to
involved
answer
with,
that question?
she's not involved with the right-of-way division, correct?
I don't know about that. Let's see. She oversees and administers the right-of-way division. She's currently the director of the right-of-way division, as
Well,
she
with
testified on page 15 of her deposition. And she said she's pretty much in charge and has been since 2010.
With respect to billboard issues though, correct?
You can take a look at her deposition if you want.
Okay, how many exhibits did you have to her deposition?
I don't know. You want me to check?
Was it approximately 50?
Yeah, let's see. Is it important? Do you want me to check?
Well, what I'm getting at is there was an enormous amount of this deposition that dealt with the permitting issues, correct?
That dealt with the necessity and reasonableness of SignAd's actions and therefore the need to continue to prosecute the case and incur attorney's fees due to TxDOT behavior. And in answer to your question, it looks like there was 50 exhibits.
Do you intend to try to use any part of Ms. Knox's deposition in the SOA case?
I don't know. Again, I really don't feel comfortable disclosing to you our trial strategy, especially in another case. You know that's not admissible.
Well, but the point is you're not trying to take someone's deposition for use in your SOA case, are you?
No, this deposition that we took in this case on February 19, 2020 was for this case. And I don't know if you know it or not, but Ms. Knox's deposition is scheduled in that SOA case for the day after tomorrow. We've got a trial date in that case on October 5, and she's giving her deposition in that case on Wednesday of this week.
Mr. Rothfelder, during Ms. Knox's deposition, you attempted to put in lots of permitting rules and regulations that were not produced in the right-of-way case, correct?
Is this the right-of-way case?
It's an eminent
Or
domain
the
case, yes.
SOA case?
Mhm.
Well, I'm not sure I follow you. Did you ask for production of TxDOT's own regulations in a discovery request? I mean, we produced everything. There's been no allegation that we've withheld any discovery, if that's what you're getting at. We've produced all discovery that you've asked for and did so on a timely basis.
That wasn't my question. Let's move on to Exhibit 27. Let me direct you to the first page of your exhibit. Your 2018 total was less than $20,000. It was $19,000, $668.53, correct?
Yes.
Your 2019 total was $61,202.21, and your 2020 total was $82,931.33 as of the time you did this exhibit, correct?
Correct.
You're now alleging that it's more than that, and you're including ancillary possible appellate and contingency fees or some sort of post-briefing fees now?
Well, the record will reflect that I said that through this trial, through today's hearing and any post-judgment, post-hearing briefing, the judge may or may not require, I estimated another $20,000 because I haven't rendered an August bill. But that's, in my opinion, going to be another 20. And yes, I gave an opinion as to potential conditional appellate attorney's fees as well.
And so approximately half of the bill as of the time you generated Exhibit 27 is generated after the state filed its motion for immediate non-suit, correct?
During the year 2020?
Yes.
Yes, those amounts are accurately reflected on the first page of Exhibit 27.
Judge, I have no further questions for Mr. Rothfelder.
Mr. Rothfelder, do you have anything else?
Could I have a moment to determine if I have any rebuttal on my cross-examination, Judge? Redirect?
About how much time do you need?
I just wanted to review my notes for potential redirect. And no, Your Honor, I passed the witness.
Okay. And let me ask just a couple questions. Since we've heard some testimony that events happened in 2017, Was your law firm not contacted by SignAd in 2017?
That's correct, Your Honor.
And are the bills that are included in Exhibit 27, are those all, segregated so that these only apply to the condemnation, and or do you have another set of bills that would be for the permitting or administrative end of this?
Yes, I believe the answer is yes and yes. The answer to the first question is that only the bills that are attached as Exhibit 27 are those that are reasonable and necessary and relate solely to this case without any duplication or repetition. We've been engaged separately for SignAd for the administrative case in the State Office of Administrative Hearings and have that set up for a separate billing file.
All right, Ms. Fagerberg, any other questions?
No, Your Honor.
Okay, so I'll tell you what, let's take about a 10-minute break, but before everybody leaves, I want to have some scheduling discussions, but we'll go off the record now. All right, so we're off the record. So Mr. Rothfelder, who do you anticipate as being the next witness?
Wes Gilbreth.
And how long do you think he might be today?
My direct examination of him will last less than an hour.
And if you had to give a real ballpark figure, Ms. Fagerberg, what type of cross-examination time do you think you'd need for Mr. Gilbreth?
I really don't know, Judge. It probably depends on what he's attempting to opine to.
Okay. All right. If there's much cross-examination of Mr. Gilbreth, we're going to be probably looking pretty close to 5 o'clock. So, Mr. Rothfelder, what other witnesses do you anticipate calling in this case?
I'm resting after Mr. Gilbreth.
All right. And then Ms. Fagerberg, how many witnesses would you anticipate?
At least one.
And who is that?
At least Mario Caro.
And how long would you anticipate his direct to be?
I could do his direct in 15 minutes.
Okay. All right. Well, let's.
Judge, in fairness, if she's not going to call Wendy Knox, I'm going to have to call her as an adverse witness on my case in chief.
All right. And how long do you think you'd need for Ms. Knox?
Less than an hour.
Okay. Well, we'll just have to see what we can get done today. I'm looking over at Ms. Lozano. What do we have tomorrow morning or tomorrow afternoon? Everybody just want to look at their schedules and see if it sounds like we could easily have a couple more hours tomorrow.
We're open, Judge.
We're full tomorrow, the next day.
I'm not available in the mornings. I have
Tomorrow?
tomorrow morning, I have a special commissioners hearing reset. It won't take terribly long, but I still need to show up for it. And one of my children has a Zoom call with a teacher as well that we need to arrange.
What do we have tomorrow afternoon? I mean, we may just have to push some stuff because we need to get this done.
Okay, tomorrow afternoon is, well, it's supposed to be Schubert, which I think is going to be a default. And then seems like a 5-minute probate. So tomorrow afternoon might be good
Okay.
if that's a default.
Okay.
If we're Schubert.
All right. Well, like I said, we'll come back about 3:20 and see what we can get finished today. And if necessary, we may need to come back tomorrow afternoon. But we'll be in recess till about 3:20.
Right downstairs, Judge. You want to run downstairs? Put it right quickly. about to give me my own. Shut up. Well, then skin good. What's the problem?
Yeah, if we do many more of these, you gotta work on the lighting. If you notice, this bigger than Washington, it looks so good. They're-
Yeah, this is just bright lighting.
Just their skin color looks good.
We'll get you a lamp, a floor lamp
Yeah, I need something.
behind you.
Well, I don't know.
There you go.
Great. All right, is everybody here? All right, then we'll come back to order on the state of Texas versus SignAd, and Mr. Rothfelder, call your next witness.
I'm going to have Chris Rothfelder clarify the receipt of the issue on the October 11, 2019 email. Since Ms. Petterberg brought it up, he's gone to his computer and has some documents and information to share with the court.
Are you going to question him, or is he going to testify in the narrative himself?
He's going to testify if you want him to.
All right. Then Mr. Chris Rothfelder, you may proceed.
Do I need to be sworn in, Judge, or do you just want me to explain what I'm in
Well,
office here?
Okay, were you sworn in earlier this morning?
No, Your Honor.
Okay, let me just go ahead and do it. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you may proceed.
And Your Honor, while we were sitting here today and I was listening to the testimony about SignAd's Exhibit 19 and the issue of whether Ms. Diaz received my October 11, 2018 email, I went into my Gmail account on my computer and tried to do as much investigating as I could with my limited IT skills. And I was able to pull up two emails, two of the original emails that were sent to Ms. Diaz in October 11, 2018. And so I'd like to show the court and Ms. Fagerberg what's titled original message. And so, James, can you pull that up? And so Gmail let me pull up this original message version of that October 11, 2018 email. And what I was able to gather was that it actually shows proof of delivery after 4 seconds. This is the native text file of the email that doesn't contain any images, just the text and code. The second document that I was able to take a screenshot of, Your Honor, was my Gmail page. And if I can just explain quickly, back in 2018, I was using my Gmail account because I had concerns that perhaps my Rothfelder and Phallic account was having some issues. And so to make sure that I was getting emails and that my emails were being received, at times I would use my Gmail account. So that was actually the reason that I was using this account at the time. And if you see at the bottom of that screenshot, you can see that the size of that message is 979 kilobytes. And that's just shy of 1 megabyte. And in my experience, typically files that are less than 10 or 20 megabytes will easily go through over an email. And so this survey file being less than 1 megabyte shouldn't have had an issue going through, at least due to its size. And having scoured my Gmail account on my computer, I don't see that I ever got any sort of bounce back from Ms. Diaz, and I certainly don't recall her saying that she had reported any sort of bounce back. I don't have anything in the file showing a bounce back, whether it's on my email account or in our hard file. And so we'd go ahead and offer these two emails into evidence, and we can offer them, I think, as SignAd's exhibits 40 and 41, since those are currently blank.
Okay, now are 40 and 41 different from that October 11th email at 11:54?
They're just different formats of the same email, Your Honor. But exhibits 40 and 41, if you see on our exhibit list, are currently open.
Yes.
And so my suggestion is just putting them in those open slots for the ease of the record.
Ms. Fagerberg, do you have any questions about these
I
exhibits?
guess I would probably need to see them. Would it be possible for me to review them a little bit more?
Aren't they on the
So
screen there?
maybe email them to me?
I can email them to you.
That would
Okay.
be great. That way we could have our people look at them as well.
So why don't we do that, since it sounds like we'll come back and finish up tomorrow. If you can send those again to Ms. Fagerberg so she can review those.
And if it's okay, may I ask, I think I may have figured out how to upload the exhibit of what I think was sent. Would it be possible for me to show that to Mr. Rothfelder now?
Yes.
Okay. Let me see if I can figure out how to attach this.
Oh, and Ms. Fagerberg, while you're doing that, I
Okay.
can request also to Mr. Chris Rothfelder, since this may be an exhibit, you could also include that to the court so we'd have a copy of it.
Yes, Your Honor. That's the ccl@austincounty.com.
Correct.
Okay, and I don't know if anyone can see the chat function. Okay, so let me look at
We
the
don't
first.
see anything. Are we supposed to?
1 second.
What do you need from it?
Nicole, what would you like us to pull up?
Can you see it on the chat function? It says survey attachment .663 to -665. Those represent the Bates number of that within your Bates production.
Yes, it's 1.82 megabytes.
Yeah, and I was wondering if we could look at that momentarily.
Can you pull that up?
Yeah, get it.
Is there a way of opening that in the chat?
This is the survey attachment, 1.82 megabytes, is that correct?
Yeah.
I don't know if I can share my screen or not.
Okay, I'm downloading it.
Who just made the last comment?
Our videographer, James Browning.
You put it over that.
So I can't actually fully open this, but not in the way it's displayed, but
Yeah.
I'll represent to everyone that if you attempt to click on print on this, that what will occur is that if you click on actual size, it shows it to be a 36 by 24 inch survey. And so I don't know if there's a way that we can click print to see that within Zoom. I might have to do some sort of screenshot or something, but it seems to be an extremely, like the dimensions are unusual. It is
Ms.
some sort of
Fagerberg-
an oversized document.
Ms. Fagerberg,
Yeah.
the size that it prints is, in my understanding, is completely different than this actual file size of the file, just because a document may default to print at 24 by 36 inches doesn't mean that it's a large file in terms of bits or megabits. What my computer is showing me is that this file size was 1 megabyte, which is pretty standard to be sent over an email. You could certainly print it at 24 by 36, just like you could print it at 8.5 by 11.
Well, but I mean, I think 8.5 by 11 is something like 20% of its normal size. In any event, I'll talk to my computer people, but I'm just attempting to share this to show, I guess, what my concern was about this, since I don't have this in my file.
And let me ask, Ms. Fagerberg, is your concern about the October 18th email, the text of the email, or the survey that was attached?
Well, I think what I'm concerned with is the premise. I've already said I don't doubt that Mr. Rothfelder in fact sent it. I just don't have any, unfortunately, the presumption is that Ms. Diaz received it. And unfortunately, unlike other emails where I've been able to verify that, like the September one, this one, I simply can't verify it.
And is the reason you're objecting because of the text or because of the survey that was attached?
Well, I mean, maybe both. If we're not sure that it went through, then I think we have to be careful about saying there's a presumption that the state received it.
And I don't have any evidence that it didn't go through. Typically, when I send an email that has a file attached that's too large to be sent over email, I immediately get a bounce back saying that the file was too large. And I've looked through my Gmail account here, and I don't have any indication of a bounce back being received on this.
But Ms. Fagerberg, what's the harm in this exhibit that's part of Exhibit 19?
I think the harm is the presumption that the state received it when we don't have any emails confirming that from Ms. Diaz. And the document is sort of an oversized survey document that was being transmitted. And I understand it's only 1 megabyte, but I would just probably like to try and confer with my IT people and see if there's anything that might otherwise have been an issue.
Okay, well, let's try to do that then this evening, and we may be back a little bit this afternoon. So do you have any other questions for Mr. Chris Rothfelder?
I do. Well, I guess while he's here, let me ask this. Mr. Rothfelder, your father indicated you may have had communications with Samantha Diaz that were not in your billing. Do you recall having any specific conversations with her about this survey after the October 11th email?
Yes.
Approximately when?
At the commissioner's hearing.
Okay. And what were your communications at the commissioner's hearing?
That we have a survey showing that the sign is out of the right of way.
Did she say, oh, yes, I received that in October, or were you all just discussing it because you gave her a copy at the hearing?
I don't recall. I know, having looked at the hearing transcript, that I mentioned emailing it to her in October, and I don't recall her telling me off of the record, and I haven't seen in the record where she said that she didn't receive it.
Okay, but there's no specific communications you had with her about the survey other than you presenting it to the commissioners in December?
No, I believe we talked about it prior to and following the commissioner's hearing.
Okay. But you have no emails from her in your personal email account or otherwise indicating she received it?
I've produced to you all of the emails that I have with Ms. Diaz.
Okay. I have no further questions.
All right, so Mr. Chris Rossfelder, do you have anything else?
No, Your Honor.
All right, so then, Mr. Rothfelder, you can call your next witness.
And that'll be Wes Gilbreth, Your Honor.
And Mr. Gilbreth was not in the courtroom earlier this morning, was he?
Well,
I
he
don't think
actually
any of us
was, but
were.
he was off camera and he raised his hand and swore to tell the truth
All
when
right, so
you swore him in.
if he was sworn in, then you may proceed.
Okay. Introduce yourself to the judge, please, Mr. Gilbreth.
My name is Wes Gilbreth Jr.
And what are your positions, title, responsibility?
I am president of SignAd Outdoor Advertising and responsible for the running of our operation from land deals to sales to operations to installing signs, removing of signs, any and all the above.
How long you been in that position?
I've been president since 1985, so 35 years.
Is it fair to say that you're an expert in sign construction?
That's correct.
Are you an expert in sign repair?
I am.
An expert in sign purchases?
I am.
An expert in sign advertising sales?
I am.
In that you wear several different hats as the president of SignAd and have done so for at least over 30 years.
That's right.
Okay. Let's explain to the judge a little bit about SignAd Limited, the condemnee in this eminent domain case. What is SignAd?
We are a billboard company. We've been around since 1964 when my dad first started the company. In fact, I worked on this very sign back when I was a teenager, back over 40 years ago, 45 years ago or so. So I'm well familiar with this sign.
SignAd's a family-owned business?
That's right.
Okay. I don't want to spend too much time on this because we're running out of time, frankly, but I don't know how many sign cases the judge has had before, and he may be interested to know a little bit about the sign business, the outdoor advertising business in general. Can you give us an executive summary about the business of outdoor advertising that SignAd is engaged in?
Yeah, in our business, we have land men and land women that go out and search for sites to build signs. They find what we call a conforming site that meets all the state's criteria and sometimes city criteria. Then we are required to get a permit, or sometimes multiple permits. Once that's done, we accomplish our, receipt of a permit, then we build the sign and then, then it's up to the marketing department to try to sell the ad space on the sign itself.
And off-premise signs are subject to governmental regulations, are they not?
That's right.
This particular sign is subject to whose regulations?
TxDOT and the city of Sealy.
And how long have you been dealing with TxDOT and its regulations?
Well, since we, in this particular sign or just
No, in
overall?
general, I want the judge to understand your expertise in dealing with sign regulations well as sign construction, sales, purchases that you already testified
I
to?
think since the inception of our company back when Lady Bird Johnson's Highway Beautification Act was enacted back in the early 60s.
Okay. All right, let's now focus on this sign, and I want to refer you and the judge to exhibit number 20. And there was some question about a date on the sign. Identify exhibit number 20, Mr. Gilbert, please.
That's a picture of the sign in question.
And Judge, so you know, I've got hard copies I've sent to you. And Mr. Gilbert's looking at the hard copy in front of me as well. Okay, now the general date, general month of when that photograph of the sign, some 4 pages of the front and back side of that sign was taken, sir?
That's within the last few months.
Okay. Your Honor, we offer into evidence exhibit number 20.
Any objection, Ms. Fagerberg?
No.
And now let's take a look at the
Exhibit 20.
site. Let's take a look at exhibit number 2 and identify that for the record, please.
That is the aerial shot designating where the actual sign is situated along I-10 and just east of Highway 36 on the railroad corridor.
And exhibit number 2 has already been pre-admitted, Your Honor. Describe the sign to the judge, please.
Currently, or the history of it?
The history of it, like when was it built or when was it acquired by SignAd? Let's go chronologically and start back then.
Well, we acquired the sign in the 70s, mid 70s. I'm not sure from who. At the time, it was a 12 by 40 back-to-back sign, 12 foot tall by 40 foot long. It was an I-beam structure. At some point later, I think it was in the 90s, we applied for a permit to change it from a single back-to-back to a stacked back-to-back sign. Got a permit from TxDOT to do that, turn it into from 2 faces to 4 total faces. Later on, I guess, 12, 13 years later, TxDOT realized they'd made a mistake and issued us a permit in error, possibly, stating that they should not have given us a permit for the stack, and now the sign is basically illegal, and the permit was canceled. So at the time, had to hire the Rothfelders, or Chris wasn't around then, but Richard was, and to assist us in trying to negotiate something with the state, which we were able to accomplish. We were forced to remove the stack and turn it back into a back-to-back sign, which we did. Made an agreement. I don't remember how long it took to reach that agreement. And then here recently, signs, an issue again. This sign has a pretty extensive history.
Let me direct your attention before we get to that history, including that settlement agreement. I think you're talking about the 2011 settlement agreement, are you not?
That's right.
I want to go through a couple of things factually on the sign. First of all, so when that sign was built back in the 70s, as well as when that argument occurred in some decade ago, was the sign located in the same site on the railroad right-of-way that lead under the bypass there at I-10?
It was.
Okay.
Same sign.
So the judge knows that sign has been at its current location for some 50 years and it's never been moved.
I think it's probably been 60 years, Richard.
Okay. Now, you know that if you wanted to build that sign now, you'd be prohibited from doing so.
That's correct.
Because you're familiar with Sealy's regulations.
That's right.
And referred the judge and you, Mr. Gilbreth, to Exhibit 12, which appears to be Section 80-09 of Sealy's regulations. And can you identify that, please?
I can.
Do so.
This is Sealy's ordinance regarding prohibition of signs. Says the following signs are prohibited from installation. It goes on to say billboards, including digital billboards, and then off-premise signs, which this one is.
But that was passed after your sign was built some 50 or 60 years ago.
That's correct.
So your sign was allowed to be legally maintained in that site all the decades since.
That's right.
Your Honor, we offer into evidence exhibit number 12.
Ms. Fagerberg, any objection?
Yeah, Judge, I'm not sure what the relevance is. They're not alleging any kind of a lost ground lease. I don't really know why this would be relevant to the eminent domain case and the reasonable attorney's fees they're on it.
Okay, what is the relevance, Mr. Rothfelder?
The reasonable and necessary attorney's fees, and that this, if this sign was removed through eminent domain, it would be lost and lost forever, so that the market value of the sign in arm's length transactions between Mr. Gilbreth and his competitors to replace the $50,000 to $60,000 a year made it reasonable and necessary to move the sign out of the right of way and then incur attorney's fees.
I need to object to Mr. Rothfelder putting testimony in the record.
I was answering the judge's question as to relevance, Ms. Fagerberg.
I know, but you're starting to testify about something else.
All right, and Mr. Gilbreth, gave testimony about this. So what's the additional relevance of that, getting the actual Sealy ordinance into evidence?
It's the legal document that confirms his testimony of, I suppose, if there's a stipulation that you cannot build new signs in Sealy, and if this one was removed to accommodate the highway improvement project, it could not be replaced elsewhere in Sealy, I guess we don't need the document itself. Is there such a stipulation?
I'm not going to stipulate to that. I mean, the other testimony was already that there wasn't supposed to be an alteration, but the City Council of Sealy approved it. So I can't stipulate to that. I still think it's irrelevant.
All right, so objection is sustained.
Okay, now that sign is maintained on a license with the Burlington Northern Railroad, is that correct?
That's right.
And turn with me to exhibit number 21. And identify that for the record, please.
This is our lease or license, I believe it's called, through Outfront Media, which is the representative for the railroad.
Now, the railroad being referenced in the rest of the pages of that exhibit 21, correct? Burlington Northern Railroad. It doesn't make that much difference.
Yeah. There it is.
So Upfront's the agent for the railroad, who's the actual lessor.
That's right.
Okay. And the first page shows the amount of ground rent that is paid for the privilege of maintaining the sign on the property.
That's correct.
And what is the basis for calculation of ground rent?
Your Honor, I object. We're not calculating a ground lease. There's no allegation of a lost ground lease, so I don't know why we would.
Because there's, if I can respond, Judge, there has been an allegation that SignAd is not a property owner. And exhibit number 21 shows that it is indeed an owner of a leasehold interest, another type of property that is compensable in eminent domain.
You can continue with your questions to Mr. Gilbert.
So how much rent do you pay to maintain the sign on that site?
We pay annual base rental of $1,600 per year, and then 30% of the overall earnings.
Advertising revenue on the sign?
That's right.
So approximately what is your advertising revenue on the sign for purposes of converting the 30% thereof for ground rent?
We'll earn 50 to 60,000 per year generally.
So at 50 to 60,000 per year, I come up with about $18,000 a year in ground rent.
That's about right.
Okay. Now, this 30% that you are obligated to pay in ground rent, do you think that's market? Above market? Below market?
No, it's below market.
What do you think market
Again, Your
ground
Honor,
rent for that site would be?
I'm sorry, but
Senator?
I have to object. There's not been, I believe it's already been stated by Mr. Rothfelder that we are not acquiring a sign site and we're not valuing a sign site or a bonus value in this case.
Once again, Your Honor, it's designed to demonstrate and rebut the state's argument that we're not a property owner. If SignAd has a below market ground lease, the difference between the market rate and the actual contract rate is known as the lease bonus value, or the benefit of the bargain for the tenant under a compensable ground lease. And if the testimony is that indeed this sign lease is under market, there is a compensable amount that is due to the lessee, and as such, he's a property owner entitled to receive his reasonable and necessary attorney's fees under Chapter 21.095C of the Property Code.
Objections overruled. You may proceed.
So what is your opinion of the market ground rent for a sign at that same location?
Well, it would be 35% roughly.
Okay. So is it your opinion that the difference between the 35% market and the actual contract rate that you have to pay of 30%, that there's about a 5% annual advantage accorded to SignAd?
That's correct.
Okay.
That's right.
All right. We can talk about it later, but that 5% annual advantage would relate to your advertising revenue of $50,000 to $60,000 per year.
That's correct.
Now let's talk, when I was asking you earlier about the history with TxDOT, let's go ahead and begin with more recent history, Mr. Gilbreth, talking about, first of all, exhibit number 6, which I believe has already been pre-admitted.
Yes, it has.
So what is exhibit number 6?
Exhibit number 6 is a letter from TxDOT to SignAd, making an offer of $106,100 for our billboard sign.
And as the judge has already noted, in fact, he brought it up in his questions earlier, that was as early as September 6, 2017, correct?
Yeah, September 8th to be exact.
September 8, 2017. And you understood from the offer that was made that it would require complete removal of the sign.
Yes.
For which it could not be replaced because of Sealy's prohibition on new billboards.
That's correct.
So what did you and your colleagues at SignAd do in response to this initial contact from SignAd, from TxDOT, excuse me?
We were in contact with TxDOT to find out if, how much is being taken from the sign and what kind of impact it may have.
And let me direct you, and I'll ask the judge to look with us at exhibit number 7. This, let's see, exhibit number 7 has not been admitted. So can you identify to the court what is exhibit number 7?
Yeah, this is an email from Dan Creel to Christy Lambert. I'm assuming she's with TxDOT,
And Dan Creel was with
Dan
SignAd at the
Creel's with
time.
SignAd. He was my real estate manager.
And I don't want to go into the contents yet, but in general, for purposes of authenticating, Dan Creel was your real estate manager at the time, and you were the president, and you were blind carbon copied in those emails, and he undertook these communications pursuant to your knowledge and your authority.
That's correct.
We offer into evidence exhibit number 7, Judge.
Judge, I think the problem at the top, the Jessica Austin, that part is hearsay. On the bottom part, I guess I don't particularly have an objection.
Yeah, we're only offering the October 11, 2017 email, your judge.
All right, so that portion of Exhibit 7 will be admitted that starts with the Jessica Austin real estate coordinator, SignAd at the top, and
Well, actually, the from Dan Creel to Christy Lambert email on October 11, 2017, Judge.
okay. All right, so the part that starts from Dan Creel, and then the text comes down and ends with thanks, Dan Creel. That is admitted.
Correct. Thank you, Judge. By the way, did I offer exhibit 21? Did you rule on that, Judge? I offer exhibit 21, the lease with the railroad.
All right, and Ms. Fagerberg?
I object.
All right, so that objection's overruled and exhibit 21 is admitted.
Now, we can move along given the time. I'm going to read, because I want to direct the court's attention just to that second paragraph that begins. Secondly, we can get a better survey of the work to be completed at the site of parcel 1. SignAd and the railroad would prefer that we simply move the part of the sign that will be residing in the taking and continue operation of the sign into the future. I need to be clear of exactly what will be done to accomplish being out of the right of way, and the drawing which has been provided does not supply information needed. I need this information so that I can approach the city to obtain the permits and variance and will require from them. So by this time, you'd been told that there was going to be a minor encroachment on the sign,
That's right.
but you hadn't seen a survey?
We had seen a sketch.
A sketch. But are you telling me that back as early as 2017, October 11, 2017, you were asking for surveys from TxDOT all the way back then and couldn't get it?
We were.
Okay. Now, when you say sketch, now let me refer you to exhibit number 8, and that's not been pre-admitted. So identify that for the record, please.
This is a letter in response back regarding our request for a survey. And it says, TxDOT says that they.
Well, don't go into the contents yet, but this is an October 2017 letter in response to that email that's already in evidence now, October 11, 2017. And it's from Greg Polasic to Dan Creel responding to those earlier inquiries regarding a survey, correct?
That's correct.
We offer into evidence exhibit number 8, Judge.
Ms. Fagerberg?
I have no objection.
Okay, exhibit 8 is admitted.
And so the judge can see, and to save time, the second paragraph of the letter to TxDOT responding to the request for a survey back in 2017 was, in the second paragraph, please be advised that we have not been provided a better survey. The billboard sketch clearly indicates that the proposed back of the bridge rail bisecting the billboard from 1 to 2 feet. Now, you understood then that, at least from their sketch that they provided, there would only be a 1 to 2 foot overhang by the billboard?
Yeah, based on their letter, yes.
Okay. Now, when that type of situation has happened in the past, have you been able to salvage the billboard by flagging it as opposed to completely removing it in eminent domain?
Well, we've never gotten a sketch before. This, I think, is our first one. Generally, we'll get an actual survey. But to answer your question, yes, if it's just a small taking of the sign, we're generally allowed to slide it back the 3 or 4 or 5 or 10 foot or whatever it is, and save taxpayers money.
And they did provide you a sketch as opposed to a survey, did they not?
They did.
And that's exhibit number 9 that's already been pre-admitted. Is that correct, Mr. Gilbert?
That's right.
And in fact, in the lower right-hand corner, it says it's a mere billboard sketch.
Right.
Okay. So did SignAd start the process based upon the representation from sketches, at least, that only be a foot or 2 overhang, to undertake the process to do that flagging exercise?
That's correct.
And take a look at exhibit number 11, which has not already been admitted, and identify that for the record, please.
This is an email from Dan Creel to Chrissy McGee with the city of Sealy, where he's applying for a permit application to move the sign back a total of 7 feet to the 1 to 2 feet that TxDOT, that were overhanging TxDOT's proposed right of way, and then also allowing for the additional 5-foot setback that TxDOT requires. So a total of 7 feet.
Okay. We offer into evidence, Your Honor, exhibit number 11.
Spagerberg, any objection?
I do. Again, I don't think any of the permitting stuff is relevant to the eminent domain.
All right, so objection overruled and 11 is admitted.
And to clarify, on the second page on the January 8 email to Dan Creel to McGee of Sealy, he's following up the conversation. Please find attached documentation from TxDOT regarding the upcoming I-10 widening and the need for us to move our sign on the railroad right-of-way. The state indicates somewhere between 1 and 2 feet of the sign is going to have to be in the new right-of-way. By regulation, we must move a minimum of 5 feet away from the right-of-way. Is that what you were talking about earlier, the 5-foot setback?
That's right.
Okay. We would prefer to move the sign the 6 to 7 feet due south along the railroad right-of-way with very little movement, if any, east and west, to clear the state's new right-of-way line. Now, indeed, TxDOT or the city of Sealy then granted that permission by way of a permit, which is exhibit 13, to SignAd to do that very work, correct?
That's correct.
And we offer into evidence the Sealy permit, exhibit number 13, Judge.
And I believe that's previously been admitted.
All right. And as it's previously been admitted, that it shows that it was actually issued by the city of Sealy to SignAd on January 24, 2018. Correct?
That's correct.
And the price of those permits is also indicated on the first page, $180. And then on the second page, another $100 for a total of $280.
That's correct.
Okay. Now let's see if we can go chronologically to exhibit number 10. Now this is this has been pre-admitted. In fact, it's one of TxDOT's exhibits as well. So let's just walk through this email chain if we can. And I want to kind of start back here at the beginning. Page 3 shows an email that is addressed by Dan Creel to folks at both TxDOT and to the city of Sealy, right?
That's correct.
Dated January 25, 2018.
Right.
Okay. And he starts by saying, just to clarify, we're not moving the sign. We're moving only a small part of the sign out of the new right-of-way, which according to TxDOT is between 1 and 2 feet. I have confirmed with Winnie Knox, Outdoor Advertising Regulatory Program Supervisor with TxDOT, this is allowable under state rules. By the way, did you know that Dan Creel was talking to Winnie Knox about coordinating the permission for this work?
I did.
And he goes on and he confirms a couple lines down, since we're not moving the sign onto another property or moving the sign on the property, but simply moving a part of the sign face out of the right of way without moving the new sign, we've secured the City of Sealy permit, a copy of which is attached to your reference. That's Exhibit 13, right?
Right.
Now, Wendy responded to that email the very same day, just a couple hours later, right?
What was the date of that? Let's see. Yeah, same day.
Okay, so we can see at the bottom of page 2 of Exhibit 10 that Wendy Knox writes just a couple hours later to Dan and says, I am incorrect in my response to you earlier on the phone as I was not looking at my regulations and I apologize for my error. To be accurate, I've provided the regulation that does stipulate that in the instance where you're going to leave the sign structure in place and adjust the sign face to cure the encroachment, you'll have to meet the 5-foot setback. And she attaches section 21.192, correct?
Right.
And let's see, Dan responds 11 minutes later, does he not?
Yep.
And he responds to Wendy, and there's still copies to all of these TxDOT people and all these Sealy people, and says, Wendy, thanks for the follow-up. That's exactly what we had intended to do from the start. It's also what we represented when pulling the permit, discussing our plans with local TxDOT condemning authority, if you will, and what our contractor bid his work to complete. All right. Now, after you had all of this communication with TxDOT and Sealy through January 2018, did you authorize your lawyer, Chris Rothfelder, to send a letter explaining and advocating why SignAd should be given a permit to do this very work?
I did.
Is that Exhibit 14?
It is.
And we offer into evidence Exhibit 14 if it's not already been pre-admitted, Judge.
I believe that's already been admitted.
Okay. So in Exhibit 14, my law partner, Chris Rothfelder, explains the settlement agreement with Sealy that was entered into back in 2011 as one of the reasons that the permit to amend this sign and allow it to be moved 2 feet to be out of the right of way and an extra 5-foot setback, move it some 7 or 8 feet, why that should be permitted under a proper interpretation of TxDOT's regulations. Correct?
That's correct.
All right. Now then, now let's get into that settlement agreement that you started to explain earlier, which is discussed in some detail on pages 2 and 3 of the letter. You already testified.
May I object? I think I think we're starting to get very deep into the permitting debate that is set in SOA court. And I would suggest that this debate is properly left to SOA. I'm fine with some sort of general description of the fact that I know they, that we have a rough dispute and it has to do with the projection of moving the sign further away from the bridge, what's called the projected railroad right-of-way, which is why I'd agree to that exhibit. But in terms of us actually trying to debate all the elements of the administrative court office, I object.
Okay, but was Mr. Gilbreth talking about the contents of an exhibit?
Yes, he's going to talk about the contents of Exhibit 14, which is already introduced into evidence, indeed pre-admitted into evidence, Judge.
Right, so he can testify about the contents of Exhibit 14.
All right, I want to refer you to Exhibit number 1 attached to Exhibit 14. So we've got Exhibit 14 and there's 2 exhibits attached to it, are there not?
That's correct.
And the discussion in the letter that the judges ask you to reference addresses those 2 attached exhibits 1 and 2, does it not?
It does.
Okay, so what is exhibit number 1 attached to Exhibit 14?
Exhibit 1 is a letter dated February 11th, 2009. This is addressing, let's see what it says here. It looks like there's a violation of our sign at that location. So this is the notice I referred to earlier where they're canceling our permit.
And the basis of the cancellation of the permit was that the sign was located in what they call the prohibited area, namely that covered by then section 21.1483. Is that correct?
That's right.
All right, Judge, I think you can take judicial notice of this, but we've got evidence to prove it. Exhibit 4 is section 21.148 that was enforced at the time, basically in 2009, that addressed the same complaint that TxDOT is asserting about the location of the sign now, although the regulation number was changed in 2011 to 21.145.
All right, so you
So
asked,
we offer into evidence exhibit number 4, or ask the court to take judicial notice of that prior legislation.
okay, now are you asking me to take judicial notice of 148 or 145?
Well, right now it's 148. I'm going to get to 145 in a moment. But I offer into evidence exhibit number 4.
Any objection?
Your Honor, yes, I object to all the sort of comprehensive debates on this. And so maybe could I have a running objection, Your Honor, with respect to the TAC codes and the
Yes.
discussion of this if you're going to allow it?
All right, and you may, and I'll also take judicial notice of those sections of the administrative code.
And while you're at it, Judge, I guess you can take a look at exhibit number 39. And for your reference, I put exhibit 4 as the predecessor to exhibit 39, page 4. And as you can see, the 4th page of exhibit 39 is section 21.145, prohibited signs of TxDOT's current regulations. And as such, Judge, we offer into evidence exhibit 39, namely TxDOT's current regulations pertaining to this case.
Same objections, Your Honor. And also, I don't have on exhibit 14, I don't appear to have any attachments. There's attachments on exhibit 14.
Yes, two exhibits attached to exhibit 14. Is exhibit 39 admitted, Judge?
And first of all, I want to make sure if Ms. Fagerberg can find those attachments. In the copies that I was given, it does have the attachments.
Okay. I have
Well,
exhibit,
they're exhibits 1 and exhibit 2 to exhibit 14, the letter itself.
when I printed all oh,
You go about 5 pages into exhibit 14.
okay. I think I know what happened. Okay, I think I wrote you all last night and said for some reason exhibit 1 and exhibit 2 keep appearing over and over again in the production, but those were the other exhibits. I'll have to pull that up.
All right, so let's talk about exhibit 39. Is there objection to exhibit 39?
Yes, Judge, same objection.
All right, I'll overrule the objection and admit that, and also take judicial notice of the TxDOT regulations.
All right. May I proceed, Judge?
You may.
All right, so we were talking about, Nicole, are you ready? Do you have exhibit 1 to exhibit 14?
Hold on, I'm pulling it up now. Is it a 15-page total?
No. What do you mean? Exhibit 14?
Correct. I think I have it now. Thank
Yeah,
you.
yeah.
I
Mhm.
do. Thank you. I apologize.
All right, so Exhibit 1 to Exhibit 14 is a notice of cancellation dated February 11, 2019 from TxDOT, correct?
2009.
2009.
Right.
What did I say? 2009.
Right.
And the basis for the cancellation of the permit was section 21.1483 prohibited signs.
That's correct.
And again, the judge just admitted that old regulation enforced back in 2009, 21.148, correct?
That's right.
And the current version of that prohibition on signs being in TxDOT right-of-way when projected across the TxDOT right-of-way, that's now 21.145, correct?
That's right.
Same regulation, just renumbered.
That's right.
Okay. So same dispute some 10 years ago between SignAd and TxDOT regarding the location of the sign in the so-called TxDOT right-of-way when projected across the railroad tracks.
That's correct.
Okay. Now, did TxDOT and SignAd resolve the same dispute over the same regulation as part of this cancellation that was rendered back in 2009?
We did.
And that's part of Exhibit 14 that's already in evidence, namely Exhibit 2 to Exhibit 14 is a settlement agreement and release dated February 11, 2011. Is it not?
That's correct.
Okay. So the record's clear. Did SignAd and TxDOT settle its dispute over the predecessor to section 21.145, allowing the sign to be in that so-called prohibited area of right-of-way when projected across the railroad tracks?
Yes, it took 2 years, but we were able to reach a settlement.
Did you pay us reasonable and necessary attorney's fees for that?
I'm sure we did.
But you didn't get reimbursed, did you?
No, we didn't get anything
Okay.
back on that.
All right, so in any event, in that case, both parties mutually released, discharged, and waived any complaint they might have about this same complaint about the sign
Objection.
being in the prohibited area, did they not?
Objection, Your Honor. I think we're starting to characterize legal documents and settlement agreements, and that's getting very far afield again of our eminent domain case.
Well, Judge, I can rephrase.
All right, you'd rephrase.
And now let's take a look at the second page of Exhibit 1 to Exhibit 14 that's already in evidence. That's the settlement agreement, second page. And the third whereas, I'll just read it, provides that whereas the parties to this settlement agreement and release have agreed to settle all of their disputes and to release each other from any and all obligations relating to SignAd's conversion and continued operation of the sign on the property, and from any and all claims that were or could have been asserted in the SOA case in the lawsuit. And the parties then go on after that release language and specifically provide, dropping down to paragraph 7, that the parties agree to fully release each other from any and all obligations, liability, and damage arising out of construction of the sign on the property. And indeed, on the next page, under release of liability, paragraph 9, the parties agreed, did they not, in consideration of the above agreements for themselves and all who may now or in the future claim by or through them, they fully and finally release, acquit, and forever discharge all those parties for that in any way may be claimed or legally responsible or liable directly or indirectly to each other in any manner related to the SOA action. Now,
Same objection, Your Honor.
I
I think
objection on that, I think.
And aren't you just reading from that exhibit?
I am. It's already in evidence. I'm just writing.
Objections overruled.
Was it your understanding that you had a full, final release and acquittal of all of TxDOT's complaints about the sign being in this so-called prohibited area of right-of-way when projected across the railroad tracks?
That's correct.
Objection, Your Honor.
Objections overruled.
Your Honor,
And
may I
you-
have a running objection as to questions about anyone's interpretation of this settlement agreement?
You may.
Thank you.
And you had to take certain action. You had to provide certain consideration in exchange for TxDOT's release under this settlement agreement, did you not?
That's correct.
Paragraph 3 specifically provided that the parties agree that the new face size created by the vinyl wrap shall be 20 feet tall and 33.5 feet wide. The parties further agree that the sign will meet TxDOT's overall height limit of 42 measured from the crown of the adjacent overpass. So you had to make modifications to the sign, correct?
That's correct.
And when you did so, in addition to releases, they provided under paragraph 4 that they would reinstate and honor that permit at the current operating permit for the sign, subject to the conversion and consistent with paragraphs 2 and 3 above, correct?
That's right.
All right. Now, on that basis, did you feel like you had the right to go ahead and accommodate TxDOT's highway project that we've discussed in this case by moving the face of the sign back the 2 feet that overhung the right-of-way plus the 5-foot setback?
We did.
TxDOT had released, discharged, and disclaimed any complaint that they had about the sign being in this so-called prohibited area, right?
That's right.
And indeed, I saw that you weren't trying to hide anything. You were talking to TxDOT in exhibit number 10 through Dan Creel throughout January 2018 and telling them that this is what we had intended to do from the start.
That's right.
All right. So did you submit a permit application to do it?
We did.
All right. Now that, I believe, has already been pre-admitted into evidence. And there was a date issue on it. You submitted exhibit number 25 on the date of the attached permit application, March 29, 2018, correct?
That's right.
And I don't know if the judge actually did it or not, but we were going to change the date on the transmittal letter to March 29, 2018, instead of this September 11, 2017 date.
That's correct.
Is that a typo?
Yeah, it's a typo.
Okay. All right. No doubt in your mind that Dan Creel submitted this transmittal letter to TxDOT with the permit application to move the sign as you had thought you secured the permission under the settlement agreement on March 29, 2018.
That's correct.
And he did so with a transmittal letter that both attached the permit application to TxDOT, correct?
That's right.
And also enclosed the city of Sealy permit building permit that was already discussed, exhibit number 13.
That's right.
Okay. All right. Well, what happened next, Mr. Gilbert?
Well, we were denied.
Okay. Are you telling me that they denied you even after they entered into that settlement with you a decade earlier, allowing the sign to stay in this so-called prohibited area?
That's correct.
And even though Chris Rothfelder had submitted a letter that provided the settlement agreement and all of the arguments about why you were entitled to move the sign out of the right of way, namely exhibit 14?
That's right.
Okay. And they issued a denial in what is already pre-admitted as exhibit 15, correct?
That's right.
All right. Exhibit 15 is pre-admitted, is it not, Your Honor? Yes.
Yes.
So that's a denial of the application to amend the permit to move the sign back the 7 or 8 feet to accommodate that TxDOT highway project.
That's right.
And the judge can see at the very bottom of the denial letter, they cite that section 21.145B. Do they not?
They do.
Okay. And the judge can see once again that he's taken judicial notice of section 21.145B, the third page of Exhibit 39, which is the successor with identical language to Exhibit 4, namely section 21.148. The provision that you had released, discharged, and acquitted one another under, correct?
That's right.
All right. So I noticed that TxDOT has language that if you feel that this decision is in error, that you can write a letter to TxDOT's executive director and appeal this permit denial. Is that right?
That's right.
And TxDOT's executive director, James Bass, received such an appeal from my law firm, did they not?
They did.
And that's Exhibit 16.
Right.
We offer into evidence Exhibit 16, Your Honor.
Ms. Fagerberg, any objection?
Yes, I object.
All right. And what's the basis of your objection?
Because, Your Honor, what it is, it's just, basically, it's just I think as I stated before, when we were looking at exhibits, I think the primary permitting issue is simply on notice that they were having disputes. But I think this is really just argument that's being put in as a prior consistent statement or bolstering. I mean, it's
So-
essentially just an argument of counsel in written form.
So objection is overruled and Exhibit 16 is admitted.
We don't even need to go into it that much, but Exhibit 16 is actually the appeal statutorily required of the notice of denial that was Exhibit 15, right?
That's correct.
So rather than just bolstering and that type of thing, you're required to insert those grounds for appealing the denial of the permit application, right?
That's right.
And Chris Rothfelder wrote that appeal letter, and once again, he attached this time as exhibit number 2 to the appeal letter, the same settlement agreement that you've already discussed at length, namely the February 11, 2011 settlement agreement that discharged and released all of these complaints about the sign being in this prohibited area.
That's correct.
And he raised those same issues, this time to Winnie Knox's boss, James Bass, executive director at TxDOT.
That's right.
And by the way, the permit was denied by Wendy Knox herself. That's exhibit 15, correct?
That's right.
So let me get this straight. The way that TxDOT's rules are set up is when a party, an applicant in this case, has a complaint about the denial of a permit application by TxDOT, that the procedural rule is that you get to appeal to the boss of the person that denied the permit application in the first place?
Yes, that's right.
Okay. Well, you lost that appeal, did you not?
We did.
Okay, and that's exhibit 17, which I believe has been pre-admitted.
Yes.
And is therefore in evidence as the July 25, 2018 letter from Mark Williams, Deputy Executive Director, confirming the Denial of the permit application signed by Wendy Knox, one of his subordinates, correct?
That's right.
All right. Now, one thing I do want to point out is at least this letter for the first time acknowledged the existence of the 2011 settlement agreement, did it not?
It did.
And the judge can look with us at page 2 of Exhibit 17 and see that this letter from TxDOT's executive director affirming the previous denial of a subordinate, he actually recites there on page 2 pertinent provisions of this settlement agreement, exhibit number 2 to that appeal letter, correct?
That's right.
In fact, those paragraphs that he quotes were some of the very ones that I brought to the judge's attention, correct?
That's right.
And then he goes on in his letter and says these provisions make it clear that regardless of the right-of-way issues brought up in the notice of the denial, the sign in question is a legally permitted non-conforming sign, correct?
That's correct.
Now, we're not going to belabor it right now unless the judge wants to go into the permitting issues, but he then goes through an analysis on the second page and justifies affirming his subordinates' denial of that amended permit application, correct?
That's right.
We'll take that up if the judge wants to hear about it, but certainly on October 5 at the SOA hearing. Now, fast forwarding to July 25, 2018, you've now got a situation where TxDOT, despite your applying for a permit application, has denied that permit application, even though you had a settlement agreement from 10 years previous. What'd you do next? What was your thinking? Tell the judge at that point when you went through all of this explanation with TxDOT, coordinating with them these plans to move the sign just 7 feet out of the right of way, getting the permit from Sealy and providing that to TxDOT to make sure it could be done safe and securely. And now you get this denial by TxDOT to do the very work that you'd been planning. What was your thinking?
Well, we were a little bit confused. It was, we're talking about 7 feet, which is normally not a big deal. And now all of a sudden we're going to 170 feet. Basically the same issue we had confronted 10 years prior and thought we were fine with that, which I guess we were for 10 years. I didn't realize there was a limit on how long that agreement was good for, and it pops up again 10 years later. So they're using the same issue, and so we were backed into a corner because we're sitting on a $750,000 sign we didn't want to lose.
Objection, Your Honor.
What do you mean?
What's Ms. Fagenberg's objection?
Your Honor, the $750,000 is not something that was ever disclosed before their briefing last week. And the basis for that opinion hasn't been brought out. If at some point he wants to try to do it, I'll have to take him on for dire and we'll look at some case law and whatnot. But I need to have a running objection about him attempting to opine to something that wasn't turned over and wasn't ever mentioned in discovery, and that we haven't had any of the necessary predicates for either.
Judge,
Objection sustained.
Judge, if I can be heard on that. She said this several times now that this was never turned over. I challenge her to show us a discovery request where she asked what is the value of the sign on the open market that Mr. Gilbreth would have to pay in order to salvage the $50,000 to $60,000 lost income stream if they could not shift the face over and instead had to remove the sign completely and forever in eminent domain.
Okay, let me sustain the objection again, because sign advertising revenue from faces is not compensable in eminent domain cases. Moreover, I did issue a full set of discovery, which I believe Mr. Rothfelder's already alluded to, and we found in billing, and it was not disclosed in the RFD responses, which is where you are supposed to disclose the opinions of your experts and or issue a report or do whatever you're going to do. There was nothing turned over.
You didn't ask.
I would respectfully suggest that you filed a designation of experts that had no details on this, and you answered your request for disclosure that had no details on this. So I can email.
He's not giving an opinion for seeking an award in condemnation. I agree with you. And so the judge knows. In condemnation, the value of billboards are limited to the cost approach. But outside the context of condemnation, which we are now, after they've dismissed their case, and where we are when the state does not have the public necessity to force the removal of the sign, we're in arm's length transactions between billboard operators that are buying and selling signs on a daily basis. And they do so based upon the revenue generated on the sign. The evidence is already in the record that this sign generates $50,000 to $60,000 a year in advertising revenue. And this witness, as part of the reasonableness and necessity of attorney's fees, Judge, should be given the opportunity to testify why he felt comfortable, why he felt it was reasonable and necessary to spend over $200,000 in damages, fees, and expenses on an item that through eminent domain was only going to give him $118,000 to $150,000. But if he went out on the open market, couldn't secure a replacement for that $50,000 to $60,000 for less than $750,000. That's the nature of his testimony, and it's directly relevant to the reasonableness and necessity of attorney's fees.
May I respond, Your Honor?
You may.
So, Judge, first of all, I don't think that advertising stream is in the record for the truth of that matter asserted. I believe
Absolutely was produced. We absolutely
Hold
did
on.
produce our advertising records to you.
Hold on. That's not what I said. I said it is not in the record for today for what you're claiming. The only way it came in is because I was overruled on an objection where you calculated the ground lease as a result of the advertising income. Okay. Look, I think it's far afield, and I think it's prejudicial to try to start arguing about how much a billboard is worth and saying, well, I don't like the eminent domain law on it, and starting to speculate about what you could get in an open market for business value. That's not what would be determined in eminent domain value. I don't think that's a relevant assessment for the court to hear in terms of the reasonable and necessariness of the attorney's fees.
All right, so the objection is sustained.
Okay. So faced with the reality that the sign would be removed and couldn't be replaced because of Sealy's prohibition on signs, and faced with the reality that TxDOT's deputy executive director had affirmed the previous denial of his subordinate, Wendy Knox, what was the reasoning? What was the motivation? What did SignAd think about at that point?
Well, we'd pretty much exhausted all of our potential remedies, applying, appealing. We'd notified them of our plans to move the sign back the 7 feet necessary. And so we made that decision to go ahead and do that. TxDOT was anxious for us to get that 2 feet out of their taking portion, their proposed right of way. We needed to accommodate TxDOT. At the same time, we had to make the difficult decision to move our sign back that 7 feet.
Now let's refer to exhibit number 31. And those are photographs that already have been pre-admitted into evidence. So in referring to the photographs that are already admitted, exhibit 31, just explain to the judge physically what was involved in actually moving the sign back the 2 feet from the aerial encroachment plus the extra 5-foot setback.
Well, what the photo we're looking at on Exhibit 31 is the after effect, after we moved the sign 7 feet. On the left side of that Remax sign, it originally was 7 feet over to the further to the left. When we removed that, we also had to remove what we had at the time was a 5th pole, an I-beam pole that was supporting that end of the sign. When we took that 7 feet, we put it back on the far end. As you can see, it's kind of a odd support to it, you know, with it extending further out to the right than to the left to accommodate that setback.
Now, there's actually several different pictures at different stages of this process in this multi-page exhibit, is there not?
That's right.
Okay. And that work necessary to eliminate this encroachment was done by who?
It was a combination of SignAd employees and our contractor, Houston Sign and Service.
Okay, and we're going to get to those expenses in a little bit. Now, all of these photos looks to me like the work was done during the light of day.
Yeah, the work was done took almost a month, late July to late August.
So you didn't wait until it got dark so TxDOT wouldn't be able to catch you?
No, it's hard to do that sort of work at night.
Well, how about on a weekend so they wouldn't catch you?
No, it was done just normal work hours.
All right. But you did not do the work with the permit that TxDOT denied permission.
We didn't have TxDOT's permit. We did have a Sealy permit, City of Sealy.
Did that make sure that you did the work safely and consistent with plans and engineering by the local folks there at the Sealy Building Permit Office?
That's correct.
And the sign was pretty much adjusted out of the right of way by the date that's on the first page of exhibit number 31, namely August 21, 2018?
That's correct.
Okay. Now, did SignAd incur cost, expenses, and fees as a result of the movement of the sign to accommodate TxDOT's project and then the filing of the condemnation case and its prosecution by the state before it was finally dismissed over a year later?
We did.
Okay. Now, let's go over those costs, fees, and expenses. I refer you, Mr. Gilbreth, and the judge, first of all, to a summary of cost, fees, and expenses that is exhibit number 26. And without reading anything or disclosing it, is that an accurate depiction and summary of the actual cost, fees, and expenses incurred by SignAd?
That's correct.
We offer into evidence exhibit number 26, Judge.
Objection?
State objects as not being relevant.
Objection overruled and exhibit 26 is admitted.
Now we're going to go through each of these line items, starting with on exhibit 26. I see that the vendor is actually SignAd Limited and the description is some labor and materials. So tell the judge what work was divided between SignAd and that outside vendor, Houston Sign and Service. How did you coordinate it? What did you do? What were the charges?
Well, the bulk of the labor was provided by SignAd. And then the equipment was provided by Houston Sign and Service, equipment and operator of their crane. May have had a welder out there too assisting, but we had our team of guys out there doing most of the work.
Now, exhibit 29 has not been introduced into evidence. So please identify for the record the two-page exhibit 29.
This is in copies of invoices from Houston Sign and Service for the work that they had done on the sign.
That's the outside vendor that worked with your in-house groups to accommodate TxDOT's project and move it out of the right of way.
That's correct.
We offer into evidence exhibit number 29, Your Honor.
Any objection to 29?
State objection, Your Honor. We don't think it's a compensable damage before the filing of the condemnation suit.
The objection is overruled and exhibit 29 is admitted.
Now, the 2 pages on exhibit 29 are charges from Houston Sign and Service. And those 2 pages on the first and the second page, when added together, coming back to exhibit 26, our survey, they total $24,635 for Houston Sign and Service. Is that correct?
That's right.
In addition to, by the way, is Houston Sign and Service, is that Jim Redmond?
It is.
He's the guy that took those photos that are exhibit number 31, right?
I'm not sure if he took the photos or not.
Okay. How long have you been doing work with Jim Redmond?
Oh, 40 years.
Okay. So when y'all work together like that, was it an opportunity to save costs and expenses, including by using SignAd crew in tandem with this vendor that you'd been using for some 40 years?
Yeah, we probably saved some money.
Okay. But it still cost you, by using your in-house crew, I see some $21,400, $21,504.
That's right.
How'd you calculate that? How'd you determine that?
Well, they had however many guys we had out there and their hourly pay over that 3 to 4 week period that they were out there.
Okay. So the total for the construction work, when I add the SignAd work and the Houston Sign and Service outside vendor for moving the sign out of the right of way, the total between the $24,635 and the $21,504 comes up to about $46,139. Correct?
That's correct.
All right. Now, in addition, you had to hire a surveyor and those to actually survey the property and provide that survey and demonstrate to the state that the sign indeed did not encroach on the right of way, correct?
That's correct.
And turn with me, if you would, then to exhibit number 28 and identify that for the record, please.
That's a copy of the surveyor's invoices.
I show that exhibit 28 has been pre-admitted, Your Honor. Is that correct?
That's correct.
Okay, so you can go ahead and explain by reviewing the document who is Thomas Land Surveying.
That's a survey company.
In fact, he actually came to meet Judge Leedy at that February 2019 temporary injunction hearing, did he not?
That's right.
He testified there about the survey that he took to show the sign had been out of the right of way.
That's correct.
And we come back to exhibit 26 and we see that the charges for the surveying work was $1,874, right?
That's right.
Then we already talked about Sealy's permit fees to do this work was another $289.
Right.
And I've already testified that you've incurred attorney's fees through July 31 of $163,802.
That's correct.
Now, you heard Ms. Fegerberg say that she stipulates that those hourly rates at least are fair and reasonable. You heard her say that, did you not?
I did.
Okay. Now, you also heard me say that this month I estimated an extra $20,000 through this trial and post-judgment hearing.
That's right.
So the 212,106 plus another 20 comes up to $232,106 in expenses, costs, and attorney's fees. Have you paid all of that except for my August bill that hasn't been rendered yet?
I believe we have.
And to your view, are all of those charges reasonable and necessary?
They are.
Pass the witness, Your Honor.
Ms. Fagerberg?
Judge, it's 4:51 p.m. How long would you want to go? It might be more prudent for us to break.
And I know earlier, I thought you said that his testimony or his cross-examination wouldn't be that lengthy. So how long do you think it would be now?
Well, the problem is he went over a lot more stuff than I had anticipated, Your Honor. I didn't realize he was going to testify about all these sign regulations and whatnot. I thought they were just going to have him testify as to a few financial documents. So it's going to take quite a bit.
Okay. All right. So if we come back tomorrow at 2 o'clock and we finish with Mr. Gilbreth, and then we have Mr. Caro and Miss Knox. Is that it?
Yes, on my case in chief, I'm going to call Ms. Knox adversely.
Okay.
Well,
And-
let me say this. I can go ahead and stipulate that I'll call Ms. Knox, but we need to confirm the witness availability. I can tell you that both Ms. Knox and Mr. Caro have very poor availability. They're very busy people generally. So we need to stop and chat with the witnesses and make sure they're available.
Okay. We'll go off the record and let's confirm that right now.
This is Miss Knox, Wendy. I have meetings in the afternoon, as she stated. Looks like I can move all of them. I do have a meeting at 3 to 3:30 that I really need to be at. If there's any way we can work around that, possibly. Everything else I can move and be available.
And is that meeting going to be a Zoom type thing, or you have to go?
Yes, sir. Our department requires everything to be virtual, so I could just change cameras, if you will. So.
All right.
Well, maybe what we could do, if Mr. Caro is available, we could do Mr. Gilbreth first, then I could call Mario and you could be the last witness after that concludes, if that's acceptable to everyone.
I don't intend to rest until I've called Ms. Knox adversely.
Okay, you mean you didn't have her on, well, okay, Judge, it's up to you. Even if I stipulate to have her in my case in chief, you're going to call her first?
So you'll stipulate that she will be available for cross-examination?
Yes, I can. I didn't realize you were going to have so much testimony on sign regulations and that it would be admitted. But now that I've heard that, I'll stipulate that I'll go ahead and put her on tomorrow in my case in chief.
Judge, to accommodate the court's schedule, I'll agree to simply cross-examine Ms. Knox as opposed to calling her adversely, and I therefore will rest after conclusion of Mr. Gilbreth's testimony.
So, Ms. Fagerberg, if you had to guess, how long do you think you'll need with Mr. Gilbreth?
Maybe half an hour.
Well, I mean, is it worth just finishing up with Mr. Gilbreth now so that we can come back tomorrow and start fresh with the next witness?
I mean, I don't know how Ms. Knox is going to be at her 3:30 call if Ms. Fagerberg is going to take a half an hour from 2 to 2:30, and then she's going to call Wendy Knox. I bet it'll take closer to an hour, and I probably have almost an hour as well. So there's no way she's going to be able to get a 3:30 call tomorrow unless we finish up with Mr. Gilbreth today and then start at 2 o'clock with Ms. Knox tomorrow. I can rest after Ms. Fagerberg completes the examination of Mr. Gilbreth right now.
Well, let's go ahead.
Okay, how long can we go? Can we go to at least 5:30?
Yes.
Okay, all right. Well then let's see, if you've rested with Mr. Gilbreth, if I can just have a couple minutes to get organized, then we can start in 5 and we'll try and finish him today.
Well,
Right.
I asked him and we're ready. Come on. All right, whatever the judge wants to do.
And that's also, since he's here, what's Mr. Caro's schedule for tomorrow?
I'm available tomorrow afternoon at, starting at 2 o'clock.
Because we may have some other follow-up with Chris Rothfelder tomorrow too. So let's see if we can finish up Mr. Gilbreth today.
Okay. All right, let me start.
Okay, so are you ready?
Yes.
Okay. All right, so we're going to go back on the record, and Ms. Fagerberg, you may continue.
Okay, so Mr. Gilbreth, let's go ahead and start with some of your contentions about the Sealy sign ordinance. Did you personally confirm with them that the sign would not be removed, that the sign could not be relocated within the city of Sealy?
Not me personally, no.
Did somebody else from SignAd do it and you have personal knowledge of that conversation?
I do.
Who do you think talked with the city of Sealy?
It was Dan Creel.
Okay, and Dan Creel is no longer with your company, correct?
That's correct.
Why did Mr. Creel leave?
I don't recall exactly, but he'd been there for 15 years or so, and I think was looking for a different opportunity.
Okay, so you were not in attendance and you've not talked with anyone at the city of Sealy, but you believe Mr. Creel had spoken with them.
Ask and answered. Objection.
Objections overruled.
Yes.
Okay, and it's your understanding the city of Sealy said no, correct? That you couldn't relocate within the city of Sealy?
I don't know that particular question came up or not. All we were asking for was the 2 feet.
And is it fair to say that under the city of Sealy sign ordinance that typically you weren't even supposed to be able to alter the sign at all under the ordinance, correct? But they made an exception on that one by meeting with the city council. Is that what happened?
I think there was a variance involved, I believe.
Meaning you were able to secure a variance.
That's right.
Okay. And was that through the voting of the city council?
I believe so.
Are you familiar with the overall 2015 City of Sealy sign ordinance?
Not in its entirety.
Okay. Have you ever read it before?
Not in its entirety.
You're aware, though, that it says that the premise of the billboard ordinance is that it believes that billboards are visually unappealing and can be distracting and dangerous to drivers.
Objection, Your Honor. There's certainly no pleading in this case about any complaint of the visual appearance. Indeed, they're going to condemn it for road widening. That's the only relevant issue.
All right, well, there was some questioning on direct exam about the Sealy's ordinance, so I'll allow the question.
Are you familiar with it? You've indicated you've had this for a very long time.
I'm familiar with the portion of the ordinance that doesn't allow new signs to be built.
Okay, and what's the basis for that?
I have no idea why they made that decision.
You've never read it before?
I've never talked to the people that passed the ordinance, made the change, no.
Okay, and let's talk a little bit about, you indicated that you thought that the sign was only moved 7 feet, but it seems to me like there's a fair number of different measurements that have been measured throughout this case. Would you agree that some of the other documents have shown different measurements than 7 feet?
I've never seen anything different.
Okay, well, let's go through some of the exhibits that you went into evidence. Let's bring up. Let's find it. Let's go to the maybe it's, let's see, exhibit maybe around 28. Let's see if it's in there.
We're there.
Oh, that's not the one, sorry. Okay, I'm trying to find the one about the, so on exhibit 29, which is Houston's sign, it talks about 7 feet of existing sign face to be removed, correct?
That's what it says.
Okay, but isn't there another statement, I believe, in one of the other invoices indicates that it's going to be 9 to 10 feet?
Is that a survey that you'd mentioned earlier?
No, I think it was one of the other construction bills that you all introduced. Maybe it was part of the City of Sealy one. Let me try and find it. Well, let me do this. Let me ask a question. What is your understanding of the exact distance of the sign face to the bridge before you all moved it? What was the exact distance?
No idea.
You have no idea?
No.
Would you believe that TxDOT inspection records would be the most accurate way to determine that?
I don't know about that either.
Okay. Why do you not know how far it was away from the freeway? I mean, from the bridge, sorry.
Well, we generally don't know what the distances are from bridges. That's not where we measure from. We measure from the right-of-way line.
And where do you believe the right-of-way line was in relationship to this bridge?
If we look at the survey, it'll show us, it'll tell us. And I don't know what that is.
Well, the survey that you've introduced from Mr. Thomas, that one is showing what's the present condition today after you've moved it, correct?
Are you referring to a particular exhibit?
Well, so let's see, let me find it. Is it 18 that is the surveyor's exhibit that you had done from Mr. Thomas?
I'm having trouble reading this fine print on here, but it appears to be.
Right, so that is only measuring the distance in the after, but you know of no document to help you know what the distance was in the before, correct?
Not unless we got one from TxDOT, which I know we'd requested. I'm not sure if we ever got one.
Right, and I know you complained about the fact that TxDOT didn't have an official signed and sealed survey, correct?
Yes, we'd ask for that, yes.
Okay, but you were still able to complete the construction work without it, correct?
Yes, we did our own survey and measurements to determine the distance needed.
The only survey I'm aware of that's been turned over was the one by Dan Thomas, which shows the after scenario after the sign has been adjusted. Are you saying there's another survey?
I'm not sure. I'm not sure if we worked from the sketch that TxDOT provided or where we started from. We must have had something more definitive to work from to be able to determine what was necessary.
As we sit here today, are you able to identify another survey you had commissioned beyond the Dan Thomas one that's dated in October of 2018?
I don't know of any.
Okay. Let's go to, for instance, let me find it. I've located the items I wanted to ask you about in terms of the distance. It appears to be exhibit. Exhibit number 11. And that has a fair amount of documentation on the end. And the one I'm looking for is the one signed by Jim Redmond. And it has, it's essentially looks like it's a quote.
Is that January 10th, 2018 that you're referencing?
That's the one.
Yes, I see it.
Okay. So did you notice that within that it says total cost to install, and I guess it looks like a typo, total cost to install, remove 9 feet from sign and add to the other end. So is that, seems to me this is indicating that 9 feet from the face are being cut off on one side and added to the other end. Is that correct?
I think there must have been some confusion because if you read the paragraph above that, it says 8 feet. So looks like somewhere between the 7 and 9.
Well, it indicates there's going to be pipe installed 8 feet south of the existing sign.
I'll read that.
Okay, so your former testimony was that the sign moved 7 feet, but it's fair to say that at least the pipes may be moving 8 feet and the face may be moving more like 9 feet.
Are you asking me a question?
Yes, is that, I mean, do you think that sounds reasonable based off the quotes, or do you know differently? Have you, it doesn't sound like you have a before measurement, so it's probably difficult to assess what the after measurement is.
Yeah, my guess is they didn't know for sure how much was necessary.
I bring to your attention some of the inspections that were done by TxDOT. So let me direct your attention to, let's go to exhibit, let me find it. Let's go to exhibit number 35, please. Let me direct your attention to page 3 of that inspection report in the top paragraph. Does it indicate that the GPS?
I object. She hasn't even established that the witness has ever even seen the document before.
Mr. Rothfelder, you've pre-admitted this.
I didn't say it was not admissible. I'm just saying that this witness hasn't been established as having any personal knowledge to give you any opinions about it. I'd be surprised if you've ever even looked at the document.
All right, well,
Okay.
let him look at exhibit 35 since it is admitted into evidence.
What's the question about it?
The question is, according to this document, the existing sign structure is approximately 8 feet from the edge of the pavement in the before.
Objection. The document speaks for itself. This witness, who has not been established as overseeing before, has nothing to add to what is written on the document.
So, Ms. Fagerberg, where are you pointing that out on the exhibit?
It's on the 3rd page, Judge. So if you go 1, 2, 3, it's the top paragraph, and it says inspector comments with GPS measurements.
So are you looking at the part that says approximately 8 feet from the edge of pavement of IH10?
That's correct, Your Honor.
Okay. All right, so that's into evidence. So do you have any other questions regarding this?
I do.
Okay.
Okay, so according to the survey that you commissioned, which is, I believe, let's go back to Exhibit 18, the one from Dan Thomas. I'd like you to read the measurement that Mr. Thomas thinks the sign is now from the edge of pavement. Can you see that document, or is it too small?
I can see something there. Let's see what it says. Now, what's the measurement you're looking for?
What is in the after scenario, how far is the sign from the edge of pavement?
Figure out where the edge of pavement is here. I don't see edge of pavement denoted here. Do you see it on there?
I'm gonna have to pull up my larger document.
Hey, Judge, did you show that Exhibit 18 is admitted into evidence?
Yes. That's the one that was admitted as long as the transcript from the injunction hearing was admitted.
Very good.
Are you able to find a larger one?
Are you asking me?
Yes.
I only have one in front of me.
Okay.
This is
And
8.5.
it's too small to see. Is that the problem?
Well, if you can guide me, I might be able to figure it out, but there's a lot of print on here that's very difficult for me to read.
Okay, so you seeing the survey today, it's not apparent to you what the distances are.
I can't make them out.
Okay. I'll represent to you that as I see it on a very large digital one, and remember, I've represented that I think this is supposed to be a 36-inch by 24-inch document. It looks to me like Mr. Thomas has come up with 21.6 feet from the edge of pavement to the bridge.
Are you asking me if that's
Yes, I mean,
accurate?
that's what the document says, or do you all disagree? Am I misinterpreting the survey?
He said he can't see it.
Do you not have a large size one that he can verify?
We have our exhibit number 18 in our exhibit finder. like the judge
That-
has and you have.
That
Okay.
sounds like it might be right. I can't tell you exactly if it's 21 feet or not, but it sounds like about where it should be.
Okay, but then that would mean that that's more than, it moved more than 7 feet then, didn't it? It moved more like 11, I mean, that moved more like 13 feet, 13 and a half feet.
Well, again, I have no idea what the distance was before or after. Do you have a plat or survey showing before? I could tell you.
Hey, Judge, we can go going on as long as she wants to on this, but I thought we're a little short on time. And I object on the basis of evidence on relevance in that there's no allegation that the sign is still encroaching on the right of way, whether it was moved 7 feet or 11 feet. I thought there was a stipulation when the injunction was granted that the sign is now out of the right of way. So this belaboring testimony seems to be irrelevant at this point.
May I respond, Your Honor?
Ms. Fagerberg, it sounds like that Mr. Gilbreth does not have an exhibit in front of him that he can read, so.
Your Honor, I guess the reason I mention it is because they make it sound very, very minor, like TxDOT's being very petty not to let them do this. And I wanted to point out that some of these distances may in fact be larger if we look carefully at the factual record. That's what I'm getting at. And it seems like there's a discrepancy when we look at these different admitted documents as to exactly how far it was moved. So that's where I'm going with that. But Your Honor, I can move on to additional lines of questioning.
Is that anything that either Mr. Caro or Ms. Knox can expand on tomorrow?
I think the discrepancies probably exist in multiple documents, but I mean, Ms. Knox has inspection logs that she can look at for GPS coordinates to provide our interpretation, but I don't think it will be the same as theirs.
All right, well, let's go ahead and proceed with Mr. Gilbreth as best you can.
Okay. All right. So Mr. Gilbreth, you also mentioned that you believe that SignAd was a property owner in the case because you have, I believe it was referred to as the concept of a bonus value. Is that accurate?
Well, the bonus value was applicable to the landowner. Is that what you're referring to?
Well, let me ask you this. What is your interpretation as we sit here today? What is your interpretation of the way in which SignAd was a property owner in the condemnation case, if any?
Well, there's actually two different bonus values, if that's what you're asking. I'm not sure.
We're
One-
only talking about real property values.
Okay. Well,
So
that
in
would
other
be
words,
go ahead.
I was going to ask, okay, so there's not actually a ground lease in this case, is there?
There's a lease or license, as it's called.
Right. So in other words, you don't actually have any particularly a fee lease agreement with BNSF. You have a license agreement with BNSF, correct?
That's what it's called.
And BNSF is continuing to receive funding. You all are continuing to pay them as we sit here today, the monthly rent.
They are.
So there's not been any extinguishment of that of the license agreement.
Not as of today.
Okay. Now, are you indicating that it's going to happen in the future?
Well, I hope not.
But there is no sign site extinguishment now while the condemnation is ongoing.
Not as we sit.
Okay. That's something you're worried about?
It is a concern.
If in fact you were to lose the administrative office hearing, your concern then is that you would have some sort of, there would be an issue then with the license agreement with BNSF.
I don't know if I'd have an issue necessarily.
what do you think would happen with BNSF and the license agreement?
Well, if the sign goes away, then the license agreement would go away also.
And so that's something that's foreseeable today and that's concerned you.
It's definitely a concern.
Is this the closest sign you have to a bridge in the state of Texas?
I don't know.
Is it top 10? I mean, do you have any idea of how close some of your signs are?
I've got 2,400 signs scattered around Texas. I couldn't tell you.
Okay, so you have over 2,400 billboards in Texas.
Yeah, faces.
Okay, so that's 1,200 signs?
No, probably less than 1,000 would be my guess. Actual structures.
Okay, but so you don't keep track of which ones are unique or close?
No. I mean, I know some of our signs because I've been on most of them. I actually climbed on them. You know, growing up, I was helping construct signs growing up as a kid. So I know a lot of our signs, and a lot of them have changed over time.
When vinyls are changed, are people have to jump up onto these billboards and there's construction crews that go on top of them up to change the vinyls?
Well, it'd be a long jump. What'd you say? I was 21 feet from the edge of the highway to the sign. That's a long leap, but they do have to climb the signs.
Well, actually the 21.5 feet is the current before the bridge is expanded, correct?
I don't know.
Mr. Gilbreth, you had contacted Wendy Knox at one point during this case in 2008, correct? In 2018, correct?
Me personally,
Yes.
I don't recall.
I have correspondence from you at one point attempting to contact people in 2018. Does that sound right to
Want to
you?
refresh his recollection with that correspondence?
Sure. I'll have to upload it in chat again. All right. So I don't know if you all can see it in chat, but it's just an email from you to Ms. Knox during the course of, I guess, the negotiations that were occurring in 2018. You've met Ms. Knox before,
I have.
and you know people from TxDOT, correct?
I know Miss Knox. I'm not sure I know anybody else though.
Okay. With respect to, you certainly knew how to contact people from TxDOT to let them know that in fact you'd gone ahead and moved the sign as a business decision.
I'm sorry, tell me that again.
Sure. In other words, you certainly knew some people at TxDOT through your many years of billboard experience and permitting disputes and whatnot. You certainly knew people you could have contacted to let them know that you had moved the sign, correct?
Yes, and that's what we did.
But you did not alert them that you had actually moved and had altered the sign, correct?
We've notified them ahead and also after the fact.
What correspondence do you have that indicated you alerted TxDOT after the fact that you had moved the sign without a permit?
I think we had 2 or 3 emails from Dan Creel to Wendy discussing what our plan was. And then I believe Chris Rothfelder after the fact.
Okay, as we sit here today, can you show me any of those emails that show me that you, I don't know what testimony you've sat through today, but are you, you didn't personally tell anyone at TxDOT that you had moved the sign, correct?
No, I did not personally speak with anyone.
Okay, if you're aware of any correspondence from SignAd, can you identify that told us that you had moved the sign out of the right-of-way encroachment? Can you go ahead and show us that now, please?
It'd be easier if you told me which exhibit it might be.
I'll represent to you, I don't think you all ever told us that you moved it out of the right-of-way. I believe that only Chris Rothfelder and that correspondence we went over indicated that there was, in his opinion, no longer an encroachment or whatever, but no one has actually ever admitted that they moved the sign out of the right-of-way without a permit.
Well, that was what we had discussed all along.
Correct. You had sought that to do it legally, correct?
Right.
Right. But you never alerted anybody after that you did it, correct? Without the permit.
No, we told them the sign was now out of the right of way.
Who told them that? Who told TxDOT that?
I believe that was Chris Rothfelder that notified the state.
Have you personally reviewed Chris Rothfelder's correspondence in this file?
Not at length.
Is it the same testimony we went over with Chris Rothfelder this morning and Mr. Richard Rothfelder this morning?
I believe that's accurate.
All right. There's a SOA case pending with all these permitting issues, correct, Mr. Gilbreth?
That's correct.
And that's already set for trial.
Yes.
And are you seeking attorney's fees in that case against the state?
I'm sure we will.
Okay, so you're seeking your own attorney's fees in that case against the state of Texas.
Well, I'm assuming we would be, yes.
Okay. And do you think public safety is important?
Of course.
Okay. And so if someone were to deny a permit based on a public safety consideration, that's not an irrational consideration, is it?
Not at all.
I have no further questions for Mr. Gilbreth.
Mr.
Brief
Roth,
redirect, Your Honor,
Nate,
on issues only directly related to what Ms. Fagerberg brought up, specifically at the end of the question, she was asking you about a SOA proceeding, and I refer you to exhibit number 45. Is that the notice of cancellation sent by TxDOT that triggered the SOA proceeding that Ms. Fagerberg asked you about?
That's correct.
Your Honor, we offer into evidence exhibit number 45.
any objections?
I have an objection.
So exhibit 45 is submitted.
And as we can see, dropping down to the third paragraph, the basis for the cancellation of the permit was the same as the basis for the denial of that amended permit that we saw in exhibit 15, namely this 21.145B, right?
That's right.
The so-called prohibited area when you extend TxDOT's right-of-way projected across the right-of-way, projected across the railroad tracks, correct?
That's right.
And once again, that initiated the SOA proceeding that she just got through asking you about. And the petition in that SOA proceeding is exhibit 32, is it not?
Objection leading.
What is exhibit 32? Identify it for the record, please.
This is This is our petition before TxDOT.
Okay, so that's the petition that TxDOT filed against SignAd initiating this SOA case that's set for hearing on October 5.
That's right.
The one that Ms. Fagerberg just asked you about in her cross-examination.
That's right.
We are introduced into evidence, Your Honor, Exhibit 32.
Any objection to Exhibit 32?
Well, yes, because I think from my perspective, I think I've said we don't want to get too deep into the permitting. And I think this is starting to get too deeply into it. We're going beyond notice of cancellation into the actual arguments of the case now.
Right, pursuant to your cross-examination on that very issue.
All right, but what's the relevance of the contents of the petition?
Among other things, Judge, the relief that TxDOT is seeking in the SOA case for the removal of this sign and the request for over $1 million in penalties for the same acts that they're complaining about in the denial of the permit application that we already discussed. She opened the door, Judge.
I disagree.
You ask him about it, and you ask him whether he's seeking attorney's fees in this very case.
Okay,
You opened the door.
The objection is sustained.
No further questions, Judge.
All right, Ms. Fagerberg, anything else?
I have no further questions.
So we're going to adjourn for the day. And before people leave the screen, though, we want to make sure we're all on the same page for tomorrow. Go off the record. All right. So for tomorrow, Mr. Rothfelder, who are you going to start off with?
Well, I probably can close. I was going to testify myself to correct the record in that SignAd is not seeking attorney's fees in the SOA case, despite Mr. Gilbreth's confusion and probably despite his request that he could get attorney's fees in the SOA case.
All right. So if you testify to that, are you going to, we may need to clear things up with Mr. Chris Rothfelder too. How long do we think that might take?
5 minutes. I mean.
Okay. All right. So like I said, we can get started about 2 o'clock. So hopefully by 2:10, 2:15, Ms. Fagerberg, who would be your first witness?
I would need to talk to Ms. Knox about her scheduling conflict, and we'll have to figure out who will go first.
Okay. Was that's something we can figure out right now?
Let me ask Ms. Knox, what's going on with the 3:30 meeting and what can you do on that?
Well, actually the meeting, I'm not sure everybody heard me clearly. My meeting is actually at 3 o'clock. It goes from 3 to 3:30. It's a really high important, it's a very sensitive meeting that I need to be able to attend. So if I'm able to go to the meeting and come back would be great.
Is there,
Well, Ms.
I guess,
Ms. Fagerberg, how long do you think you're going to need Ms. Knox?
I don't think very long. I think, frankly, Judge, I think to be consistent with my position, I don't think the permitting really matters, but unfortunately, because it's been brought so far into, I feel like if nothing else, I need to correct some factual things and I need to show that at least we have some rational basis for our decision, but I don't anticipate putting her on for very long.
Well, if she's, and I realize not for very long is open to a lot of interpretation, but if
maybe
why don't we
30 minutes?
Well, why don't we start, if we start with Ms. Knox at 2 o'clock, don't you think you're going to be done again in a short
I do,
time?
but Mr. Rothfelder indicated he wanted an hour of cross-examination with her.
All right.
I said less than an hour, and it'll
Okay.
depend upon what the direct is.
Is there any
No,
way
I'll tell you what I'll do. I'll stipulate right now. If you don't call her, I won't call her. So we don't need her.
Well, I think the problem with that is we now had a lot of testimony from you
So fine, if you want to call her, I'll cross-examine her.
right.
Okay, and then remind me about how long we think Mr. Carroll might be.
I think Mr. Carroll will be pretty short. may I make a suggestion? What if we started at 1:30 with Ms. Knox? Is that possible?
Well, we're gonna have to check, because I know we have some other people coming in at 1:30. That's why I was hoping we could finish that all up by 2 o'clock. So
Okay.
what do we have coming in at 1:30?
Schubert and which is supposed to be a day and a half file, and then approve on a probate, or like an application.
And so what's on the Schubert, did you say that might be default?
But I have not heard that from Ms. Allen, if I can. The trial. And that's a pretty long.
Yeah, I know. Let's see. I wonder if I'm sure she's not in the office now. Where did you hear that it might be a default?
Because supposedly Anderson's client did not his client anymore. He told her client that he ain't gonna show up.
Okay.
So if he has no attorney, he's not showing up, then it's gonna wind up to be a default. But then you
We
could
could
show
do
up.
like 11 to 12. Can anyone else do 11 or something to start?
We have 2 3-hour hearings we need to squeeze in from 9 to 12. So, and although what are they?
Bagnall in the morning, and then entry of order on Fisher Banks.
I mean, that's just approval. I mean, if that's just an entry, that's.
Yeah, that's gonna be nothing. It's a 3-hour hearing with Bagnall.
Right.
Scheduled at 9.
Switch the camera slowly to me.
I mean, and remind me on Bagnall, aren't they just trying to interpret something about visitation?
It's multiple orders.
Who are the attorneys?
Mayhem and Ballard.
Are they both gonna be here? And that's not.
Yes,
not
it's by
by-
Zoom.
That's not by Zoom. You know, what if we just tell them to get 2 hours and 9 to 11? Because I want to finish this one up. Okay,
Do you want me to see if I have Mr. Ballard's phone number? Cell phone number?
if you want to check and see,
Okay.
check and see. You know, if we're able to come in and do anything at 11, so Ms. Fagerberg, what do you think we can get done? I mean, even if we come in a little bit early, what are we going to be able to take care of?
Well, I could do the directive Ms. Knox. And so we could start, and that way we'll guarantee she gets out for her important meeting. So I think I certainly could accomplish the direct, no problem, in less than an hour, absolutely. And then that way Mr. Rothfelder would be able to start fresh with Cross at 2. And I think that would work out. And that might also give us, if there's anything left over in terms of the ITS issue about that document or anything else we wanted to clear up, we could, we'd have a little bit of time to clear it up as well.
Well, why don't Ms. Lozano's going to see if she has a cell phone number from somebody else. Now we have some child custody issues that have to be resolved too.
Yeah.
I mean, where else will everybody be at 11 o'clock? If, I mean, if that runs over a little bit and if everybody's kind of here on standbys, so we don't start at 11, we start at 11:15 or something like that. Is that?
That's fine with me.
Everybody's going to kind of be in their office anyway.
My conflict should be cleanly over by about 10:30.
Okay. Well, then why don't we shoot to try to start back up at 11, and just, if I'm finishing up the child custody case, I'll be trying to twist their arms to get it done as quick as possible. So we can, start with Ms. Knox at 11, and now, so we start with Ms. Knox at 11, when we finish up her direct, and take care of the two Mr. Rothfelders, then maybe break for lunch, and then after lunch, we come back and do cross-examination of Ms. Knox. Is that kind of what we're looking at?
Yes.
Okay. All right, we will shoot for that, and I'm gonna have to find out if we need to send a new invitation out for tomorrow.
I couldn't get a hold of anybody. I even
Okay.
tried to call the office thinking maybe they were there.
And so what will we have to send out a new invitation? Okay. All right, so we will send out a new, and how much lead time?
I can do it for 11 in the morning, and then if we on there, we get on there. If we don't, we don't.
Is that something you do today or?
Yeah, I'll do it tonight. I'll do it
Okay.
right
All right, so we'll send out an invitation for tomorrow at 11 o'clock. Okay, and we'll just try to get started as close to 11 as we can and start off with Ms. Knox's direct. If we finish that up, let both Mr. Rothenfelders clean up some of the pieces, and then after lunch, we'll finish up with Ms. Knox and do Mr. Carl. All right.
Thank
So
you,
I will-
Judge.
All right, see everybody tomorrow.
Thank you, Judge.
Thank you.
Bye-bye.
Thank you.
Okay, bye. Okay, so I'm not doing anything.
I'll do it. I'll take care of it.
That didn't keep you on the edge of your seat?
Oh my. I'm trying to throw up. Get me on the edge of my seat. Okay. Crapola. I gotta figure out these people's emails. It's in your email. Okay, let me. Okay, so we're gonna end it.